Good. Thank you very much, Mayor and trustees and staff for having me up this evening. My name is Sam Light, and I'm General Counsel for CIRSA. That stands for the Colorado Intergovernmental Risk Sharing Agency. That's a mouthful, so we just call it CIRSA. We're the town's provider of property and casualty insurance. We're very proud of that fact. In fact, Wellington is one of our newest members, joined the pool this year in 2022. So we're very proud and honored to have the town as a member of our organization. We look forward to working with you. We value our relationship with you as elected leaders, your appointed leaders, your staff. Let me tell you just a little bit more about CIRSA, and then I'll dig into the content of why we're here this evening. So we've got some newly elected trustees. So I understand that, right? I think, right? Congratulations. Congratulations.
Mm-hmm.
So a little bit of background about CIRSA. We're not a commercial insurance company. We're what's called a public entity self-insurance pool. We're organized under Colorado law, and our only book of business is providing insurance for Colorado cities and towns and affiliated entities. That's all we do. We're very proud of that. We think that puts us close to our members in terms of understanding your risks and the needs that you have. At CIRSA, we handle what I call the bread and butter stuff, right? That's getting the insurance policies in place and the renewals and doing the underwriting. And oh yeah, knock on wood, sometimes we handle the claims that come in on your behalf, right? But recognize also that as an organization, CIRSA provides other services for our members, which are there for you as an organization as much or as little as you would like to use them. For example, on the training side, we do trainings for elected and appointed officials. So myself and our executive director, Tammy Tenoy, do that for you all as electeds. We're happy to do that for your appointed boards and commissions, and we provide staff trainings as well. For example, I do supervisor trainings, respectful workplace conduct trainings. For your operations folks, we have a risk control division that provides training both in person and online for all sorts of operational needs. So for example, if the public works folks want to stay current on their flagger certification or need instruction on safety and trenching and all those kinds of things, those are available to you. We have 282 members. That's about 275 in our property and casualty pool and about 140 in our workers' compensation pool. And we were formed in 1982. For you all, we're going to talk about training for you. But before I forget, for additional resources for elected officials, if you go to www.cirsa.org, across the top of the homepage, the ribbon there, there's on a drop-down menu of training materials, education and training, there's a tab for elected officials. And that puts you on the landing page for all the things that we put together that we hope are of help to you. Articles, webinars, a copy of a handbook that I'm going to mention in a minute, blog posts, a couple of videos, even some that are, I hope, a little bit humorous. I don't know about our attempted humor as an insurance company, but we try to take a lighthearted approach on some of the risk issues that you face. So I hope those are of help to you. I know that my slides, I think, found their way into the packet together with two handouts. I put at your places two more that I'll mention this evening. And I also put at your places a copy of our publication called our Ethics, Liability, and Best Practices Handbook for Elected Officials. We wrote that specifically with you in mind as Colorado's elected leaders. Though it's written by a bunch of attorneys, we tried to go light on the legalese, I hope, and provide more of a practical elected leaders perspective on issues that are important to you on behalf of your communities. So for example, there's a further explanation in this booklet about what the, hope it wasn't your first question, but what are my liability protections as an elected official? That's explained in there. There's more about open meetings and open records laws and executive sessions. There's a new chapter. Who uses social media as an elected official? Yeah, so we got a new chapter in there about social media because there are some dynamics there that need to be understood from a risk perspective. So I hope that's a helpful resource for you all. Next slide, please. There we go. All right, there's a quick overview of my presentation. In the interest of time, I won't go through it bullet by bullet, but I do want to make this disclaimer. I want to make our time together as useful for you all as possible. So if you have questions as we go through my training material, feel free to ask, and I'm happy to give you my comments from CIRSA's risk management perspective. But one caveat on that. So before I joined CIRSA about 3 years ago, I was a municipal attorney for about 25 years doing what your town attorney does. Okay, so I've got a pretty good radar for what I call the live one. So feel free to ask me any question, but sometimes the dynamic is, well, yes, Sam, I've got a question. What if another member of the city council does this? And everyone's eyes widen and, oh my, this is going to be exciting, right? So my radar is going off at that point, telling me this is the live burning question of the day in the town of Wellington. And so for that, for legal advice, right, you want to turn to and rely upon the advice of your town attorney. Same thing with staff support. Okay, if it's an issue that needs resourcing from your town administrator and staff, you want to look to them and rely upon them. I'm happy to give you some thoughts from our risk management perspective, but please rely upon their assistance and advice. I do think that my suggestions on risk management that I give you tonight are going to overlap on the legal issues, are going to overlap with the advice that you're getting from your city attorney. But if there's any disconnect here, listen to your town attorney, and he can call me tomorrow and remind me, what were you telling them? So, okay, next slide. My presentation is organized in terms of commitments, right? Commitments that we can make as elected leaders to help us do our job effectively together as the institution of council and help lead our community. I know we got some brand new folks, and then we have a couple, the other ones who got one term under our belt or 2 terms or half a term. Okay. 1.5. Nobody with more than 34 years, right? That's my record. Okay. That was down in Southwest Colorado. And by the way, it was a statutory town, just like the town of Wellington. And I asked that question just to get a sense of how long the electeds had served. And the mayor said, well, I got 34 years on the board. And the first thing that jumped in my mind was, wait, term limits? Well, you know, in a statutory town, the office of mayor is different than the office of trustee. So, you know, that's how you do it. You remember mayor, trustee, mayor, trustee. You do that for a while, and that's how you're going to get your 34 years of service. And I assure you, your community will appreciate your longstanding service to the town. But more seriously, the reason I mention that is no matter how long we've been on the board, I think, you know, my first suggestion here to you is no matter how long you've been on the board, step back and remember that when you become an elected official, a government official, your relationship to the community changes dramatically. All right, you're no longer just a citizen of the town of Wellington. You're now a government official, and that's a 24/7 job. Okay, it's not, don't give up your personal life. It's not that you can't have a personal life. Please have a personal life and enjoy it, but recognize that in the eyes of the citizens, the eyes of your constituents, right? Particularly when they're interacting with you about town business, they will always perceive you to be a representative of this organization, a representative of the institution of the Board of Trustees, right? And as they should, right, as government officials, your words, your deeds, your conduct matters, leaves an impact, has import. In a dicey situation, it can leave a residue. And in a worst case situation, it can lead to significant risk, including claims against the organization or against you individually. So keep that perspective in mind, right, Mayor? It's the 10 o'clock phone call. It's the 7 a.m. at the coffee shop. What's going on with the town, right? When they're interacting with you, they will always, you can even tell them over and over, this is my personal opinion. But in their eyes, they're still thinking, this is a representative of the town, right? And what they're saying is what I understand to be what the town's doing or saying or what have you. Recognize also that when you get elected, you're no longer an outsider to town government, right? You're now the ultimate insiders. And it has meaning in this way in terms of risk. Now that you're on the inside, the town's ways of doing business, they stick to you, right? The town's ordinances, the board's code of conduct, the resolutions, the policies, whatever those look like, right? And there are a lot in government. Government is kind of rules driven, right? Those rules stick to you, such as criteria for making decisions, the way you conduct public hearings, right? So you have to commit yourself to that. It's very dangerous to take a perspective that says, you know, that rule, that provision of the code of ethics, I don't really agree with it. And, you know, you can do what you want. I'm going to do this. That's an outsider's perspective, right? On the inside, things do stick to you. Recognize also, are you elected by wards? Yeah, I didn't think so. You're all elected at large. But remember, whatever drove your interest in running for office, right? Maybe that was a handful of issues, or maybe it was just a very few, one or two issues that you were very passionate about. But now that you're on the board, right, the job description requires that you be a great representative of the board and the town with respect to all issues that come in front of the board, right? Sometimes we're going to talk about later that requires you put aside some personal interest in service of the institution of the board and the town. So keep those thoughts in mind, and that'll serve you well. Next slide. We took the oath, right? We got, right? Municipal election was early in April. Everybody took the oath of office. Whew, got that, because you're supposed to do that within 10 days, I think. So we got that taken care of. Well, I think I swear to uphold the Constitution and the laws of the state of Colorado and the ordinances of the town. That has meaning for you ethically, morally, legally. And that's a lot of what I'm going to focus on tonight, right? I think the oath of office has embedded in it, even though you didn't say these words directly in the oath, has embedded a few core commitments, right? They include a commitment to respect your role and responsibility within the town's organizational structure. We'll talk about why that's important and how it relates to risk. You made a commitment to lawful conduct, including the town, following the town's rules, procedures, and criteria, right? I swear to uphold the ordinances of the town. Whether you knew it or not, when you got elected, you became subject to the Colorado standards of conduct for local government officials. And you actually have some supplemental rules in your own town code. So you made a commitment to ethical practices. And then finally, this last bullet may not, on this slide, may not seem to fall out of the oath of office as neatly as the other ones, but when we were elected, right, we were elected to be but one voice to a council that has 7 members, right? And that job requires that we're all contributing our own individual perspectives and positions, but ultimately the board does what? The board speaks with one voice. One voice. That's what we're all working towards. What is your constituents want to know? What did the board decide? What's the board's position, right? And so that means success from where you sit means working towards consensus building, or at least getting 3 more members to come along with you, right? You know, maybe your administrator is more comforted when the vote is 7-0, or the direction is unanimous, or a thumbs up, or a universal head nod. But whether you get there by 7-0 or 4-3, the job duties of individual members is to contribute to the board as an institution in view of speaking with one voice. And I think that requires that we bring to the job courtesy and respect for our colleagues, ways of articulating their positions, right? Professional courtesy and respect for how we have different styles in debating, actively listening, making council deliberations a safe and respectful place where everyone feels like they have equal time to participate in that process of making the single voice of the board. So I think keeping that in commitment in mind will serve you well. Next slide. Maybe. Oh, there it is. Okay, last piece of this one is, so I know we're fairly brand new, but I'll ask this question because it's probably one I hope you asked before you got into government service. Who likes process? Yeah. So in local government, process is a product in and of itself, right? But I think particularly at the elected and appointed leadership level, right? One of the job duties is to deliver good process and good governance on behalf of the leadership of this organization and its leadership, right? So I think both practically and legally from a risk standpoint, good governance. Give a good push. There you go. Good governance depends upon committing yourself to a couple of core civics principles. There are plenty more, but I'm just going to highlight a couple of them. So I think if you commit yourself to the core civics principles that are listed on the left-hand side of the slide, then by and large, the corresponding legal issue is going to take care of itself, right? So by that, I mean, commit yourself to openness and transparency. And you're going to have few, if any, disputes, arguments, claims, litigation over compliance with Colorado's open meetings law or Colorado open records laws. Just to give you one sense of what that commitment entails. Did you all get your town email addresses, or do we have town email? So we're going to use email to do our job as an elected official, right? Do we recognize that the emails that we send and receive wearing our hat as a trustee, by and large, are public records and are open for inspection by anyone who asks the clerk, right, for public records that are responsive to whatever the category of the request is. So that commitment requires that even if we intended that one email I was going to send only one from one trustee to another, that maybe somewhere down the road, right, there may be some other reader that we didn't have in our mind when we wrote that email, right? That's sort of the commitment. That's just one aspect of the commitment to transparency. We'll talk about more in a minute. Commit yourself to fundamental fairness, and I assure you, you'll have few, if any, people ever showing up saying, you violated my due process rights, right? This usually comes up around public hearings, where there's additional requirements to make sure we have proper notice, that we're handling the evidence correctly in the hearing process. So as a takeaway, just in the limited time we have, committing yourself to fundamental fairness means whenever there's a question of process that comes up, right? Well, you're going to throw all the hard questions to your town attorney, okay? But it means err on the side of giving process, giving fairness, right? It may come up, was the notice proper for this hearing? Right? If we have a problem with the notice, it's better to fix that and make sure everyone got proper notice. If in the middle of some hotly contested development hearing, there's some question about, did everyone get these documents? Does everyone have a chance to review these documents? Then we could slow the process down and make sure everybody has a chance to review that. Commit yourselves to being predictable and even-handed. I hope the clerk didn't give you your first night on the job, the code book. It's pretty substantial. But it's there for a reason. Those ordinances, right? They lay the framework for all sorts of decision-making, right? From land development, right? To liquor licensing, right? To a whole number of other things that you do as a board. You want to commit yourself to applying those rules in a predictable and even-handed manner. You don't want to be a board or community that gets the vibe of, just to use an example, let's say one applicant comes in, says, well, I went to the board for my minor, do you have PUDs? Yeah. I went to the board for my minor PUD amendment, and the application criteria were clear and straightforward, and the process was simple, and the rules were explained to me, and I got my approval, no problem. But then somebody else who's in the same, thinks they're in the same situation says, well, that's odd, because I feel like there were all these new application requirements that weren't mentioned in the development regs. And there were some strange things going on at the board level at the hearing. Oh, and by the way, they took this novel and unprecedented interpretation of their rules. And guess what? They turned me down. Is that not a good place to be, right? From a risk standpoint, the legal risk there is either the equal protection claim, right? Someone who feels that they're similarly situated to someone else, believes that they've been given unequal treatment under law. So we get equal protection claims on our members' behalf every now and then. The other fancy word there is certiorari. And that's simply a claim by someone who says the decision made by the board, right, was simply arbitrary, right? Either it wasn't based in any rules, or it was a made up basis for turning me down, or there was no substantial evidence to support the decision. So you want to be predictable and even-handed. Lastly, mutuality of respect may not sound like a huge predictor of risk, but I really think it is, right? Because I get it. It's going to be a tough job some nights. Some nights you're going to have a packed room and emotions are running high and it's a controversial issue, right? You may even have that situation when the mayor calls for public comment. The first person says, well, the board, do this, right? And the next person who stands up and board, don't do that, do the exact opposite, right? You get multiple people with all sorts of perspectives on what you ought to do, and you're having that thought again at that time, says, oh yeah, this is not a job where I get to make 100% of the people happy 100% of the time. That just goes with the territory, right? But if that person goes home from that meeting, right, and says to themselves, you know, I get it now. The board's got a tough job. They had to take all those differing opinions, right, and work through them. They had to look at what their rules were and come up with that one decision that serves the best interest of the town. You know, that person may even say, I disagree with what they decided, but you know what? I feel like I was heard. I feel like it was a good process, and I feel like I was respected. What a great place to be in terms of building trust and faith in local government, right? And the legal issues tend to fall aside. The opposite reaction is the person who goes home and goes, you know, I'm so mad about that decision, right? But you know what? I also think that the decision, it was like the decision was made before I even got there. There were strange things going on with the hearing. I feel like they didn't listen to me. I feel like I wasn't respected. Those are the ones who are mad enough sometimes to say, well, I'm going to go look for some way to legally challenge it too. So we really think at CIRSA that one of the underpinnings in some of the types of claims that we see is actually a claimant who's mad enough about that underlying civics principle of was it a respectful and fair process that they then go fishing for the legal basis of a claim. So, all right, next slide. Any questions, thoughts on all that? By the way, one of the handouts that I didn't mention that I know you got last week that was shared with me was your orientation book, which talks in some portions of it about the teamwork aspect and the working together and respectful. I have to tell you that orientation book was the best orientation book I've ever seen. I'm going to tell when people, this is the season for statutory towns in particular, right? They have their elections in April, and so people call us at CIRSA and they ask for, do you have orientation materials guidance to help us get folks oriented? I say, I'm going to send you the link for the Town of Wellington orientation session that you had last week. I just think it's a great document. I hope you find it to be a useful resource. I know that we're in a paperless society and you get a lot of paper, but that's a binder that I think will serve you well as a wonderful reference moving forward. Okay. All right, let's pivot and talk about transparency. Not a legal term, but that's the buzzword. Your citizens love and appreciate everything you do to be transparent. So whatever it looks like to you as an organization, right, consistent with the resources that you have, do things to show your commitment to transparency, even if it's not legally required. You have a wonderful website. I was able to go through your website today to look at your minutes, your agendas. They may not stand up every meeting and applaud you for your commitment to transparency, right? But maybe it's because, they know there are tools and vehicles for them to quickly check in. Oh, I can find the minutes for the meeting. I can watch the video quickly or whatever it is. I can find the agenda, and if they can just check in and assure themselves that things are going fine and they can see what the board's been up to, that's a great place to be. The opposite of that is believe me, if we toe close to the line, right, then suspicions go up, right? And once you get the interests of that kind of constituency that's suspect or suspicious of your commitment to transparency, at worst, it can lead to claims that go on for long periods of time, or at least fights about nuanced language in the transparency laws where people say, well, I don't think you comply with that provision of the statute because that's just the way you are. And, so whatever it looks like to you, commit yourself to transparency. All right, I know that probably last week, if not at other times, staff went over the open meetings law with you quickly. I just want to go over it again. Just 2 points, actually, real quickly. So the open meetings law has got a lot going on in it, but it basically says this with regard to the main rule. It says whenever 3 or more members of the board meet to discuss public business, that's a meeting that has to be open to the public. Simply means a citizen has a right to observe that discussion. Second half of the rule is if a 4th member is going to be present or you're going to take any kind of action, any action at all, that has to occur within a duly convened public meeting. And you have to post notice and agenda in advance, and that's what staff does for you. So that's it, easy peasy. There are no issues. Well, there's some nuances. You maybe covered this last week, right? But whoever's going to host the social event for the board sometime this summer, well, what if all 7 of us go to the social event that's hosted by the mayor? Does the government watchdog have the argument that you violated the open meetings law because all 7 of you are at an event? No. What if 4 of you, I just went there. So what if 4 of you bump into each other at Ziggy's Coffee? Have you violated the open meetings law? No. In either case, the statute expressly says that it does not apply to social gatherings or to chance gatherings, so long as in either case that does not become a vehicle for a discussion of public business. So the practical takeaway is if you bump into each other at Ziggy's, that's not the time to say, oh, well, while you're here, let's talk about the proposed budget amendment that's on the agenda for tomorrow night. That would be a no-no because we're violating the openness requirement and the notice requirement of the open meetings law. So still kind of easy peasy, right? Well, so a meeting includes any kind of gathering under the law. A meeting includes any kind of gathering convened in person, like we're doing now, by phone, electronically. Who likes Zoom meetings? Love them. And I think, among our 282 members, I would tell you that I think one thing that will outlast the pandemic is some use of electronic meetings, right? So whatever that looks like to you, wherever you land, our suggestion from a risk management standpoint is to make sure you have policies in place about how those meetings occur. right? Whether it's a virtual meeting policy or a remote attendance policy or whatever those things look like. I think that helps, may not bubble up in the legal risk all the times, although once in a while we do have claims around that issue, but it more helps you all as the institution of the board decide what your norms are, what your agreed upon norms of conduct are for each other with regard to those kinds of things. So the last thing was, a meeting includes any kind of gathering by person, by phone, by electronic means, email. The statute was amended in 1996 to add that phrase to expressly extend the statute to email. So that's why staff will tell you when you're having an email, right, with other trustees, do not have a discussion, right, of the merits or substance of public business by email because of what's the concern? The openness provision, right? So whatever those tools look like, right? Maybe we have some members who say they'll put at the bottom, please don't reply to all, or to ensure open meetings compliance, do not reply all, that kind of thing. That'll help you stay out of harm's way there. So one of my handouts that was in your packet was CERS's suggestions for elected and appointed officials around email. It explains a little bit further what that openness requirement is and how it creates a risk for you under the open meetings law. By the way, the remedies for violation of open meetings law is the other side can get a court order that says, don't do it again. Okay, we understand that now. And if you took some sort of action without meeting the open meetings law requirements, that action can be voided. Okay, which sounds like, well, we'll just do it over. Well, if it was an action that had some effect on the rights of third parties, that can get a little dicey, right? And the other thing that goes on is that if the claimant's successful in their claim, then the judge is required to award the claimant their attorney's fees, okay, which are not covered by insurance. Probably the most damaging thing, apart from the legal aspects with regard to an open meetings violation, is the loss of faith and trust in your commitment to transparency, okay? So my handout's got some suggested do's and don'ts about, and I take full ownership and responsibility for them. So if you don't like them, let me know and we'll make improvements. The state legislature, next slide, please. There's this phrase, I think it's called, what is it, Luddite? That's a person who hates technology, right? So it's, we're not Luddites. And I don't mean this to be like, I'm not anti-technology, but as an elected or appointed official, you just need to recognize that email has different dynamics for you with respect to compliance with the open meetings law. So email can be a good tool for some things, but not for a discussion among 3 or more trustees about the merits or substance of public business. Our state legislature actually jumped into this arena last year and passed House Bill 21-1025. Which expressly said that there are certain types of emails that do not constitute meetings. For example, if the email is just about scheduling and availability, well, all 7 of you can be on that email. That would be helpful because then we can know what each other's schedules are, right? Or if it's simply an FYI, what if maybe you're working on changes to your development regulations and you want to send to your fellow trustees, hey, here's an interesting article about construction costs in the Denver Business Journal, FYI. That's fine. But you don't want to say in response to that, well, that's the reason we ought not to have this language in the new development regulations. And then somebody else chimes in and then you got emails flying right? That's, now you're getting into deliberation. The statute, the amendments from last year also say that just posing a question for later discussion is okay. And just copying your colleagues on a response to an email from a constituent, which is natural. Maybe the mayor got an email, doesn't know whether you all received it from that constituent, but wants to copy you and staff just so everyone knows that he sent a response to that citizen. That's fine too, but you can see the underlying thread in all 4 situations, right? In none of those cases is there a substantive discussion going on among the members about the merits or substance. That's exactly what the legislation said. A discussion of the merits or substance of, what does that mean? Well, the legislature was kind enough to tell us a little bit more. Merits or substance means the essence. It's like effervescence, whatever it is, the essence. Okay, but you know what it's common sense. We know what they're talking about, right? Discussion of the merits or substance of matters of public business need to be reserved for when you gather in this room and talk collectively. And that's where you do your best work anyway. because you're deliberating with each other, right? Being able to see body language and talk to each other, look each other in the eyes. This is my position. I respectfully offer this position, that kind of thing. All right. You raised your hand. You already raised your hands for social media, right? Okay. There's there's a chapter in here about social media. I apologize that it raises more questions than it answers, but recognize as public officials, there are some risk dynamics around the use of social media. Okay, I don't want to dwell too deep into them, but just to point out this, if your social media, if you're using social media and it walks and talks like a government social media account, okay, and I can't tell you in one sentence where that line is. That law is still being developed. But if a court ultimately decided that your social media site was one you were using to do your job and it walked and talked like a governmental social media site, then you're a governmental actor for purposes of the First Amendment, right? And the takeaway there is that means you cannot block people or delete their comments because of their viewpoint or what they're saying, okay? So just keep that in mind. That's touched on a little bit. Now, on the other hand, I know that once in a while, elected and appointed officials can be on the receiving end of less than courteous comments on social media. Does that ever happen? And staff too, right? So there's also a body of law developing around whether content can be blocked or removed, right? In certain situations. There are some very narrow exceptions. It's well established that, for example, that if it was obscene, right, or is immediate incitement to riot, that kind of content can be regulated. But there's an evolving body of law of what constitutes a threat via social media, okay? So I got two suggestions for you all in that regard. First, remember your governmental actors and that removing or blocking content based on its viewpoint can be a significant First Amendment risk, okay? And I hope you're not facing this, but in some areas, some folks who are very smart and they're very passionate about what they do, they know where that line is and they get very close to the line without stepping over it. Okay, so if that's the situation you want to, you see something that appears to be undecorous on social media, you want to talk with your attorney and staff, and you're probably going to be in that case, if it doesn't fall into one of these other baskets, you say, well, let it go. We'll let it go. And we're just not going to do anything about it. The good news I have for you on that is last time I checked, I think there's 300 billion posts on social media each day, if I have my statistics right. Okay. So those comments are going to fall into the ether pretty quick. We just have to have a thick skin and let them roll off. Now, more ominously, if you are on the receiving end of what they call a true threat, which is an imminent threat, right? Puts you in fear of safety for your own physical well-being or that of a family member, then reach out and get some resources. Contact law enforcement or your administrator or staff who can help you. You don't have to bear that burden alone, right? Talk to other folks who can help you kick that issue around and see what, if anything, can be done. Maybe ultimately the legal analysis is that we can't remove it, but maybe there's some other way to try and get people to be more courteous and civil on social media, because that's what the vehicle was designed for, right? No. Okay. All right. Any other questions about social media? Next slide. Flipping this around. Yes. Hi.
Hi. Do you have a sample by chance of a code of conduct associated with social media interactions?
I've got one or two that I can send over to staff. I haven't seen that many that apply to elected and appointed officials. There are a lot out there that apply to employees and use of social media then, but there are a couple of samples out there. Yeah, and if you have private social media and you want to keep it private, then another thing you can do is make sure you know that it doesn't have the trappings of looking like a governmental site. Like, don't identify yourself as a politician. Keep the photos and posts to your family and friends. Now, I know that people know who you are and know what your email addresses are before you got elected and know what your social media site is before you got elected, and they still might contact you about town business. You have every right to kind of habituate those constituents to say, hey, I saw you, thanks for reaching out, but would you use this email address for any other town business, right? The other thing that goes on with social media, sometimes we all see things on social media and we go, that's just flat out disinformation. I mean, we say to ourselves, well, let's think critically about the who, how, and when, if at all, do we as governmental actors jump into that fray? Okay. Sometimes a good tool, if it's absolutely incorrect information about some town undertaking that we just simply need to correct the record, maybe a good way to do that is just direct folks to the city's official sanctioned social media sites. If it's a high profile controversial issue, maybe we've gone so far as some of our members have done this, of posting right on the homepage, click here if you want more information about this project. And that can get people, and you can direct your constituents to that without jumping into the fray. Because there's a little bit of a no good deed goes unpunished aspect of social media as well. All right, on the flip side, we've been talking about transparency. You know this. On the other side of that, you are allowed to have executive sessions, but only for a very limited number of topics and only after you follow to a T very specific procedures. One of the handouts that I left at your places talks a little bit more about the importance of that issue. Okay, so make sure that you're following all the proper procedures in that regard. Make sure your staff is there, attorney, if necessary, is there to help guide you through the steps to conduct an executive session properly. Two other things about executive sessions more practically. So when you go into executive session under Colorado law, we're required to make a recording of the executive session. And we're required to maintain it for 90 days. And then after 90 days, it can be destroyed as long as there's not a litigation hold on that tape. My practical takeaway is that unless your attorney has asked that the tape be turned off because it's an attorney-client communication, that's the one circumstance where the tape can be turned off. Otherwise, the tape in executive session is still running, still running. So like in all matters, right, in public life, courtesy, tact, diplomacy, professionalism matter, even in executive session. Okay, it very rarely happens, but sometimes we have this scorched earth litigation where in civil discovery, the other side under tight confidentiality restrictions is allowed to get a copy of and review an executive session tape. It's usually a civil rights claim where the claimant's saying, yes, the theory of my civil rights claim was that my civil rights were violated because of the motives of the governmental actors. So I'd like to listen to the tape and see if they had some illicit motive. Right. So the tape's still running. You want to make sure that you know when that happens, you do not want to be the one who's got their name attached to some zinger that was said in executive session. That's a bad place to be from a risk standpoint. So courtesy tact, and it's our obligation collectively with whatever staff's in the executive session to remain on point. Right. Whoever's the referee has got to have that flag ready to say, if we came in there for discussion of a personnel matter, then we can't say, well, while we're in here for a personnel matter, let's talk about that piece of property we're going to buy, right? That'd be off topic. So just be cognizant of those risks. Next slide. All right, to drive home my last point about executive sessions and confidentiality, let's run through the scenario real quick. Let's say we're in executive session, we've done everything properly there, and we're going to, in executive session, develop a strategy for negotiating the purchase of a piece of vacant land. You're allowed to do that. You can have executive session for developing strategy. And we've got a confidential appraisal with us in the executive session. And in the executive session, the board instructs. You're allowed to do that. The statute says you can give instruction to your negotiators in executive session. The instruction is, let's have the mayor and town administrator meet with the landowner and offer up to $100,000. Okay, so the next day, board member Smith bumps into the landowner at the Human Bean. Right? Just open one of those. Right? Okay. And says, hey, you know, we talked about your property last night and, you know, you're going to get an offer from the town for 100,000. And, you know, I think we might go as high as 125. Problems? Yes. Yeah. Yeah. So people call me about this at CIRSA and I remind them, look, I'm the attorney for CIRSA. I'm not, so call your town attorney. But they're asking for, like, are there rules around this? Is there statute around this, right? So I said, well, if we're going to dissect this legally, let's ask ourselves first, who's the injured party in my scenario? Who's the injured party?
The town.
The town.
Taxpayers.
Yeah. And I said, well, you know, and typically in the legal world, the injured party sues the other party. So are we going to sue ourselves? I don't know, right? So I think actually the greatest injury here is to the institution of the board as a board. right? And then also to Smith, who's got to go back to the board later and say, do you trust me? Right? So you owe it to each other from a fiduciary standpoint, and as a commitment to each other for the board to function at its highest level, to be on the same page about confidentiality, right? And so one of the tools I suggest is at the end of those kind of executive sessions, the presiding officer says, of all the confidential information that we've discussed in tonight's executive session, which information, if any, leaves this room and who are our spokespersons? And then we're all on the same page as a board. And I think that's a fiduciary obligation, right? And you've got a provision in your code of ethics about that as well. And that puts everybody on the same page, and you have to be there, even if you may have voted against going into executive session, and you may hate this idea of buying this piece of property, but from a confidentiality standpoint, you're still duty bound to protect the confidences that the board determines, right? So keep that in mind. I'm talking about conversations here, but it also happens with documents too. That's why I mentioned the appraisal. If you ever have uncertainty about whether a document's confidential, just ask your staff, right? The ones from a town attorney are pretty apparent because you got that big red stamp, attorney-client confidential, right? But sometimes you'll get a mysterious communication from the administrator that says work product at the top. What's this mysterious work product? Well, that's the statute actually allows for certain types of background confidential material to help you make decisions. That's called work product. That's a little fuzzier from whether it's confidential or not, but make sure you consult with staff on how you're going to treat those documents. All right, next slide. All right, just a couple of thoughts about meetings. We all know this, but having good meetings, they just don't happen by happenstance. Good meeting prep starts with the time the packet comes out. That's your time as a trustee to begin looking at the packet and jotting down your notes and questions that you're going to have on the matters that you're going to be taking up that night. There is a risk dynamic to the agenda. Okay, the open meetings law says that your notice of your meeting shall include agenda information where possible. Okay, so there's two good things to that. First, having the agenda tells everyone, reminds us all where we're going to focus our energy and attention that evening. Right. And if we stay on the agenda, then we're out of harm's way with regard to the open meetings law. Right. But I know sometimes, even with the best of intentions, it can come up, the mayor calls for approval of the agenda. And as a board member say, yes, Mayor, I've got something to add to the agenda. I forgot to ask staff to put it on it. I'd like to add this item to the agenda. I encourage that you look at it in terms of the empty chair principle, is what I call it. Is there a chair in the room that's empty that would have been filled had someone known that you were going to talk about that evening, that item tonight, right? And that's a good self-regulating principle on that. Maybe there's a distinction between something that's purely routine, administrative, inward facing to the organization. Maybe the administrator got a letter from DOLA today about a grant and just wants to give you an update and confirm your direction on some administrative or financial matter involving the corporation, right? But that's a lot different to saying at the time of approval, I'd like to add tonight the blockbuster issue that we've been discussing for months, and I think we ought to bring it to closure tonight. Maybe fewer people that know about it then, but they're going to know about it later. And they're going to be awfully upset about it later when they heard that you added it to the agenda and talked about it. So there really isn't, given the openness principle, the open meetings law, this option of discussions on the QT, right? Oh, one thing I forgot about to ask you about transparency. Remember I said it's 3 or more members? So what about the idea of one-on-one discussions? Is that okay? I mean, part of the job, a big part of the job is building relationships, right? And there's nothing in the open meetings law that prevents 2 trustees from having a one-on-one meeting, right? Now, where there's some tension in the law is what if a one-on-one meeting becomes a one-on-one meeting followed by another one-on-one meeting followed by another one-on-one meeting, right? And then what appears happens at the meeting appears to people to be mere rubber stamping. Like people coming in, they go, the worst case scenario is you show up at the meeting, it's the first time on the agenda and someone says, well, I'll just make a motion to approve because we've already talked this issue to death. And the question is, the natural question is, well, where and when did that occur, right? So our statute, to be fair, does not prohibit one-on-one discussions, okay? In Texas, they actually have a word for it. They call it a walking quorum. Such a great Texas phrase. Okay, so we don't address this issue head on, but we need to be cognizant of it, right? And there are cases that say that if the action that occurred at the meeting, the evidence shows that is a mere rubber stamping of conversations that occurred outside the meeting, even if they were one-on-one, then that's going to run afoul of the statute. So be cognizant of that. Your discussions of the merits of matters need to occur. If you want a real live current day example of that, you've been following the news about the Douglas County School Board. And I don't know how the lawsuit's going to turn out, but the Douglas County School Board right now is embroiled in litigation about the open meetings law, about whether they complied. And I guess I don't know if the allegations are 100% true or where they are in that process, but the allegations were that 4 of the members met 2 at a time, decided amongst the 4 of them that they were all in favor of terminating the superintendent. And then 2 of them went and met with the superintendent and said, well, the votes are there to terminate you. So would you prefer to resign or would you rather be fired? That's the allegation. I don't know if it's true or not. Does that sound like there's a decision that's already been reached? Yeah, the statute says any kind of action has to occur in an open meeting. Okay, so I don't know where that lawsuit's going to go, but that's something to keep on your radar and be cognizant of the risk around that issue. Sometimes you're going to have this. What if the administrator says, well, wait a second. I know I need for council, I don't know what the number is, but I need the board's approval to do a purchase over $10,000. And today a water pump broke and it's an emergency and the pump costs $12,000. Board, I need your approval. And someone says, well, we don't meet again for a couple of weeks. So my idea, I'll just call each of the board members and ask them if my fellow board members vote yes in favor of that expenditure. Would that be okay? Yeah, you want to take action at a duly called and noticed meeting. So think through what that looks like. Some municipalities use an emergency powers ordinance. Some use a process for calling an emergency meeting and then calling as soon as possible a ratification meeting after that. Whatever it looks like to you, think through what those trouble spots, how they might be handled as best they can while ensuring compliance with the open meetings law. All right. Next slide. Use inexpensibility in your meetings, whatever that looks like. I know in local government we pride ourselves in being a bit informal, but whatever the tools and techniques look like to you all, particularly during the public comment period, I guess do people have public comments speak from the podium? They direct their comments to you so that there's not people arguing back and forth in the meeting room with each other. It's no, this is the government, we're the governing body here, direct your comments to us. Do you have a time rule? Yeah, and I get to say whatever I want in my 3 minutes or 5 minutes or whatever it is. Yeah, recognize from a citizen's perspective, that's like the highest form of free speech, to stand up and petition my government, right, for grievances, tell them what's on my mind. And I know sometimes it doesn't go so well, 20 seconds into it. Here's Sam again, public comment. And I'm approaching 20 seconds into it. You're all crooks and liars and I hate guys. Well, we're going to take another 2.5 minutes of that, right? And say, thank you for your comments, right? And move on. So whatever your tools are, you should have a norm of conduct. The one that our members ask us the most about is how do we approach like this other situation where the public commenter comes up and says, even if the mayor said beforehand, laid the table and said, this is the time for comments. But the city, yes, thank you, Mayor. When is the board going to do something about this? And then there's that long pause, right? And they're asking you a question. So one of the tools we suggest on that is if you want to maintain the control of your meeting and how it flows, maybe you just remind folks, this is your opportunity for comment. We don't, as a board, engage in back and forth questions. Maybe at the end of the public comment period, our staff or one of us will have a response to one of the comments that might bear on something that we're doing. But that's one way to help the flow of your meetings if you're looking to avoid that back and forth. So the last dynamic that can come in, sometimes it just happens, you might be subject to personal attack during public comment. And that's another spot where perhaps just letting it go. Because I found in the ones that boil up in the claims, that there's usually not much you're going to say. I call it if someone's coming in hot, right? You get someone coming in hot during public comment, probably not much that's going to be said. It's going to, bring the heat down in that situation. So you just thank them for their comments and move on to the next one. Okay. I hope you never have this up here, but if you ever have disruptions that are so significant that you can't conduct the meeting, then I would recommend you take a recess. Or ultimately, I've even had members down in the metro area that had to adjourn meetings because the atmosphere got so disrupted. You want to have, in this day and age, whatever your safety plan looks like too, you want to have that. Okay. All right, next slide. Commit yourselves to ethical conduct is my next suggestion. This is one of my handouts, but I need to make a opening comment about the handout that I put at your places. So as a statutory municipality, you're subject to the state code of ethics, but you also have in your code book some supplemental rules. Okay, so you're going to want to look at both and make sure you have a good working familiarity with that. Ethical transgressions in local government don't happen all that much. They're pretty rare in Colorado, right? They're almost kind of fun and exciting to read about when they don't involve us, right? And as the municipal champion and municipal attorney, I kind of get a kick out of reading them when there's some far-flung county in another state, or it involves the state legislature or what have you. But more seriously, recognize that a serious transgression of the ethical rules, right, can lead to civil liability and even potential criminal liability, right? In an extreme situation, you can also lose your potential insurance coverage, okay? But that's only natural if you think through that, right? Public officials' liability coverage is not there to provide coverage or protection against civil liability that flows from criminal acts, right, or malicious conduct. So it's only self-evident that that's where it can go in a bad situation. Okay. So I did put at your place, next slide, a handout. And I want to go through just a couple of things real quickly. And my comments are going to be based primarily on state law, but if I remember to look at my notes, I'll make an additional comment or two about your supplemental rules. So first, the primary things that comes up for elected appointed officials is usually, do I have a conflict of interest and what do I need to do, right? So remember, you're in a conflict of interest situation when the board's going to take some kind of action that affects your own personal financial interest, okay? Your code supplements that by also defining personal interest, okay? So take a look at that. To use an example, you all as the board decide liquor licenses, correct?
Yes.
Yeah. So if we've got on the agenda a request for a new liquor license, and you happen to be a 50% owner of that business that wants that liquor license, right? Conflict situation. So what do I have to do? I have to disclose my conflict of interest on the record at the meeting before the discussion starts. So when the mayor calls that agenda item up, you want to say, Mayor, I need to make a disclosure. I have a conflict of interest, right? And then you have to abstain from the vote, abstain from the board's discussion, and you cannot attempt to influence the other decision makers. It's going to get a little technical, but let me break that down a little bit. When you make your disclosure, if you just say, Mayor, before you start, I need to make a disclosure. I have a conflict of interest. I'm going to step off the dais. Well, under state law, you've declared your conflict of interest. Do you leave the room when you have a conflict?
Yeah, I mean, you should.
Yeah, state law doesn't require it. Okay, and I'm not worried about the person with the conflict going to back of the audience and doing this. Good comment. Yeah, but for your own protection, I'm worried about something we're going to touch on in a second. So when you make your disclosure, I think even though the state law doesn't necessarily require it, I would encourage you to state what the nature of your conflict is. So, Mayor, I'm going to recuse myself because I have an ownership interest in the entity that's requesting this license. That tamps down all the speculation. Because I have been, it's really wild. They get up and leave the room, say they have a conflict, and everyone's going, oh, what's a conflict, right? So I think you serve yourself well by declaring the nature of your conflict, okay? So the state law doesn't require you to leave the room, but remember the last piece that I mentioned is it says, the state statute says, and also you cannot attempt to influence your fellow decision makers. So, yes.
I just had a question because my daughter works here in town. So
Yeah.
if there were a situation where her company was up at that, would that be considered a conflict? It's not directly financially impacting me, but it is one of my family members.
I'd have to look more closely at the definition of personal interest under your code. I think that's where the answer lies. So I'm going to ask you to check with your town attorney on that. Oh, and by the way, I'll give you a bit of a comment about the town attorney's role or the town administrator's role in these issues. Neither of them are personal ethics advisors. Okay. But they're there as a resource. They've worked around these governmental ethics issues. So they have a sense of how your ordinances work and how the state statute works. They can give you guidance and input on how the provisions work and what the expectations are. But at the end of the day, each and every member is responsible for their own decisions, right? And the consequences of their decisions around matters of ethics. But they're there, it's an accurate description, provide you a resource on that. So yeah, you've got an additional definition of what is a personal interest. And I think if I remember correctly, when I was reading, it talks about a personal interest of a relative. So you got to look at the definition of relative and that kind of thing. Okay. So if you step down, I want you to still be protected. The state law says that you cannot attempt to influence the fellow decision makers. So whatever that looks like, but what if you step down from the dais, you've done everything right, and then during that liquor license hearing, someone on the board says, well, I've got some questions for the applicant. And you're the one with the conflict. I'll answer those, right? And you come up and, how big is the new restaurant going to be? Oh, well, that's easy. That's objective information. It's going to be 2,000 square feet. Oh, and by the way, we're going to have plenty of parking and we're going to have dinner specials and you're going to love the landscaping and it's going to fit, in the new commercial area. Just wonder, does that sound like influence? Maybe, right? So the only reason I mentioned is I want you to be personally protected after you do everything right with the disclosures. Even if the allegation's off the dartboard, I don't want you to have to suffer the allegation that somehow something you said during your participation is being misconstrued or is rightfully being construed as an attempt to influence the decision maker. So it may seem unfair because you're not prohibited from holding property interests, right? But only 7 of us are on the board. So that's probably a situation where you want to have someone else do your speaking for you, your business partner, representative, or something like that. Okay. Okay. Confidential information. You have the language there is actually this on the slide is actually from your town code. Okay. Don't disclose town confidential information unless authorized by the town body, the Board of Trustees, and don't use confidential information to advance your own personal financial interest. So here's my war story on that. It's a bit extreme, but it's kind of interesting. Remember our executive session? So what if Trustee Smith left the executive session and instead said to the landowner, well, the town's going to offer you $100,000, but you know what? I'll offer you 125 personally. Good idea, bad idea. Yeah, and that actually happened in a claim situation that we had where an elected official, having participated in the executive session, knew what the entity's negotiating position was and bid it against that entity. So, but I'm a champion of municipal interest. That worked out in the end. And the municipality was able to buy that property for the price that it wanted from that elected official who actually bought the property. Took a little help from the district attorney, but we got it done. Okay, so that was an extreme situation, but you can see, that these things can have a lot, they can get, so, the more practical thing you're going to see about confidential information is just, do I know what's confidential? And staff's there to support you and help you in that understanding and keep you out of harm's way. Okay, gifts. Do you all get a monthly stipend for being on the board? So I'm here to tell you, it's not the lavish salary that you get, and it's not the lavish gifts that you get, right? That bring us to public service. It's love of community and stepping up to be leaders on behalf of the community. But more seriously, we do have a gift rule in Colorado that's enshrined in our Constitution, Amendment 41. And I'm not proud of this, but given the time we have, I've got 2 sentences about the gift ban just as a takeaway rule. So it basically says this: first, do not accept any gift from any one person in any one year of more than $65 if it's in any way related to your public service. Okay. Subject to this huge caveat, don't accept the gift no matter what its value. If it's obvious the gift is being given to you, right, offered to you to curry your vote on some action that you would take as a trustee, or to reward you for some official action that you've taken. So, as is self-evident, so much of that is about what does this look like in the timing and context of the gift. Okay, and big or small community, of course, we have relationships throughout the community, or we're colleagues with people in the community, or we know business owners and so on, right? But we know what timing and context means, and we know which gifts to turn down. Wouldn't it be odd that even if they're someone we know in passing or a friend, but they happen to own a liquor business, and the week before their renewal hearing, that's the week that they want to take you out for a lavish dinner and go to a Rockies game? Are Rockies tickets worth $65? I'm not sure.
70.
Yeah, okay, right. But you know that in the timing and context of that, you want to stay out of harm's way. By the way, your code goes beyond state law in saying that appearances matter, right? Your code says the intent of our supplemental rules is to strive to avoid not only actual conflicts of interest, but appearances of impropriety. So particularly in matters in gifts, you want to be conservative in that regard and stay out of harm's way. There are a bunch of exceptions that are listed in state law. You'll want to know what those are, just so you're prepared for those conversations. Okay. Next slide. All right, let's pivot here. Commit to supporting the town's organizational structure. So everybody in the organization has a job description, right? And again, I hope your first question when you were elected to the town attorney was not, can I get sued in this job? But the answer is yes. Yep. So here's the good news. Here's a brief overview of the protection that you have. Okay. State law, the Colorado Governmental Immunity Act. And by the way, I'm in a 40,000 foot level here. We can dig into the weeds if you have questions, but the Colorado Governmental Immunity Act basically says this. It says the town, and by extension, the town's insurer, CIRSA, will defend you and will pay judgments entered against you for acts or omissions as a trustee. Good news. So long as, there's always a catch, so long as you're acting within the scope of your employment and not acting in a willful and wanton manner. So scope of employment probably sounds odd to you as electeds because you're saying, well, I'm not an employee like Patty, I'm an elected. Well, the takeaway is simply that's the phrase that's used in the statute. And so it simply means I need to appreciate what my job duties are and correspondingly understand which job duties I don't have. Right, I'll give you a real easy example. Who within our municipality has the job duty of writing tickets in the municipal court? Yeah, so who doesn't? Everyone else. You issue business licenses, I think. So who is responsible to make the initial decision on the issuance of a business license? The town clerk. Who doesn't? Everyone else, right? And I've seen that pop up in the claims context where even my claimant agrees with that. They go, yeah, I've read your org chart and your ordinances, and I know that it's the clerk who's responsible for approval or denial of my application for a business license, but that's not my allegation. My allegation is there were some elected or appointed officials lurking behind the scenes directing that my license not be issued. Good idea? That's a tough place to be from a risk standpoint. So you can see this understanding scope of employment is, what is the job description of the elected official? And just in a nutshell, you probably covered some of this during orientation. This isn't my primary bailiwick, but you're the folks, we're a corporation, town's a corporation. Who are our owners? Yeah. You're the body that's uniquely positioned within the organization to stay at that highest level, right? And determine the wants and needs of the community and how do we put governmental resources on that? You're the ones with the longest vision, the most grand plans. You're thinking in terms of master planning, annual budget. Where do we want this community and organization to be in 1, 3, 5, 10 years? And you're in this nice place where you have a city administrator, right, who's responsible for the day-to-day administration. So that's what I would encourage you to think of in terms of your job description. In fact, it says it in state statute, you're the chief legislative body, the policy-making body, and your ordinances say that your administrator is the administrative officer for the organization. Okay, the other interesting phrase there is willful and wanton, right? You're protected as long as you're not engaging in willful and wanton conduct. That's simply this. It's conduct that's intentionally undertaken, that's designed to injure someone's legal rights, and that's taken with reckless disregard for what their rights are. I got an even simpler way of describing it. I just call it bad stuff. Stay away from bad stuff and you're going to be just fine. You'll be awesome. Right? And we all know what that looks like. We're going to stay far away from it. I will just drill down a little bit, tell you what this is the most, doesn't happen very often. Okay. But the most typical fact pattern that I see around an allegation of willful and wanton conduct is this. It's usually an individual elected or appointed official misperceiving that they have some governmental authority that they don't have, throwing on that cloak of governmental authority and doing bad things to people for the wrong reasons, right? So we know what that looks like and we're going to stay far away from it, but I wanted to cover those principles because it's important to understand where the outer boundaries of your protection are, okay? So if I sounded like the Grim Reaper on those comments, I want to end with a little bit of a silver lining. On the other hand, don't let the fear of liability, drive your decision-making. If you know, as board members, that you're making the right decision for the right reasons through a fair process, don't stray the course just because someone's banging the podium saying, if you do that, I'm going to sue you. That's what insurance is for. That's what these indemnity obligations are for. They're there to protect you, right, when you're carrying out your normal duties within the course and scope of your employment and not engaging in willful and wanton behavior. Okay, next slide. Just a couple of practical tips on this. As I mentioned, check out, the primary takeaway for you is whenever it feels a little like, are we on thin ice here? You just ask, is this something that's authorized to us? Are we following proper procedure? Can we do this? What are our options? The town attorneys, and I was one, so I'll put this on myself. Sometimes you're getting an answer that's going to say, it depends. It depends, right? It depends, But the process is, you can ask, you want to know what your options are and get a good explanation of where options are and where things get risky. And you have the right to ask for that. Recognize, though, that they may take some time, right? And that ultimately you're going to have to make a decision that's based on risk tolerance, okay? But if you need that time, like if you need to continue a matter because it's gone this way and now it feels like we're getting a little bit on the edges, then take that time and get the support from your staff. That's why they're here to support you in those processes, okay? All right, let's see, next slide. Couple more tips. These don't translate directly so much to liability. Sometimes they do, but a couple of things to make sure we don't have any issues around role discipline or scope of employment. Recognize that elected officials primarily do their job and act by meeting in a public meeting and voting on matters that come in front of the board as a group. There is safety in numbers in that regard, right? You have all sorts of privileges that attach when you meet in this room and do things collectively. As I mentioned at the outset, the role of trustees contributing to the voice of we, the board. So if we find ourselves thinking in terms of I, that can be a red flag, okay? And then finally, a norm of conduct issue. Mayor, do you have at the end of the meeting an opportunity for each trustee to give a report or comments, like trustee comments? Yeah, so we go down their dais and say, yes, let's call for board comments. And I say, Mayor, I've got a comment. Since our last meeting, I did this. And everyone else goes, you did what? Okay, that may not translate into any liability risk to a third party. But in terms of functioning at a high level in service of the institution of the board, I think you want to have as a board a discussion about what are our norms of conduct for how we represent this body in between meetings, doing things individually. And I say it because I want you to be protected, because I don't want to have to spend your lost dollars on sorting out that mess. And we have had lawsuits around those issues. But we want people to be protected. Like if the board says, would you go talk to the county? Right? When you come back and say, I talked to the county, and they go, thank you. They want to be like, oh, I told the county this, and everyone else says, but you told them what? Right? So it does require some investment in planning ahead for, what's our direction to our member if they're going to represent us in this and that kind of thing. So that can be a potential warning sign that only the board, right, can resolve by putting some attention to those issues. All right, next slide. A couple of the humble sides of being an elected official, right? Recognize that role discipline requires recognition that it is one board of 7, not 7 boards of 1, that sometimes no matter what our passion is for a particular legislative item, that if I can't find 3 or more members to come along with me, that I have to put aside that personal item in service of the institution of the board. And it requires that we agree to at least honor the decision, the voice of the board once it's spoken, even if we were not on the prevailing side. So if you were on a 4-3 vote and you were on the 3 side, you could probably tell your constituents, well, I didn't vote for that one. But I think as a fiduciary of the organization, you're duty bound not to do things that affirmatively undermine the decision of the board as a board. Okay, next slide. Lastly, the commitment to role discipline is particularly important in employee relationships, right? that you have the resources and are fortunate enough to have that organizational structure, which is the most common one in Colorado and in municipal organizations around the country. And that's where you have a legislative body, right? Policy, and then you have an administrator and administration. And I don't harp on it too much, but there is that distinction in your own org chart, in your own ordinances between policy and administration. And you have, by your own rules, given the town administrator responsibility for all employment matters except for your direct reports, which include the administrator, the attorney, any others? And judge. And that's it. That's it.
And
Yep.
advisory committees. They're not listed under our town administrator. They're listed under us.
Okay. And they help you set policy. They give you recommendations for policy. But you can see then they're a helping hand in that legislative role. Right. And if I were doing training for them, I would remind them of the same thing, that they're not, right, elected and appointed officials are not day-to-day supervisors of staff. For your direct reports, you do supervise them and you want to pay attention to that portion of the job. For example, have mutually agreed upon healthy processes for reviewing performance, determining work plans, giving direction. But for the other employees in the organization, elected and appointed officials are not employee supervisors. And you don't want that risk. Your full-time paid professional staff that has experience in HR matters, let them handle the employment stuff, which is very complicated. And they love that risk, right? Okay. That's where you want it to lie. We do have once in a while employment practices, liability claims that bubble up where somehow an elected or appointed official got overly involved. Right? Maybe it's a situation like somebody, let's borrow Public Works. Somebody in Public Works gets terminated and the claim gets filed. And so we put our adjusters and attorneys on there and they have to do an investigation to figure out what happened. And we look at the org chart. We say, okay, who's the supervisor? We interview the supervisor and we say, okay, you're the one with the hiring and firing authority. Why did you fire this person? Well, I didn't want to fire. Are we off to a good start? Yeah, sometimes, not very often, but it's, well, some people in this, other people in the organization wanted me to get rid of them and so on. And then we got to start asking other people questions. I've never had an elected or appointed official that had to have their deposition taken or be interviewed in an employment practices claim ever come back to me and say, that was a lot of fun. Let's do it again. Okay, so protect yourselves. You have a point of accountability and responsibility right here. So rely upon that, trust that systems are in place. Even if you're hearing something over and over, your point of accountability is to go to the administrator and say, I'm hearing this. Have you got it taken care of? And then she, on a need to know basis, right, which sometimes may not be very much, but still, right, you have to honor that. And so I was a municipal attorney for 25 years. I know though that sometimes it happens, right? Once in a while, somebody, can I talk to you about my boss? Right? So what's our response going to be? We love and appreciate our employees, but I, as a member of the board, and we as a board, do not get involved in HR matters at that level. I would encourage you to talk to your supervisor, HR department, the administrator, the attorney, whatever it is in the organization, so that way you unburden yourself from what you're hearing and you're getting back to the town's proper chain of command, just for lack of a better phrase. Okay, recognize on this slide, this concept is spelled out in your town ordinances, right? I think your administrator will agree. Please tell me if I don't, but asking, you bump into, well, cordial, you say hi and how's it going to an employee, and you ask, hey, how much longer is that street going to be closed? That's fine. But that's it's a lot different than giving direction to staff. And imagine how it looks from their perspective, or the impression it leaves with a line staff member if an elected or appointed official is coming to them with a quote request or a thought about what you ought to be doing, right? Those are things for the administrator, the department heads, the other supervisors. You want to give your direction collectively to your administrator. Okay, next slide. That can be a little messy sometimes, but you as a board, I encourage you to commit to speak with one voice when you speak to your direct reports. Sometimes it can get a little messy. Maybe the mayor's trying to divine what our direction is to the administrator. We talked to have a good discussion about an issue and said, let's give some of our direction to our administrator. You got one idea, you got a different idea, you got a different idea, 7 different ideas of what the direction ought to be. The administrator, mayor turns to Patty and says, you got your direction? No, no. No. But who owns that issue? The board. The board. You know, maybe in that wisdom that the presiding officers have, he's going to realize, well, this is intractable this evening. Let's just hold this over to another meeting. But we as a board have to commit to resolve our differences as a board and not conscript staff into that. Because that's how sometimes you may even have to put it to a vote and decide that direction by a vote. But that's where you get credibility, right? Accountability and clarity into what your direction is. And your direct reports are responsible and accountable to the voice of the board as a board. And you don't want to let it linger, because sometimes the dynamic that happens is a couple of days after that difficult meeting, people start popping by the administrator's office. Well, that was a messy discussion the other night, but here's what I want you to do. Is that in service of we as a board? Yeah, so you want to work through those issues. Okay, next slide. My last 2 substantive slides here are about due process. I just want to real quickly, and we do individual trainings on due process matters separately. Happy to come do one, but I just want to get on your radar this concept that, as you know, sometimes part of the job, you're just making general policy that applies to everybody and no one in particular. But other nights for certain agenda items, you're making decisions that affect people's individual property rights. And in Colorado, for municipal governments, that's almost always land use decisions and licensing decisions. And you know it when you see it because you got a specific applicant, right? And in that situation, you're now subject to what we call the due process rules of engagement, because you now are exercising this awesome power. The 7 of you get to decide property rights decisions. And that's the way we want it to be, right? We want this board to decide whether or not that development gets approved in this town, or whether or not that license gets approved or denied. But with that goes our obligation under the Constitution, right? No person shall be deprived of property without due process of law. And we're the 7 individuals who are ultimately responsible for ensuring that person gets their due process. So we know what it looks like. There's a lot of parameters to that, but a due process hearing, usually there's extra notice, right? And then we're having kind of an evidentiary hearing in front of the board. And that decision has to be made based on the evidence that's presented at the hearing, right? And it has to be based on the existing criteria for making that decision. And the decision has to be made by a fair and impartial decision maker. That's you. Okay, next slide. So the links at the bottom of the slide are to 2 videos on this topic, but just a couple of suggestions. There's the links there are basic training on quasi-judicial matters, but these due process rules of engagement require reducing some things differently. Like we can't engage with the parties to the proceeding outside of the hearing, right? We have to make our decision based on the existing criteria. If it was a liquor licensing hearing and then had a nice hearing and mayor says, okay, let's bring it back for board conversation. I said, Mayor, I'll start. I'm going to vote no because I don't drink. That's not one of the criteria. There are all sorts of criteria, like is the liquor premises more than 500 feet from a school? Is the applicant of good moral character rather than a 6-time convicted tax felon? That kind of stuff. But your staff is going to help you with the criteria, and the staff report will have them all set out. These are the criteria. You want to focus your discussion, frame your discussion around the criteria, even have them at the ready. Mayor, I am inclined to vote in favor of this application because I believe it meets our criteria for, and then you list, say what you want to say about those. On the other hand, I know sometimes the discussion starts out a little rough. Let's say it's, you said you do planned unit developments, right? Had a good hearing, mayor says, brings it back for discussion. Mayor, I'll start. I'm going to vote no because I don't like it. That's a little rocky start, but we can get there just by using Sam's rule of why. If we as fellow trustees just ask each other why. Why do you feel that way about this application? And we have the criteria in hand, and there's a couple of magical things going on. We're explaining to everyone who's present, right, the reasoning for our impending decision, more to the risk issue and the legal side of it. When you have those conversations about why, you're building a defensible record of the reasons for your decision. right? If I said, I'm going to vote no because I don't like it, and somebody says to me, why don't you like it? Well, I don't like it because the applicant didn't contribute to our Christmas fund last year. Well, not a good start. Staff's going to jump in and remind us, right? That that's not a criteria, right? I'm going to say, well, I don't like it because they don't have solar panels on each and every home. Staff might, I don't know if you do or not, but staff may jump in and say, well, that's not one of our criteria, right? But I may say, I don't like it because it's too tall. Oh, well, now we're getting somewhere, because one of the primary issues in discussion was their request for a building height variance. So now we start having a discussion around it, or even more fuzzy criteria. Well, I don't like it because it's not compatible with the neighborhood. That's a legally valid criteria. But you say, well, why isn't it? Why do you feel that way? Well, because it's all this crazy glass, or it's an entirely stucco building, and our design guidelines call for wood and stone. Now you're making so use that to your advantage. And I hope that's helpful. And I hope those videos are helpful. All right, last slide to wrap things up. Getting out of the weeds is commit yourself to wise leadership as elected leaders on behalf of the community. Right, recognize that you set the tone for the entire organization in terms of treatment of each other, the community, the business interests. Do remember that tone and temperament do matter, even in the risk area, because particularly for civil rights risk, sometimes we get claims for our members where a civil rights claim can take a bad turn, even if it doesn't help much with the legal theory, but if it has this tinge that the government actors perhaps overreacted, or worse yet, that their decision was somehow retaliatory, that can be a bad place to be. Commit to use your staff as an effective resource for you. Do you all get emails at home from constituents? Right, so use your staff as a resource. You may get that email and you see it and go, well, I don't really know much about this. It's about some public works project. So you can send that to Patty. She may need to check with the public works director. They'll contact that citizen, give the citizen the information that they want. And then your administrator will loop back and let you know, hey, we talked to citizen Sam and told him what the status was. And next time you see citizen Sam, you say, hey, did we get you the information that you needed? Oh, awesome. If not, they say, well, thank you. We always are open to suggestions for improvement, but use your staff as a resource to help you do things and help the organization look good at the same time. And commit yourself to a no surprises approach with each other. Last slide, I think. And finally, my last takeaway is one that I've emphasized a number of times. Commit yourself to act as we in service of the organization and the institution of the board, and that'll build strong leadership and lead you all to successful and wonderful public service. Thank you all again. Congratulations for newly elected folks and to all of you. And thank you for joining CIRSA, and we're happy to have you. There's a couple more slides with some more links and resources and a little more information about CIRSA. So with that, I'll open it up if you have any questions. But if not, Mayor, trustees, thanks very much for the opportunity to come visit with you all. Any final questions, thoughts?
Do you guys offer any classes associated with marijuana licensing for those criteria and to coach us to do that better if we were to take that on from a board perspective and from our staff?
We don't have what I would call a canned training program, but if you're working on marijuana issues and you'd like consultation with some of our experts about where the bunkers lie on that golf course, I guess is one analogy, that we have folks who can provide some member assistance. For example, we have attorneys who will work with your town attorney just from a litigator's perspective or a risk management perspective and make comments on draft ordinances, things like that.
Okay, thank you.
Thanks for the question. Thank you all. Any other questions?
Thank you.
We're at 6:58. Can we get like 5 minutes before we start?
I now would like to call to order the April 26th regular meeting of the Wellington Board of Trustees. The time being 7:05 p.m. Please all rise for the Pledge of Allegiance. Pledge of Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Can I get a roll call, please?
Trustee Gator,
Here.
trustee Kinney, trustee Mason,
Here.
trustee Teets,
Here.
trustee Wiegand,
Here.
Mayor Pro Tem McDonald,
Here.
Mayor Shosse.
Here. And now would like to have some comment from the town attorney or
Regarding virtual
regarding,
participation in meetings virtually. And if this is partially to be addressed for this board, as this is the first meeting, regular meeting with the new members of the board, and trustee Wiegand is attending virtually.
Yes.
The town code authorizes the town to have fully virtual meetings under very limited circumstances. Otherwise, the meetings are to be in person. And that's very important for terms of quorum. Quorum must be a majority of the members of this body in person. It has been the practice of this board to allow virtual participation in certain circumstances in the past. And so I think that's the idea with trustee Wiegand participating today remotely. We'll be able to participate in the conversation and vote as a member of this board. However, we do have a quasi judicial hearing that's in front of us today. And an important part of a quasi judicial hearing is that the decision that the body makes be based on the record. And because trustee Wiegand is not here in the room, he might have access to information that's not in the record, and that could cause some problems for us with a quasi judicial hearing. So we ask that, or I would ask that trustee Wiegand recuse himself from participating in any quasi judicial hearing that's before the board today. However, otherwise participate fully as a member. We will readdress virtual participation. I think it's one of those things that needs to be spelled out very clearly why, when, and how it's done. So we'll readdress that with you later. But any questions on virtual participation by trustee Wiegand?
No, that's good. What are you classifying as what I got to recuse myself as? Which items?
Item number 3 and number 4 on the board agenda is a public hearing and an ordinance. And these are quasi judicial hearings on a land use decision. It's a
Perfect.
rezoning application. So on those items, we asked you not participate in discussion nor vote on that matter.
That's what I thought. Thank you.
Thanks.
comment, Gator?
No, as long as trustee Wiegand's good, that I'm good.
Cool. All right, we'll move on. Are there any amendments to the agenda this evening? No, okay. Are there any conflicts of interest related to the items on the agenda this evening? Perfect. Now we'll move on to item B1, public comment. Individuals wishing to speak on non-agenda items are asked to sign up on the form provided at the podium. Once called upon, please come to the podium, state your name, and you will be limited to 3 minutes during this public comment.
Hi, my name is Karen Eifert and I live in the Knolls. I wanted to share in public comment. Is that, okay. I wanted to start squealing. I've been in communication with Mayor Shosse, and I really wanted to be able to I wrote a response today to Mayor Chelsea, and I wanted to bring that before the whole board and for the public to hear what I had to say. So I'm just going to read that. I said, thank you for responding. It was nice of you to share that you made prayer a part of your decision process for the nomination that you brought to the board for Mayor Pro Tem. My concern is that you did not address any of the concerns on how you completely shut out the nominations from other trustees. Honestly, it would not have mattered if you had nominated Mary Poppins. Shutting out the town trustees from verbalizing their nominations is the issue, not Ashley McDonald that you mentioned in your email. Wellington is not a home rule town. Wellington is a statutory rule town. In a home rule town, the mayor can act without the input of the board, as I felt you did last Tuesday. Wellington is a statutory town rule. You as mayor are required to include the trustees when you make a move or a motion, or a movement. There should be a discussion from the board of 7 and public comment as well before calling for a vote. I expected nomination for Pro Tem. I expected that you would move to open up nominations to the board and let them explain why they were choosing people that they were for nomination. I expected that you would go to public comment on the nominations and then bring it back to the board for board discussion. This did not happen. Mayor Chelsea, you personally came to my home and sat on my front porch with my 12-year-old son and my husband and myself and talked about how important transparency was. I have high hopes that this board will come together and each one of you will work your hardest to bring transparency from the board to the town of Wellington. Sorry, I'm nervous. You said that you would work with the people of Wellington, you would work for the people of Wellington, and that you would work with the Board of Trustees. You even went as far as to counsel my son, who will be on the library board, to let him know that he should always listen to other members of the board before making any decision. Mayor Chelsea, I really believe it's time that you heed your own counsel. I thought it was great counsel that you gave to my son, and I really hope that you start to include the entire board for all of those decisions. They affect the entire town, and we elected 7 of you for a reason. And I really want to see the 7 of you work together, and I don't want these things pushed through or rushed through as a last minute thing. And it really appears that, oh my gosh, I've got to do this right now. And then we suffer the consequences of a hasty decision. That's all. Thank you.
Thank you for your comment. I will take all of that to heart, and I do. Comment from the board?
My name is Reginald Westfall. I live at 3268 Wild West Lane. And I'm excited about our change in the board and the second public meeting of our newly elected mayor and board of trustees. During the weeks preceding the April 5th election, I communicated with no small number of our citizens, not by postcards, mailers, or yard signs, but face to face. I had some really enlightening conversations as they shared with me their desires and hopes for Wellington and this new change that was about to happen. I learned that most of them moved here for what Wellington was not. They didn't move here for what Wellington has become. I'm so glad that I took the time to really get to know them and some of these citizens before and after the election. However, I do deeply regret that I was not able to spend as much time with some of you, now our newly elected officials, especially with the mayor and also with Trustee Mason. However, be that as it may, I learned so much about our citizens and how they feel about their town. I would like to take a few seconds of your time to mention a few salient themes that I garnered from those conversations. One, they want transparency and fiscal responsibility from their elected officials who have sworn to protect their interests. They voted for a fresh new deck of cards, as it were, and not just a reshuffling of the old deck players into the town's various commissions and boards. They want a mayor and a board who will champion their vision for Wellington. They do not want to become a Windsor, a Severance, or a Timnath. They want no more of the real costs, both financial and social, of the mismanaged growth schemes and dreams. They do not subscribe to the philosophy of growth is the answer to a better community. And really, they don't really want a Walmart or a Lowe's or those things that can destroy our budding small business. What I have seen in the community since we moved here 4 years ago is we have 2 coffee shops, we have multitudes of duplicity in small business. I realize we're along the interchange, but diversification is a good thing, and the Planning Commission is involved in that. So I don't know why we interject competition to businesses that are just beginning, and then that essentially divides the number of clients. Makes it tough for them. Anyway, so now here I stand in kind of disbelief at the agenda tonight that this very board and mayor overwhelmingly plan to implement that would seat another majority of old cards that the people of Wellington either voted out of office or failed to vote into office at our April 5th election. How can this be, I ask you? How can you claim to represent the people of Wellington? I sincerely ask you to reconsider your planned actions tonight, plans that at best have the appearance of flagrant disrespect for the voting citizens of this town, and at worst, an outright conscious desire to ignore them. I hope your actions prove otherwise.
Thank you, Rich.
Kathy Y. Dallas. I live in 3405 Revere Court in Viewpoint. And I just want to congratulate everybody who has been voted on to the Board of Trustees and the mayor, and thank all of you for, I mean, I know how frustrating and how much time it takes just to kind of review stuff before I come to the meetings. So I am in awe. I don't have anything, one specific thing to say. It's just, this is mostly a suggestion. I moved here about 9 years ago. And back then the trustees did a lot of the work that the staff does now. So you guys should appreciate them because they, I mean, Ashley was part of the parks, the impetus behind the park. And it was all grassroots like that to start with. And then it got laid on the trustees. So, so things went slower and obviously sometimes wronger, so as we can tell from what happened with the water and everything. But they had a pretty good grasp of what was going on. And now that's kind of been shifted over to the staff, which is good. The staff has experience from elsewhere. The staff has my favorite best practices from elsewhere. But that's not necessarily Wellington experience or what's best for Wellington. So what I'd like you guys to keep in mind is that when you're presented with things from the staff, if it doesn't make sense, if you want to study it longer, if you want to think about it longer, if a whole slew of people bothered to come to the meeting and, have objections or some sort of public comment, just table things. There's very little has to be done right this second. We can have a special meeting or wait till the next meeting. It's because sometimes it seems stuff gets pushed through just because nobody wants to deal with it any longer. So my favorite president was Calvin Coolidge, and he said that it's much more important to kill bad bills than to pass good ones. And so that is kind of what I think, is that it's better to not pass something if it's not really what we need and what we ought to be passing and what the town wants. So I guess it's sort of the transparency thing, but that's you guys' responsibility, because the staff works for you, the staff works for all of us, and you guys have been elected by a good chunk of all of us. So thank you. Stamp me.
The consent agenda consists of minutes from March 22nd and April 12th regular meetings. Can I get a motion to approve?
I'll motion to approve the consent agenda meetings from March 22nd, 2022, Board of Trustees regular meeting.
I'll second.
Gator.
Point of order, Mayor, I think we need to include the April 12th meeting minutes as well. We have two sets of minutes in the consent agenda.
Do we want to bring up the April 12th first too, before we do it? So I'll amend my motion to add minutes from April 12th, 2022, Board of Trustees regular meeting.
That amendment to the motion would require a second, because we already had a second, so.
I'll second.
Okay. Can I get a roll call on these minutes?
Peter,
Yes.
trustee Kitty,
Yes.
trustee Mason,
Yes.
trustee Teets,
Yes.
trustee Wiegand,
Yes.
Mayor Pro Tem McDonald,
Yes.
Mayor Shosse.
Yes. All right, on to the action items. Number one is, our first action item is resolution 17-2022-A, a resolution of Board of Trustees making appointments to the Planning Commission. Mr. Byrd, presenting.
Thank you, Mayor.
I'm
Shosse.
sorry, Mayor, if I could, just make a suggestion before we start. Sorry, Cody, apologies. I would like to make a motion that we move to postpone the consideration of Resolution 17 until May 10th, 2022 at the Board of Trustees regular meeting.
Is there a second?
I would
The
second
second.
that.
Okay.
And I think there should be discussion on whether or not that should happen.
Open up the floor for discussion.
So the reason I do this is because in listening to public comment, but also having to respond to a lot of comment from the public the last few days after this agenda came out, I will say, I agree, we are a board of 7, and I would love to look at what our board of 7 wants to do moving forward with how we appoint these positions, because they are quasi judicial. They majorly impact those who those decisions are made by. So I really feel that we need to listen, one, to our public, but also to work together as a board to establish our own guidelines and our own way of doing things. It might have been this way before, but it might not have to be that way moving forward. It has come to my attention, we don't have to push this through tonight. So I would really like to wait until our board retreat.
Thank you. Any other comments? Gator?
Yes, so I had expressed understanding on the old board, this was the process that we had where we had interviews and then with 2 trustees. And I had concerns then, and I had shared those concerns with staff prior to this board being seated, that with boards like the Planning Commission and the Board of Adjustments, because they are quasi judicial, they are making determinations on different things in the town that do not come back to us. That I, as a trustee, do not feel comfortable just putting my stamp of approval on someone I've not met with. I haven't had the opportunity to talk with them. And I know there are concerns with the ability for us to have a quorum at the next May meeting. I know one idea that was pushed out was, would there be some way to do like maybe 1 appointment and then we could work out a process that we can all agree on? From my standpoint, I have no problem if it's not the people that I think would be best. That's not a concern of mine. The concern for me is about the process, because the way the process is done right now, what we have is there was interviews that were done. There was 2 trustees, members, staff. We had the chair of the Planning Commission, chair of the Board of Adjustments, which for the record was my wife. But that doesn't mean that I have information. My wife is not me. I'm not my wife. So just because she sat and heard something doesn't mean that that's the questions I would want answered. But that's none of that's to the public. And so we're just presented with 4 names, and we were presented with 4 names to the Planning Commission out of, I believe, 8 that applied. I didn't even get the list of everyone who applied for those boards until yesterday evening. And I only got that because I specifically requested that of staff. I was not presented with the packet. It was not offered to me. So for me, I'm presented a list of 4 names. I have no idea if they're the most qualified names. I don't know if they're the best names. And for me, with such an important decision as this, I don't feel comfortable just saying, well, let's just push it all through. I think we do need to come up with our own process. I understand staff was operating under the old board's process. We are not the old board. We are a new board. And I think that we should try to find a process that we as a whole can feel confident in behind. We just talked about with Sursa about needing to act as one body. And I want to be able to support the decisions of this body. And for me, I'm not asking that I like all the people that are selected. I simply want to be able to say, we followed a process that I'm comfortable with. The process that we're going on right now is not something I'm comfortable with. I have not met these applicants. I've not had an opportunity to talk with them, and I would not be willing and comfortable to vote on them. And I prefer that we do this in a way that I can feel comfortable to vote and support whatever decision the board makes in terms of who the applicants are. Regardless of whether I support those individual applicants, I want to be able to support the decision of this body.
I do have some comments. I would love to have the opportunity to proceed with some of the items that we had planned on to discuss the applicants, because the interviewing process that we did was essentially a recommendation process to the board. We would explain the reasoning and decisions based off of a very consistent process for interviewing those applicants. They all were asked the same questions. We all looked at their qualifications. A lot of these items aren't necessarily subjective, but actual, as if you were applying for a job, are you qualified and how so based on the content and the role of the position? those are the things I would love to share with the group to show you our findings of those interviews. Those interviews were completed by 2 trustees. I was present. Also, the chairs of each of the commission or board that was also looking for this position. So, the chair for the Board of Adjustments, the chair for the Planning Commission. So, and those are folks that have, of course, that direct link, firsthand experience. We'll work with these folks more than anybody else in our room will, based on those specific boards and commissions. So I highly value and weight their opinion on those decisions based off their current roles that they were granted from their peers within their current boards and commissions. So I think that their opinions matter significantly and probably or more applicable for the interview purpose. So with that said, this is a process that has existed. This was not a special exception that was done for this specific interview process. As much as I understand and I appreciate that during our board retreat, we will discuss as this new board how we're operate going forward. We cannot halt all activities right now for the act of saying, but it's my board now. We still have to run the town and continue operating within timelines and making sure that we're respecting our candidates, respecting our applicants for public hearing items and items that require a quorum within our planning commission and within the Board of Adjustments if that were to be needed. If we do not have the members within that, we've already notified the public, for example, of public hearings, but don't have enough people to listen to that public hearing from a quorum from that perspective of that commissioner board, we're doing a disservice to those.
Point of order. My point of order is that is information. There is a quorum in planning commission.
There is the possibility of there not being quorum if somebody misses the meeting. So that could put us into a situation where nothing could be done and we would miss the statute for the annexation.
So can I move to amend that we only support a single member that we can all nominate and elect to fill as a backup in case we don't have that quorum?
The motion that's on the floor is to postpone this item to a date, not to even consider the item, the resolution. So before it could be amended or anything like that, the motion to postpone needs to be handled.
Okay, I'd like to finish my thought, if that's okay.
Please do.
Okay, what's at risk here, I think, is that if we were to proceed with this motion as is, if this were to pass, we might provide the reputation that regardless of applicants and public who are following process within our town, within our scope, and engaging with our planning department to bring forth public hearings. And if we weren't able to hear those or have a quorum present or put at risk in any way that process, we would be saying that politics and ego almost, and this is a perspective I think that could be perceived, are more important to Wellington than handling our business as we should. So that's what I would want to avoid. I want everybody to know that if they're following our processes and goals within these plans and commissions, they know that they will receive fair and just treatment from the judges set forth in their quasi-judicial activities that they're doing. So I think it's really important that even though this is a process within the older board that set forth for these interviews, I think it's a fair one. I think that there's been some accommodations made to be cautious moving forward. I'm sure somebody else might want to comment on that. I think that all these selections were made of amazing candidates and also making them delay and push off. It's also not a kind thing to do for volunteers who are offering to volunteer their services. I think we should respect them in their time as well, that this was on the agenda and that we acknowledge it. But I have a lot of other thoughts about this, but I can guarantee, and I'd love to share my results of what I found out from these interviews of some amazing candidates and overwhelming numbers of people who applied, which make me so happy that so many people are wanting to volunteer for our town.
Mayor Kaler, I have a procedural question. May I ask Mr. Sapienza a question?
Yes.
Thank you. Mr. Sapienza, with the motion on the table, if the motion fails, is the item available for discussion still, or is it just dead?
The motion on the table is to postpone this to a date. So if the motion to postpone fails, the agenda item is still open.
I apologize. Was there a date set in the motion? May 10th. Thank
10th,
you.
yeah.
Thank you for the clarification.
Okay, so I do have a number of comments on this, and I do have a suggestion for the town staff. Patty, if we could look at, for future boards to have these meetings moved or for nomination like a month after the election, I think that would be fully appropriate. First of all, I do have a lot of confidence, and I like a lot of the candidates that have been nominated. I still want to hear from Cody, and I still want to hear what everybody else has to say about this. But I want to say, this interview process has not changed. There was one point in the past, one meeting where recommendation was not able to be made to the board, where options were brought to the board and the board was able to interview those folks. But I want to be clear, the board does not interview candidates currently, right? Alongside town staff, right? The candidates are all recommended by the chair of the planning commission, the chair of the board of adjustments, the two trustees, McDonald and Kinney. And I think we need to be respectful of staff time and trust the process and recommendations that we've been given. The fact of the matter here is we've got a trustee that's participating over Zoom. And if we're talking about policy and procedure here, I think it's interesting that we would consider changing the board rules for this particular item, but we're not talking about changing policy for other precedent that's been set by the past board. So it would be my recommendation. And once again, I've personally read through all of the candidate applications. I'm very confident in these people to address Reg. Reg, to be completely honest, everybody that's applied are all pretty much folks that have been on boards and commissions in the past. You're correct. There are only about 3 of them that have not. So of the total number of applicants, I just wanted to make that clear. We are going to be having some folks in that have served in the past. So I think that's all I've got.
McDonald.
I'll save my comments. Thank you. I'll save my comments for following the motion on the table.
With no
I
further
do have a
comment.
comment.
Trustee Wiegand's on Zoom.
Oh, yes, sorry.
Yes,
Trustee
I would
Wiegand.
like to- I would like to see us postpone and then possibly go with the fourth or one person to get on there too. So we can have a quorum. Just like Kathy had said earlier, making a fast decision isn't necessarily the best decision. And I think we want to make the best decision possible for the city. I think we got so many things coming up here that we got to make sure that we got the right people in the right place. Also, too, I got a question about how you guys set the time frame. Who's going to get each one of the periods there? Whether it's a 4-year, 3-year, 2-year, or 1 year. How did you come up with that? So, just some questions I have too, and I have some concerns. Thank you.
Thank you. With no further comment, I motion this to a vote or public comment. Sorry. Open public comment.
Mr. Mayor, usually public comment is reserved for the agenda item as a whole. So I think if we're going to move to public comment, it would actually be appropriate for the agenda item to be considered in its usual course, even though we've already had some discussion. So I think Cody, we should go, if the desire is have public comment before a vote, I would recommend we probably hear the whole process. We have Cody give his staff give its full presentation, discussion, and public comment. That would be my recommendation, but it's up to you, Your Honor.
So I'd agree with Mr. Sapienza that the public comment would be for if we're keeping the agenda item. So if we right now have an amendment to, or we have a motion to, so we should probably vote on that motion, because if we're tabling the item, then we bring back to that. Otherwise, we could, if the item stays on the agenda, then we would have public comment in the normal course. That would be my suggestion, because we are not discussing approving the item, we're discussing actually delaying the item.
I would agree with Trustee Gator. If you desire to have public comment, I would recommend going through the full process. However, it would probably be appropriate to just call the vote on this one.
I will call the vote on the postponement. Trustee Gator.
Trustee Gator. Trustee Kinney.
No.
Trustee Mason.
No.
Trustee Teets.
Yes.
Trustee Wiegand.
Yes.
Mayor Pro Tem McDonald.
No.
Mayor Shosse.
No. Welcome back.
Thank you, Mayor Shosse. Cody Bird, Planning Director. I'm actually standing in on behalf of Town Clerk Crystal Eicher, who normally handles these processes. But I'm happy to do so because I am the staff liaison for both the Planning Commission and the subsequent item is for Board of Adjustments. And I did participate in the process of interviews. So I simply wanted to stand in for that topic tonight to introduce these items. We did follow a typical process, as I think it was alluded to. The chair of the Planning Commission, Eric Sarter, was involved in that, and so was the chair of the Board of Adjustments, Christine Gator. And I believe both of them are here tonight. So I would encourage them to also share any thoughts that they had with those recommendations as a part of your consideration for this evening. Thank you.
Thank you, Mr. Bird. Again, my name is Eric Sarter. I'm the chair of the Planning Commission. First off, congratulations to the new board members. It does get easier, I promise. You will work through it. You know, as all the conversations just kind of gone back and forth here, we've obviously conducted the interviews for the Planning Commission seats. I will just speak on behalf of the Planning Commission and the the appointment nominees that we discussed for Planning Commission. I'm not on the Board of Adjustments. I'm not part of the Board of Adjustments. I don't feel it's my place to recommend candidates to the Board of Adjustments. So all my comments are strictly related to Planning Commission. You know, as it was mentioned, the process was a 20-minute interview. We saw 11 total candidates for 4 available seats. To everyone's recollection, that was the most candidates we've ever seen for open Planning Commission seats, which is awesome. This trend of continuing to want to serve your community and volunteer on these boards is strong, and it's great to see, because all that can mean is more qualified applicants, which I feel we had. I'll speak a little bit to each of the candidates, but I kind of want to just interject. Being passed over this time around was not, it shouldn't be taken as a slight to any of these applicants. You know, everybody applied, everybody did their 20-minute interviews, and everybody brought something valuable to the table. You know, it honestly, we tend to see things in a black and white and qualified and not qualified and right or wrong manner, but that is not how these applications went. It was not how the interviews went. Everybody did legitimately bring some qualifications to the table, but the reality of the situation was we had 4 empty seats and we had 11 people vying for them. This is the result. To the applicants and the folks that applied specifically, we started with Tim Whitehouse. Mr. Whitehouse obviously has been a trustee already. His experience and commitment to the town of Wellington, I feel, speaks for itself. You know, he successfully navigated 4 years of a trustee and decided to reapply and run again. That takes something special. So, oh, sorry, trying to fly from the cuff, and I'm not terribly good at it. Like I said, Mr. Whitehouse, I've had the pleasure of serving with him on the Planning Commission, and there's really no better experience than applying for the job that you've already done, and he's done it well. Next on our list was Lisa Chalet. She's obviously coming off of a Board of Trustees campaign of her own. I know it didn't go the way she planned or wanted to, but that doesn't negate the experience of seeing kind of the inner workings of the town, and that brings some valuable experience to the Planning Commission as well. Somebody that's been through the kind of the rigors of the campaign, has been familiarized with the Board of Trustees, Ms. Shelley also served on the wastewater resident roundtable, which I served on with as well. And it sounds like she gained some really valuable insight as to how the inner workings of this town, you know, how it works kind of behind the scenes. You know, she's got good building experience, she's got development experience. Everything that she brought to that interview is relevant to the planning commission, and she was a strong candidate, which is why you see her on the resolution tonight. I could say much the same for Ms. Moyer. Larry Moyer, excuse me, obviously also came off of a campaign for board of trustee. Same story. It didn't quite go the way she planned. I'm thrilled she applied for the planning commission. Her interview, I think the breadth of her experience was something that no other candidate brought. She has been in development and seen projects from raw land to closing. That is not something that we've had with any of our other candidates. She has seen the broad spectrum of development from bare ground to a closing on a property, and she's done it with multiple municipalities and appeared before planning commissions in multiple municipalities. It's a valuable experience. And then Mr. DeCentra, our new fish, Gary came prepared with a resume, as well as multiple letters of recommendation from previous employers. So thanks for that, Gary. That was awesome. The board really appreciated his experience, and he's obviously been in the field, a relevant field, for a long time. So we also felt it was important to just have some fresh eyes as well, although they were qualified, fresh and qualified. So obviously everybody lives, works, and plays here to some degree. It's my experience working with at least 3 of the 4 that they really do have the town's best interest at heart. So that is the reasoning behind you seeing them on the resolution tonight. So thank you all.
So I'm Chair of Board of Adjustments. So as a interviewing panel.
Could you share your name?
Oh, Christine Gator. As an interview panel, we decided that since there were so many applicants, that we wanted to put one on each seat instead of duplicating them to the Board of Adjustments and Planning Commission. And so Eric picked his first, and so the ones I had left were Kathy, Wyatt, Levi, and Reg, which is option 1 in your packet. I just heard trustees say that you highly weight my opinion as chair of BOA. So I'm a little concerned. I feel like you didn't trust my opinion because you put an option 2 in the packet. So let me tell you why I like Kathy. She's on the board for.
Ms. Gator, I don't mean to interrupt you, I'm sorry, but just because this action item only is regarding the planning commission.
Oh, then why did I'm sorry.
I want to hear your items, but I want to make sure they're on the right action item, so.
I apologize.
But do you have any comments on the planning commission items for you? Because you did also participate in those interviews.
You participated in both.
I'd love to
right?
hear about your impression on them.
Sure, I can tell you about the Planning Commission. My thoughts were of the minority. And so I just wanted to share my perspective. Obviously, Gary came with the most credentials, being a surveyor. And so I really liked that. I thought Wyatt also had a lot of knowledge. And just to give you some perspective, he's on the Board of Adjustments with me, was on the Board of Adjustments with me. And because he's an engineer, and because that's his experience, his passion, he talks and shares and asks questions a lot on the Board of Adjustments. And I know that was a concern that he might not do that. So just to let you know how he was on the Board of Adjustments. I also liked Levi because of his drilling and reclamation work that he does. So it's kind of the other spectrum of the site plans. After they pass, he gets to build it. Lisa had construction background, so did Tim. And for me, just deciding between the two that had just construction background, no offense one to the other, just new ideas, new face, just getting new people to be on the planning commission was my perspective as to why I thought the people that had the most credentials, the best credentials were Gary, Wyatt, Levi, and Lisa. Thanks.
Thank you.
I don't have anything further to say. I apologize to Ms. Gator for, I understand there's a little bit of confusion there, but I felt it was important since both were involved in the interviews, they both have an opportunity to speak. That's why I suggested that, but I don't have any further comments. I'm happy to stand for any questions.
Perfect. Thank you.
I think one other small item for clarification in reference to Trustee Wygand's question about how we went about deciding who filled what term, like those seats, and we chose that selection based on experience. Gave the people who had served previously the longer terms and the people who hadn't served before a shorter term so that it would give them an opportunity to get their feet wet. And if this isn't the right board or commission for them, then it would give them an opportunity to pivot and change.
Thank you. Are there any comments or questions from the Board of Trustees? Trustee Gator.
I was just gonna say, I'd like to hear from those interviewed before I share my thoughts.
Thank you.
Cool. I'd love to share. So as Commissioner Sartor mentioned, we interviewed 11 people that day, and it was awesome because there were people who had very clear experience with that specific board or commission already, and there are people who didn't at all. And it was wonderful to see the volunteering spirit of people saying, hey, I don't know if I'm the best for this, but I know I want to help. So I'm here to find out more and for you to give me direction. And maybe I'm not the right candidate, but hey, I showed up. And we're like, that's so awesome because there's so many other opportunities too. So if for any reason you were not selected for your top choice of board commission, there are so many other opportunities. And I want to encourage those people to continue trying or reaching out or learning more and seeing how that they can serve. And I just appreciate everyone so much for doing that. So with that said, again, there were a lot of candidates. I said at one point during the interviews, because I've been on the planning commission till recently, right? If I was interviewing now with the current candidates, there's no way I would have been a planning commissioner. That was the value of the candidates that were there. And I was like, wow, I feel like I'm there now because I have that very direct, immediate experience with the planning commission for years and years now at this point. But if I were the person walking in saying, I have the best intentions, I want to learn more, teach me, that's not the candidates that actually won this time because there's so many people with like pertinent professional experience or town experience or other items too. So with that said, we kind of did a little puzzle where we ranked applicants and then kind of fit them into the terms and then weighted that against the Board of Adjustments with the consideration of do we want overlapping members or not? And there were advantages to doing that for multiple reasons. And one of the reasons that we wanted to do it initially, just as a reminder, is we have a hard time with attendance of Board of Adjustments because they don't meet as frequently sometimes. And they would not necessarily be as engaged because they don't meet frequently and have multiple items that they review in each meeting. So with that said, the idea was there would be a best practice then to have crossover members, right? So that was kind of one of the considerations, given that we had so many candidates and so many people who wanted to be involved, we didn't know if that was necessary. So that was kind of part of the process, but we can talk about more about that, the Board of Adjustments action item. So for the people that we recommended for Planning Commission, and again, as we ranked them, the top one was Tim Whitehouse, who's been a planning commissioner longer than I have, and then of course a previous trustee. One of his amazing abilities that he mentioned during the interview, and I've witnessed firsthand, is he is the most detail-oriented person I've ever met in my life. He will actually read the plans, like every single word of it multiple times. I'm not that kind of, so him matched with others is a great team. And I think he brings a great item and dynamic. Plus he has so much good experience with the land use code right now. And zoning in general, because he has that firsthand experience. So He is a fantastic applicant and is highly recommended as our top recommendation. Next, of course, was Lisa Cholet. And I'm almost embarrassed to know that I got a lot of opportunity to know Lisa, but not until this interview did I understand the depths of her professional knowledge associated with development. How many projects she's worked on such a large scale with so many different municipalities. She brings knowledge that our entire town can benefit from, specifically in the area of planning and development and everything associated with that, and is extremely dedicated and capable. Next is Lowry. And again, another thing I'm embarrassed to say is I knew her prerequisites and her experience that she brought, but I didn't know the depth of it. And then the experience with the actual processes that are involved with the Planning Commission. She's been all of our candidates in this case, or Lowry, Lisa, and Gary in this case, have been on the other end of the Planning Commission as people presenting to planning commissions of different municipalities. And not just once or twice, but for extended, large, long-term projects of many different multi-units, smaller units, things that involved funding from multiple locations, all projects that we've likely never even seen in Wellington before. And so with her depth of knowledge there, and just experience, it makes her a very top candidate. Same thing with Gary. It was great to get to know him. And he has, I think, 40+ years experience of doing the work that we hear and listen to from the Planning Commission. So it was a very hard list of candidates to compete against. And we got some amazing, amazing people who are willing to lend their professional skills and talents to our town for $0. It's amazing. So I can stand behind all of our candidates wholeheartedly, saying that they are amazing assets to this community and will serve the Planning Commission really well. That's just like highlights of it. There's so much more that we learned in our interviews, but I figured I'd summarize it for you.
Thank you. Trustee Kinney, do you want to talk further on the interview process?
Sure, I'll provide a few comments. Thank you.
Thank you.
First, I want to thank the people and the volunteers that applied for these committees and commissions and for taking time out of your evening to show up and be prepared for these interviews. It can be an intimidating process if it's something that you've never done before, to sit in a room with staff and elected officials and try and tell them why you're the best person for the job. I would also like to thank the staff for taking time out of their evening. It was a long evening, but it was very intentional. It was a very thorough and intentional process. And something that I appreciate about the process was that we did not all agree initially on who we selected for our 4 candidates. As Ms. Gator alluded to, she shared her 4 candidates. My 4 top candidates were slightly different than what were presented in the packet. But I think what is really important to share is that multiple times throughout the evening, once we received kind of worked through the process and came to our selected candidates, we asked each other several times, are we in consensus? Do we all agree? Can we all live with this decision tonight? Because if we were not in consensus, we were not going to make a recommendation. So I think that that's important to share. Tim Whitehouse, thank you for throwing your name in the hat after not having the outcome of an election that you may have intended. The same for Ms. Cholet and Ms. Moyer. It takes a lot of courage to put your name in the hat when you've lost the game. To stand back up and get back out there and keep going and keep trying, it takes a lot of courage and determination. So thank you for doing that. And Gary, thank you for having the courage to be a new and fresh face in the community. That is something that I thought was really exciting about this process, were all of the new faces that wanted to get involved. That's something that this board, and I'm sorry, the previous board has talked about a lot, is community engagement. How do we get the community involved? And I think the fact that we had several applicants that were new faces is an excellent measurement that our efforts for community engagement and getting the word out there is working. So good job. Thank you to the board. Thank you to the staff for all of our hard work trying to work on that. Although the 4 candidates in the packet were not the ones that I, had personally thought were the best candidates, I stand behind the presented applicants in the packet.
Thank you. Any comments from trustee Gator?
Thank you, Mayor Shosse. First, I had a process question for staff. Are we required by law to appoint all 4 seats at one time?
No.
Okay, and if I am to understand correctly, the concern that's been raised is that we have currently 4 members of the Planning Commission. One of those last day is this coming meeting, and the concern is that if we don't do this appointment immediately, we might not have a quorum to hold a May Planning Commission meeting. Is that correct?
The concern isn't necessarily about Mr. Friedrichs, but just in general with if someone got sick, I mean, just hypothetically wanting to confirm that we would have at least a quorum.
Okay. So we would have the possibility of appointing, we could appoint 1 seat that would help with addressing potentially a concern, but that would be legally allowed. Is that correct?
The board can appoint any number of seats at this time.
Okay. So I guess, again, as I shared earlier, really my concerns with this is about the process. It's not about how the people have been appointed. And I understand we're in a unique situation with removing 2 trustees and a mayor from the board all at one time. That was not a normal thing for us to empty several seats all at once. The concern that I have is, again, what I shared earlier is these are quasi judicial boards. Speaking to the planning commission at this moment. The other thing that is a concern is the one thing that I did not hear from any of the reports from this is what is these people's vision of what Wellington should be? Do they see us becoming a Fort Collins, a Windsor, a Loveland? Do they see us staying as an agricultural town? And that's one of the things that we have just gone through is we had our planning commission that put together our comprehensive plan. And that really dictates a lot of things in terms of what developers are going to look at Wellington, what businesses are going to come to Wellington. And that's a document that the planning commission, the board of trustees has no say over. We give some input and feedback, but ultimately all decisions on that are made by the planning commission. We as trustees have, it's out of our hands. And so to me, those are questions that I would have wanted to see answered by candidates to understand not just what is their professional background, but also what is the vision that they have for the town. When they're considering site plan reviews, what are the type of things that they're going to be looking at, not just from a technical standpoint, but from what type of a culture is this going to create here in Wellington? And so I understand the concerns of trying to get something. I would be amenable to saying, can we maybe appoint 1 person that we can come to consensus on to the planning commission to address the concern of making sure that we have a quorum for the May meeting. And then I would like for us, we're sitting down this Friday and Saturday to work out how are we as a board of trustees going to operate. And if we as a board of trustees decide we are going to use the exact same process that exists today, I have no problem supporting that. But I want that to be our decision, not a decision that is passed down to us by staff or by the previous board. And so from my standpoint, I would want to be able to have, I know some of the people on this, but my job as a trustee is not to appoint people I know and people I like. You know, there's a lot of people I know and I like. One example is I think that Wyatt Knutson would have been a great person on the planning commission. He's got a ton of experience. He's served on the board. He's served on the planning commission. He knows this construction and planning stuff. A lot of people who have questions about going to the planning commission, go to him and ask for help. That would be a great person to have on the planning commission, but he was not included in that. And until I actually requested documents last night, I didn't even know officially that he was even considered for that. And so that to me is where my concerns lie, is it lies with the process.
Thank you. Trustee Mason. Trustee Sherrill or Teets?
I do, thank you. So I want to mirror what John said, but I first want to address everybody that did apply for Planning Commission and Board of Adjustments. Honestly, it has nothing to do with the people applying. It's how the process is applied to the procedures. And looking through a lot of the applications, I know that I have brought up one of my main concerns is how many conflicts of interest there is. And when we are looking at trying to represent Wellington best, when we have people that have listed multiple conflicts of interest and we are applying those people to these boards, my concern comes as, are we going to have a quorum for planning commission if we're having multiple people recuse themselves because of that? I want to say I would have loved to have supported Tim as my nomination if we were to do so for the planning commission. I do feel that his passion for this town is huge, huge. But that's still the same as what I would like to see. Lisa, you're wonderful. I love the fact that I think when I counted them in your application, you volunteer on over 9 boards. That's pretty amazing. But we also have to classify is planning commission is a big job. There's a lot of responsibilities and we are accountable to our residents first. And I want to make sure when we were conducting interviews that we were making sure those conflict of interests that did arise wouldn't be something that is coming up or is a 7-year project in the future. Those were my main concerns when I was looking at this. It had nothing to do with the people applying for the seats. I still talk to Lisa through Messenger. It has nothing to do with the people that applied. It has everything to do with multiple conflicts of interest. The Board of Trustees now not being able to weigh in or ask questions. And the best fit, we had a civil engineer apply who has a lot of experience and he is an alternate on the Board of Adjustments. So those are some of my concerns and I would have loved to have been able to address that. I won't unfortunately be able to support the appointment because I didn't interview these people. So that's my comments.
On my behalf, basically what I've heard is the process works. I've heard that there was compromise and they came to a consensus on who they wanted. And I think what makes us successful as a board, successful as a town is compromising. That's what makes relationships work. That's what makes people successful. And
I was gonna say,
dang it, I forgot about him again. Trustee Wiegand.
Sorry about that. I do appreciate everybody that has done the process. We got some great candidates there. And I appreciate everything that they've went through. 20-minute interview is not necessarily the most entailed interview. I'm just concerned about getting the best people there for the city or for our town and to make sure that we're doing the best job for them. So I don't know if I appreciate the people. I just don't appreciate the process at the moment. Thank you.
Thank you. I'll start over. So what I heard was there was 4 people. They brought on 11 applicants. They went through the process. I have their applications right here. It states on most every single one of them whether they had conflict of interest or not. I think that's a pretty important part of the process that they went through on choosing those individuals. I also think that when you have those many applicants, that it is going to be a difficult process. There are people that are not going to be picked. I'm going to trust in the board. I'm going to trust in the people that ran the interviews to take on their recommendations. Trust is a huge part of what we need to do up here as a board. We need to trust each other and we need to trust the recommendations that we are getting. So that is going to be my comment on that. I would actually like to open it up for applicants to maybe have comment in this. Is that something I can do, Dan?
You're the mayor.
So if there's any applicants that would like to speak on behalf of what conflicts they may have or not have, processes that you went through, anything of that nature.
Hi, everybody. Congratulations to the new people. Lisa Cholet. So I'll start with the easy one, conflicts of interest. I don't have any. I might sit on 9 boards. Most of those are within the school district. Most of those serve 30,000 students, not just this town. However, I do use those relationships that I've built for the last 10 years to the benefit of this town and to the kids that live here. I don't think that should disqualify me as a planning commissioner. I do that not for applause. I didn't run for trustee for applause. I made a commitment in every forum I was asked, would I stay involved in this town? And I committed every single time that I would. And that's why I put my hat in for the planning commission. I think I am qualified for it. I have demonstrated in the last 8 months of my involvement in public comments, in being on the sewer rate roundtable, that I'm always applying common sense and practicality to the rules and the laws that govern this town. I would be delighted to be a planning commissioner. My job is not to put my own vision on this town. I wasn't elected. That's when that would be my job. But my job is to implement the vision of the people that sit here, but more importantly, not just the people that sit here, but everybody that's at home as well. And some of those people did vote for me, and I made a promise to them that I would continue to be here, but I also am committed to doing always what's best for the town of Wellington. That means treating the staff with respect and respecting their time, and treating all of you with respect and respecting your time. And I think that it would be beneficial to everyone, the residents, myself and my family, and to all of you, to trust one another, trust the people that sit on the boards right now, and trust us that have chosen to put our hat in the ring for a job that isn't going to be easy. And it's going to be making decisions and doing the right thing every time, and just trust that we can do that. There isn't a bad applicant in the pool. I don't know everyone, but I can speak to the people that are recommended. I read their applications, and I think that each and every one of us brings a lot of skills to the table, and we want to serve this town. And I think it would be foolish to allow the need for things to be different, or politics, or whatever is driving anything, to get in the way of just what's best for Wellington. So I would encourage you to vote that way. And if you don't think I'm the best for Wellington and you don't vote for me, I'm okay with that. I'll be all right. But just know that I'm putting my foot forward because I love this town. And I show that in the 9 different boards that I sit on. And I think that says something.
What she said. I also made a commitment, and I just feel that it's important to say that, you know, through the forums as well, was asked, how will you continue to serve the town if you are not chosen? And though things did not go my way, they went the way that the town chose. And I support that wholeheartedly. And ultimately, my dedication, my wish, my vision is just a town where we can all thrive. And so however the board sees that, whatever vision the board puts through, it's our job as the planning commission, if appointed, to do what we are there to do, and to work with the people that come to us wanting to propose projects and hear them and serve the town however we can. My skills and my background, I believe, do make me an excellent candidate for this. I've always thought that, and I would love to be able to serve in this way. But again, like Lisa said, if you don't choose to vote that way, that's fine. I'm putting myself out there, and I want to serve this town, and I want to use my knowledge to help us however I can. So thank you.
Haven't stood here in a while. My name's Tim Whitehouse. I've been in this room since 2015. My wife and I started showing up to figure out well, how does this whole thing work? I can tell you back then, it worked a lot worse than it works now. Yeah, it works way better now, but yeah, so I've been on planning commission for 4 years, been in construction over 20. You guys see me around, you know what I do. You see me out shoveling the streets, right? I'm not town staff, but I'm here, I'm committed. The question came up about conflicts of interest. Don't have any. Now, if there were one, and it's certainly a possibility, what do you think is going to happen? You're going to recuse yourself. You're going to declare it and recuse yourself, just as I have done in board meetings. This is not some sort of magical process. It's pretty straightforward. So, but hey, I'm willing to do it. I said I would. I think I'm qualified. But again, you get to make the choice up here. That's really, and again, whether it's 1, 2, 0, that all lies within your hands to do. So.
My name's Gary DeSanta. I'm the new blood in town here. The good thing about that is I don't have any preconceived notions. I'm not involved with any businesses or anything. So all my views are going to be new, clean views. Conflicts of interest, absolutely none. I moved to Colorado about 4 years ago, lived in Fort Collins my first 2 years, and been here 2 years today, actually. My background, I'm assuming you guys got a copy of my resume, but I've worked in the engineering firm for 40 years. I've been involved in all aspects of it. I'm not an engineer, but I have done drafting on engineer. I've done preliminary design for water, sewer, storm sewer, sewer treatment ponds. I've also done the inspection on projects like that. I was also a licensed surveyor in Nebraska and Kansas. So I've worked with numerous developers laying out subdivisions and infrastructure with them. So I do have the experience. Granted, I'd say I'm the new guy around here, but one thing I noticed, the last town I was in, they were going through a process like this, but it was for position on the board of trustees. And the candidate that everybody liked was a new guy on the block because of no preconceived ideas or anything like that. So this was my first opportunity to get involved with the city. I tried for board of trustees, but I was too late getting signed up for that. So I thought this would be the next best thing because I have the background to it. So, there's always a learning curve. I'm not saying I know everything about it, but I've been on the other side of the table. So I know what people on this side of the table think, and I know what people on this side of the table think. And it's never 100% the first meeting. So there's a lot of give and take between both entities. So I really hope that you appoint me to this position. Thank you, guys.
Thank you, Gary.
Good evening, I'm Levi Kalu. Just want to start out by, I have zero political experience. So I came to, I wanted to apply for the position because, I've never had the opportunity to get involved with the community. I've been part of the oil field for the last 16 years. With that being said, I've been gone, every 2 weeks, live in a different place, whether it be North Dakota or in another trailer somewhere around here. So I haven't been able to actually be part of the town when I wanted to. Although I have been a resident of Wellington for quite a while. I've got 2 teenage daughters, and that's my main concern to want to be involved with the town. I mean, I want to have grandkids one day. I want them to be able to come home to a good place. And I mean, I guess if it's my view, I don't want Windsor. I don't want Tinmouth. I don't want Fort Collins. I would like a place that, it's a small community. Everybody moved here, I'm pretty sure, because of that reason. And that's That's my view. Whether I'm supposed to state that or not, I'm biased. So that's my view. I mean, I don't necessarily think it needs to say very, very small, but it needs to have responsible growth, within the community. Everything needs to be thought out. My experience has been in the oil and gas industry as a consultant. Currently, I do reclamation work for basically everything you go in and drill. We go back through 30 years later, cut and cap the well, and we make it go away. Make sure everything looks good and the environment's taken care of. Any remediation that needs to be taken care of is done. So that comes along with reading grading plans, things like that. So applicable experience. I grew up installing mainline water lines, sewer lines for the city of Fort Morgan with my family business. So I have plenty of civil experience. And I think that there's older parts of Wellington that need that. The last thing that I will close out with is, although I do respect prior service in the community with in regards to the politics, I do believe that sometimes it's a citizen that can do the best job, because you see it from a citizen's point of view. You have conversations in the restaurant, you have conversations with your peers, and those are kind of my thoughts on it. Thank you. Have a good night.
Thanks, David. Are there any other applicants that want to speak? Okay. Are there any comments from the public regarding this agenda item?
Good evening, Mr. Mayor, members of the board. My name is Tom Donnelly. Just so happened to be here for another agenda item, but I actually am representing the applicant that will be before the Planning Commission in 2 weeks' time. So I have perhaps more than anyone else in the whole room have maybe even the guy who's never served wants to get appointed. I have maybe more of a vested interest in ensuring that you can seat a full body at your next Planning Commission meeting. So I count on the wisdom of this board to exercise their judgment and find a way forward so that you can at least have a seated board and can really provide these fundamental and statutory, frankly, rules of government. So I know you'll get there. I was a member of the Larimer County Board of Commissioners for 12 years, and these are uncomfortable discussions because you're dealing with people. A lot of times they're people you know, right? And you're talking about them and you're rating them against one another in public. And so it's awkward and it's embarrassing and nobody wants to do it. You're doing a good job. You are. It's hard work and you're a brand new board. And I used to fight with Gator's dad all the time on this stuff for forever. It's none of it's personal. And I hope everyone here leaves it all here and all the people there leave it all here as well. You're doing a good job. There's a path forward. I think you're very close, just as an armchair quarterbacking here, to finding a path forward. And I hope you'll get it done and get it across that you're the quarterback, right? In this analogy, get it across the goal line, Mr. Mayor, and let's move on with this meeting. Thanks.
Thank you.
Hello, board. I am Sawyer Eifert. I live in the Knolls. I have noticed in previous meetings that the code of conduct hasn't been followed by the Board of Trustees and the mayor. I go to CYO with my dad, and it's called Colorado Youth Outdoors, and they taught me in archery that we need to follow through and to get a bullseye, and that comes into play with this meeting, and the board needs to follow through with your commitments and to the public and the people of Wellington. Thank you.
Thank you.
Great job. Thank you.
Karen Eifert, the Knolls. I would just ask, I know it's been asked before, but I'm just going to say it again. I really wish that these votes would stop being rushed through. I wish that the board would consider all of each other and not say something to one group of people and promise something to one group of people and then change your mind as soon as you walk into this boardroom and leave what you have said to your constituents and to the people of Wellington in the dust. And I really feel like these positions should not be a consolation prize for not winning another office. And that may or may not be going on, I don't know. But if that is going on, please consider the people of Wellington. Please consider that we voted for you for a reason. We talked to you, we voted to each one of you. We heard what you had to say and you made promises. And I really hope that you keep those promises, not only to when you're talking to us out in public or aside, but also when you walk through these doors. You walk through these doors and sit in those chairs, please have enough tenacity to hold to what you said you would do for the town of Wellington. Thank you.
Thank you, Karen. No more further comment? Okay. Gonna bring it back to the board for any final comments. Trustee Gator.
So what I think would be a compromise, because again, my goal is to find a solution that we can work together, is I would like to know if the board is amenable. And so I guess that would be an amendment, but to appointing a member to the planning commission tonight so that we can make sure to field the board quorum for the meeting coming up. And then let's address the process and then come back and appoint the rest of those at our first meeting in May so that we can get this done and off the table, but find a process that really kind of allows everyone to feel like their voice has been heard. I appreciate the applicants and I think that's important. But I think it's also important to remember that we as elected officials, we're called on to make decisions that we feel are the best for the town of Wellington. And if we as the elected officials say that we need to have information or additional information to make that decision and a good decision, I think it should be a priority for this board to make sure that we can make that information available. So I'd like to, I don't know if you want to finish comment before I actually make an official amendment to see if it's voted on, but that's my thought.
I'm a little alarmed that 3 trustees came to this meeting with the indication that they should move forward with one appointment. That seems like a very unique thought that's brought by 3 separate individuals. It makes me concerned that maybe that was the discussion in a separate meeting that occurred outside of this one. I do want to make that noted. All 4 of these candidates are overly qualified from most of the people currently sitting on the planning commission. They're amazing candidates and have gone through this entire process in the timeline that was provided and described to them in advance and that we had as expected for this agenda item. I feel there was unfortunately a tone of almost like defensiveness that people are begging or feel burdened for wanting to volunteer for our town. And that is really sad to me because if you volunteer for the town of Wellington, you should be celebrated, not like defending yourself against certain process. It is our role in this case to make sure that our boards and commissions are staffed appropriately. And we have extremely qualified candidates. I would love to, and I would be in favor of moving forward with the action item as listed and as recommended by staff.
Trustee Mason.
Yeah, so well, I have been thinking about this over the last number of days, and quite frankly, I had considered options to potentially change the rules, these types of things. But I think what I come back to is I truly do trust this process. The recommendations that we've given, these are excellent candidates for this. And I suppose what I want to stress again is that the interview and recommendation process has not been changed here, right? This is what the prior boards have done. And I'm not sure that, we're going to discuss all this on Friday. And if the board agrees, we're going to change the rules. But I'm not sure I agree that I think what the idea here is that only the board does interviews and makes recommendations. Well, is that fair to our commissions? And I would suggest probably not. So.
Thank you. Yes, Trustee Teets.
So I will be honest and say that this actually was a discussion before this meeting. So I was asked to pick one person that I would feel comfortable voting for when we came here. And after going through our CIRSA training, have figured out that that was a very bad idea. So because it's considered, what did they call it? A walking quorum. So we actually have a walking quorum in this matter, and I don't feel we can vote because I know how you're voting, and I know how you're voting, and I know how you're voting, and I know.
Oh, do not.
Well,
say-
that's just what was explained from somebody else.
Okay.
So
Did
that's
did it
the
come out of
thing.
my mouth?
No.
Okay.
So probably shouldn't have been represented from someone else then. But so, and that's my concern with this and where I'm going and suggesting that this truly needs to be brought back to our board for a discussion because people came here with a general idea of a 4-3, and I guarantee you that's happening. So I want to apologize because we just went through our CIRSA training before you guys came here. And I'm going to be open and I'm going to be honest and transparent and figuring out that it is not okay. And it's called a walking quorum. I don't have anything else.
Dan?
The information that trustee Teach just shared is as much as I know, I mean, I've not heard any of that prior to now. This action item is in the agenda, or it is in the packet. So the board has had an opportunity to discuss it. I think if there have been one-on-one meetings as the CIRSA just explained are appropriate. The issue is if 3 or more individuals got together, the walking quorum issue doesn't happen every time there is a one-on-one meeting. I mean, part of working in a body of 7 individuals is there are a number of meetings between one-on-one to talk about the agenda item that's in the packet. So I don't think that there's a reason here to postpone this item or continue it based on that. It seems like the conversations that I'm aware of seem to have been appropriate, the standard one-on-one discussions that would happen with any board. But I have as much information as you do at this point.
Thank you. McDonald? No.
Oh, yes.
Yes. Do we have it? Okay.
Trustee Wiegand?
The one thing I'd like us to do is just be able to work together as a board without the conflict, try to do what's best for the city or the town, of course. You know, again, if this is causing some disruption within the board, maybe we should take it one step at a time. Okay. I think we got great people that were nominated. But again, if we can solve it, if we can get a good consensus within the board by taking it one step at a time instead of doing everything immediately, that might be the best way to get a good adhesive working together here. So keep that in mind. Appreciate your time. Thank you.
Respectfully, Trustee Teets, I came here tonight to hear all the discussion. I don't know that anybody knows particularly how anybody was going to vote, especially considering the fact that I hadn't even decided yet coming to this meeting today. So that all being the case, and certainly you and I have had a discussion, but I guess that's what I would point out is I don't know that we know what folks' votes are going to be here.
I would like to say yes. I mean, we've had discussions. I don't believe that we've spoken since Sunday. I did ask to see if you would have one nominee that you would pick. I had one-on-one meetings with Gator, spoke on the phone with Brian Mason, spoke on the phone with Mayor Pro Tem, and I spoke on the phone with Kenny. That's what we do with one-on-one meetings. And I was trying to bring together cohesion and trust between these individuals and between our board and trying to make this work for the town, for us, and for us to come together. That's my goal. And so I don't believe there was a walking quorum by any means. And that's where I stand on that. But I would like to hear from Trustee Gator.
All right, so give me 1 second here to get to the right spot. So for the reasons that from the feedback that we got from the interviewers, that they all felt that Tim Whitehouse was the strongest candidate of those that was submitted. What I would like to do is I'd like to make a motion to appoint Tim Whitehouse to 1 regular term on the Planning Commission, April 24th. Term begins on May 3rd, 2022, and to delay the appointments for the other seats of the Planning Commission to our May 10th meeting.
I will second that motion.
Roll call.
Roll call.
Trustee Gator,
Yes.
trustee Kinney,
No, because I would like to make the appointment for all tonight.
trustee Mason,
No.
trustee Teets,
Yes.
trustee Wiegand,
Yes.
Mayor Pro Tem McDonald,
No.
Mayor Shosse.
No.
I move to approve Resolution 17/2022, a resolution of the Board of Trustees making appointments to the Planning Commission for Lisa Cholet, Lowry Moyer, Tim Whitehouse, Gary DeCinta.
I'll second.
Roll call.
Trustee Gator,
No.
trustee Kinney,
Yes.
trustee Mason,
Yes.
trustee Teets,
No.
trustee Wiegand,
No.
Mayor Pro Tem McDonald,
Yes.
Mayor Shosse.
Yes. Next, we have a resolution for number 18-2022, a resolution of Board of Trustees making appointments to the Board of Adjustments. Mr. Byrd.
I don't have much to say. This was a same process, same nights, different individuals, different recommendation. Similar to the last conversation and good job, having the conversation. I know it's tough. But I just simply point out again that the chairman of the Planning Commission, and the chair of the Board of Adjustments were involved in those interviews. If they had any specific recommendations, I think it'd be good to hear from them as well before you begin deliberations. So thank you.
Christine Gator, Chair of Board of Adjustments. That's the item we're on, right? Am I good?
Yes.
Okay. Option 1 was my choice for Board of Adjustments as chair. Kathy Wideallis, she is on the Board of Adjustments. She was appointed to an expiring term. So her term was only 1 year long. And I think she came to 2 meetings because we don't have meetings that often. So I think there was 2 meetings in that 1 year, maybe less, don't remember. So appointing her so that she can actually have a full term, a 4-year term. There wasn't a 3-year term option. So I don't mind whether it's the 2024 or the 2026. I'll take Wyatt Knutson because he has a lot of experience and can share a lot of knowledge. So he's the other regular member. Then we have the first alternate and the second alternate. Levi has a lot of experience. And then Reg, I want to talk about him. He shared in his interview his experience on the other side of presenting a variance. He lived in a different town and he came before the Board of Adjustments there and asked for a variance and was denied. And he told us that story. And so I think as members of the Board of Adjustments, we need to have empathy for the other side. And I think he can have that because he was denied. And so he would be a great candidate for appointment. Also, we didn't want to duplicate, since there were so many applicants, 12 applicants, 11 that did the interview. We want to give everyone a chance to serve on a board and not duplicate any. By option 2, you'd be duplicating some of the members from the Planning Commission. And the first alternate, what that means is if someone can't make it, it's a board of 5 people. If someone is sick and can't make it, the first alternate gets to now vote and be in that seat. If 2 people don't make it, or if the first alternate can't make it, then the second alternate will go into that position. So those are my recommendations based on the candidates that interviewed. And Kathy as well asked a lot of good questions. Shares her opinion, which I like, Wyatt does the same. And then Reg and Levi haven't dealt with them on a board before. But I like their past experience and what they can bring to the board. Thank you.
Thank you.
I'll be brief. I already made my statement regarding the Board of Adjustments. I was supportive of the selections, but at the recommendations of the fellow panel members. So it's not my board. It wasn't my place. Thank you.
Sure, I'll kick us off on this one. Thank you, Mrs. Gator, for sharing that information about Reggie. I thought that was really important to highlight regarding his application. Thank you, Levi, for coming out and participating in this process and getting involved. And Wyatt, I appreciate your knowledge and expertise that you bring. And Kathy, thank you for your ongoing commitment to the community. You've been a dedicated volunteer for as long as I've been a volunteer, so at least 10 or 12 years. So thank you so much for hanging in there and staying involved and asking good questions, even when you don't always understand, because I think what's important to note about these boards and commissions is that we're not always looking for experts, but we're looking for a diverse set of expertise to provide a wide range of perspectives. And what's unique about the Board of Adjustments is that that board is extremely important, even though they meet very, very rarely, because those people are asking for an exception to the rule. They're asking for something outside of what the Planning Commission and what this Board of Trustees and the voters have approved. And so we need people that can take a look at those difficult and unique situations subjectively and use their unique qualifications to provide a just decision that has empathy. That is one board that does require a significant amount of empathy and understanding for situations that are unique and challenging. So although the Board of Adjustments does not meet often, it is a very mighty and important board. So thank you for the applicants that came out and applied for that. Trustee Kinney, do you have any comments you'd like to make regarding the applicants?
Yeah, I agree with that. From the perspective of the applicants, a few things were considered and weighed my options, which again, we kind of workshopped it. So we all came with our tops and then fit them into positions together as a group, which is kind of how these general overall recommendations came about, right? So Kathy Wyatt Dallas obviously has experience in that specific board, has served it well, is very committed to it and has done a great job. So that's why we recommended her. Wyatt Knudsen obviously has an extended engineering knowledge and a very vast knowledge of code and ordinances. And that, since this is adjustments essentially to those, that's why it's very essential that he has that very prominent knowledge to bring to that entire group, as a diverse subset of skills to bring to that entire group. So, and he's also a very committed volunteer. And so with these groups that meet infrequently and have a hard time, maybe since they don't talk about these topics constantly, like they would in the Planning Commission, for example, someone with that really good background, presence and dedication is vital for that board. So that's why we recommended Wyatt. The two options that you see before you, and that I would recommend we choose between those two from the perspective of the board, offer two different benefits. The first one meaning that we had so many candidates, we didn't necessarily have to do an overlap. I think initially before we thought we might have to, because there wouldn't be enough candidates to fill both boards, but there were more than enough. But the other advantage though too is that knowledge benefit. Somebody who's frequently or involved in the planning commission is going to have more knowledge of those codes and ordinances than someone who doesn't have that awareness and presence frequently. So that would be beneficial in that case to have that crossover alternate membership. That's why we wanted to provide that, because there was multiple options for the crossover dual membership that we had recommended when we were originally drafting the new policies and how these boards and commissions work. So, and obviously, so in option 2, Lisa Cholet and Tim Whitehouse would again provide a lot of that steady consistency when it comes to knowledge of codes, and also would be consistently available because they would already be at planning commission meetings, which could coordinate then with the Board of Adjustment meetings. So that's why we provided those 2 options. The 2 alternates on option 1 were Levi and Reg, and they both interviewed incredibly well and had a lot of time and commitment that they are ready to dedicate to our town. And it's very admirable to see that. And we are hoping that this would be a great step into serving the community as a volunteer. Our concern was, though, and I want to bring this up really and get their perspective on it if we have a moment to do that, is if they were to be determined as alternates in the Board of Adjustments, they would not be permitted to serve on any other board or committee within the town, because there are membership restrictions on this board and this planning commission. So if, for example, you were to accept this as alternates to the Board of Adjustments, and you were happy with serving that role, I think we would be lucky to have them. But if they were thinking that they would also like to look at other opportunities for volunteering on other Parks and Rec, Community Activities Commission, or others within the town, I would want them to know that they would be restricted from serving in that capacity if they were to accept these roles on the Board of Adjustments. So if this was I'm ready to get out there, I want to volunteer, fantastic, but it's not going to let you serve in that capacity necessarily, and you would rather pursue another opportunity where you may be able to have a more active role, I would love to know if they would have a preference. People who are ready and loving Wellington and want to participate, I would hate to stunt them right now as putting them as alternates on a board versus letting them be full-fledged members or have the opportunity to serve on another board openly. So that was the thing there. But again, amazing candidates. Thank you guys for your willingness to volunteer, and I appreciate you all very much.
I would like to hear from the applicants on their thoughts of crossover, overlap, anything of that on other boards. If you would like to speak, feel free.
Kathy White Dallas. I was not really against the overlap because the main reason that the attorney and the planning commission wanted to put the boards together, the planning commission and the Board of Adjustment, was because there weren't enough people applying for these boards. Since we obviously have more than enough people, there was 8 positions and 11 candidates or applicants. I think we should continue to keep them separate. I think there were some possibilities of, well, the one thing was, what if people said, you're on the board, the planning commission, and you're also on the Board of Adjustments, and can you really keep it straight? And yeah, I have a high opinion of people being able to keep things straight. You guys can work on the liquor board and be board of trustee members. But I think ideally, the best would be for them to remain separate. So as long as we can, I would suggest they remain separate. Thank you.
Thank you.
I guess I would like a concise answer to why that exception is made, that you can only serve on the Board of Adjustments and no other board. What is the rationale for that?
I'm happy to answer that. That provision came from a discussion of the Board of Trustees that took place, I want to say in August of last year, as we were discussing changes to the various boards and commissions. A lot of communities allow only overlap of those two boards. The idea is that we don't have one individual who's on a lot of different boards, but for the Planning Commission and the Board of Adjustments, an exception was made actually to allow participation on just that one other board. So it was intended actually to facilitate more or I'm explaining this poorly. Let me start over on that. I apologize. It came from the Board of Trustees in August. So before a lot of these changes, we allowed board members of different planning or different commissions or advisory boards to sit on a lot of different boards and wanted to reduce the amount of overlap generally to allow more participation by the community. So it wasn't just one member on many things. So actually the original direction was to allow no member of any of these advisory boards to sit on another one. But they decided that the discussion was that that wasn't maybe appropriate and they wanted those really involved people to be more involved. So with the Parks and Rec Advisory Board changes that came through, it actually said that members of that Parks and Rec could be, I believe, members on one other board, meaning that you could be on the Parks and Rec Board and also Community Activities Board if the board appointed them to those boards. However, Planning Commission and Board of Adjustments, the idea was potentially to merge those two. So they allowed overlap of just those two boards. So while other boards you could be on kind of bits and pieces, so you'd be on Parks and Rec and the Finance Committee potentially, if that's created in that way, we'll see how that's created. You could be on the Parks and Rec Board and Community Activities Commission, the Parks and Rec Board, and another one. Planning Commission and Board of Adjustment, the idea was actually to merge them in essentially. So only allowing overlap on the two and as an idea to have full membership of both boards. As I said, came from the Board of Trustees.
I mean, I
It made
guess
a lot of sense at the time.
That doesn't.
to put it in layman's terms, if we didn't have enough applicants, we could still cover both boards. But since we had a large outcome of applicants, it's not really necessary to have the overlap by any means.
What overlap are you speaking of now? I'm confused.
Okay, so you have the Board of Adjustments and then you have the Planning
Yes.
Commission.
Yes.
If there weren't enough applicants and we weren't able to fill all the seats of both, there would leave some vacancies on one or the other. And it would allow the individuals from one board to overlap to the other board since they don't often ever meet at the same time.
Okay, that wasn't my question. My question was why a Board of Adjustment person cannot participate in any other boards since it rarely meets, according to what you've all said. And I think most people that are on this are intelligent enough to catch up. What I've seen of what we're going to see next with the application for a zoning change, you guys put all the stuff in there. We look down through it, pretty easy to read. If I could, the problem I see, the way you set it up now is a member is going to be on the Planning Commission, and then he's also going to be, or she going to be on the Board of Adjustments. That's like, I don't know, like let's see, you go to the initial court and then you go to an appellate court and doggone, you're facing the same judges. That seems a conflict of interest.
The decisions of the Planning Commission are not appealed to the Board of Adjustment. So in terms of their role, they actually have a very different role. The Planning Commission's quasi-judicial hearings are, the second stage is they are make a recommendation to the Board of Trustees. The Board of Adjustment hears only variances and appeals from administrative decisions of town staff. So, and if they make a decision in their quasi-judicial role, that's only appealable to district court. So it's not at all like an appeals board for the Planning Commission.
Well, okay, so just so I understand it, okay, the Board of Adjustments then does not act on their own? They're subject to the Planning Commission?
No, the Board of Adjustment, in fact, has authority that is not appealable to any other town entity. So
Okay.
they are actually very separate. The planning commission, if they have a quasi judicial hearing, like I said, they make a recommendation to this board, but the
my-
Board of Adjustment makes a decision.
My point is though, that the boards aren't separate. They aren't entirely separate if you're going to have overlap. Is that,
If we were to choose option 2,
yeah,
that would be the case.
yeah. So I think that's not defensible in this situation.
Correct.
If you apply the same logic.
They would exist as separate entities, just like the Board of Trustees exists as the Board of Trustees and also sits as the Liquor Authority and also sits as the Wastewater Enterprise Governing Board. So they would maintain a separate, distinct status.
Yeah, but there you go. Yeah.
It's very defensible. and A lot of cities do. it.
Other people can, well, other people can be on other boards, but only the Board of Adjustment can't be on any other boards.
Well, I think that
Can
back,
somebody
way
tell
back
me
in
why?
last year, the issue is that we were having Board of Adjustment meetings and then business people would invest their time into coming to these Board of Adjustment meetings and then they couldn't have a quorum. And so we were looking for solutions to address the quorum issue, but in the circumstances that we have today, knowing that we have more applicants than we had seats filled, if that had been the situation a year ago, we would not have made that rule. So the idea is that if they were filling both the Board of Adjustments and the Planning Commission, we didn't want people to be overextended and trying to fill too many positions on too many boards. So we wanted them to be focused. Only if we thought that that was necessary to be able to have a successful quorum for the Board of Adjustments. However, the situation has evolved today to where I don't think that that's really an issue anymore.
Okay.
And it had been a discussion in the past, so we wanted to make sure that the option was still discussed this evening. But really, if the candidates are dedicated to making a quorum and the board feels like the selected pool of applicants fill the positions, then we don't have to move forward with option B. You're correct. It's irrelevant to today's situation.
And so why do you still restrict it that way then? Why not change that?
Well, that I think is certainly something that we need to bring up in that work session.
Yeah.
So we can't change it. We can't change that resolution tonight because those rules are set by,
I understand that,
but I do think that you're
logic
correct.
would dictate that no longer is a justifiable decision and is no longer needed. So you don't want to keep archaic things that are going to interfere with other people participating in the community.
I think it's absolutely one of those talking points that we can have with that work session that we're having about how we go about appointing these positions.
Yeah, I think most all of us are in agreement that we will be addressing these issues.
So Reg, it sounds like that you would be in favor of serving as an alternate then.
Yes, if that was true,
Okay, thank you.
Perfect.
but it's not true now. So I want some kind of assurance that, I can be on something else, because if I'm rarely on the Board of Adjustments, I think I can deal with that.
And, unfortunately, we couldn't offer that tonight.
Right.
Because that's not currently an action item, but we have heard you for sure, and that's something that we're committed to talking through. Yeah, but that's not something we can make as an assurance to say that you could serve on another with the Board of Adjustments as the resolution is now.
So I did want to address that. If there were to be an opening on the Planning Commission, you would be able to apply for that and sit on the Planning Commission, because as the resolution currently states, Board of Adjustments members are allowed to also serve on the Planning Commission. So if you wanted to serve on the Parks and Recs or CAC, that currently is not an option. And I think Trustee McDonald had a great idea. We discussed that. If maybe that's a change that needs to be made. But if you did want to serve on the Planning Commission, there was an additional seat that came open, you would have the option to put your name in and be considered for that seat, because the rules as they are today do allow you to serve on the Board of Adjustments and on the Planning Commission. So in that case, you could. Others depends on what the board decides at a later point.
Okay.
My answer is pretty short. I would serve it as an alternate.
Okay, thank you. Levi.
Thank you. I think that brings us back to board comment. Trustee Gator.
Yep, so my concerns would be the same, because again, my concerns are process related. So they would be the same concerns that I shared for the planning commission, and just that I don't wouldn't want to see that rushed through. But so I'm not going to rehash what I shared before, but same concerns. It's not about people, but it is about just the process that we need to go through on these boards.
This is my first meeting. I apologize that you're upset with how I'm running it. I did not get public comment, and I am going to get that right now.
I'm not upset, but why you have side conversations going on when Trustee Gator is speaking?
Because I realized I missed public comment.
Could I submit a point of order? So Mayor Shosse has, in typical fashion, he's gone to the Board of Trustees for comments and then to public comment. So we haven't actually had board comment on this all the way around. We heard from the interviewers and from the applicants. So you are actually still in order. But yes,
Okay.
Please remember public comment. But
Yes.
it's not out of order yet. We are still following the proper order.
Thank you. Trustee Kinney.
I would be in favor of proceeding with option one based on the from hearing from the candidates. That's what I wanted to make sure they were aware of that situation. So, but yeah, that's all I got.
Yeah, I'm also in favor of option one, and to have Levi and Reg both on there as alternates. They'll be brand new to the boards, and I think that'll be great to have them on there. So.
Trustee Dietz.
Thank you to the applicants. I don't have any more comment.
Trustee Wagon.
Appreciate the applicants. I think they are some fantastic people, and I love option one if we're going to be voting tonight. Thank you.
Mayor Pro Tem.
No further comment.
Perfect. Public comment is now open.
I'm Karen Eifert, live in the Knolls, and I would just like to point out that every single vote so far from last week to this week has been a 4-3 vote. And I really hope that that stops. I really hope that you each take the time to consider your votes before they're made. And honestly, I don't want to see the board run by 4 people because they have the majority and every decision to be made by those 4 people. We have a board of 7 for a reason. I've said that before. I'm gonna say it again. We have a board of 7, not a board of 4. Not a board of, hey, these guys I get along with, these guys I want to vote with. It's not about that. It's about the town of Wellington. So I really hope to each and every single one of you, don't vote 4-3 majority, but just the people that you like and that you respect and that you want to hear from. That goes for every single one of you on this board. That's it. Thank you.
Thank you.
Hi again, Lisa Cholet. I live 7424 Homestretch Drive. Public comment, as someone who is on one of the options and as someone who wanted for a really long time to be able to get involved in the town, my public comment would be to go with option one. I would like to see more people be able to get involved. I think a diversity of opinions is important. And I know you all haven't agreed on everything. It's only been a week. You'll get there. And I believe that. I believe in each and every one of you. So just continue to try to do the right thing. And again, go with option one. I will accept option two, but I would prefer you do option one.
All right, with no further comment, let's bring it back to the board for final comments. Trustee Gator.
No final comments. Thank you, Mayor.
I have none, thanks.
Trustee Wagon. Wiegand.
No, thank you. No comments.
Mayor Pro Tem.
No.
My final comment is, yeah, it's been rough up here. Bring it together. I really am. And you got to trust me. You got to give me time. You got to give us all time. We have our workshop coming up this coming weekend. And that's where we're really going to build our relationships and start to get together. We are here for the citizens. Every single one of us is up here for the citizens. You may not believe that right now, but I can tell you that I am, and I'm a man of my word. And that may mean nothing to you right now, but it does mean something. And I'm going to prove it. I'm working hard up here, and I'm doing the best that I can. And the board up here is doing the exact same thing. Every single one of us, we're in a rough situation right now. Just switched over, and we're going to grow together, and we're going to come together. On top of that, all the applicants, I just want to say thank you to each and every one of you for going through this process. That's incredible. For you to want to serve and for us to sit up here and listen to you and listen to your drive of wanting to have this community with your 2 daughters. That's incredible. You want to have this community be something great for them. We're all there right with you. Thank you to every single one of you that's here. I couldn't be more appreciative, and this has been a process, so I understand that. Further than that, I have no further comments. I would like to seek for a motion.
I'll make a motion that we approve resolution number 18, 2022, a resolution of the Board of Trustees making appointments to the Board of Adjustments for Kathy Dallas, Wyatt Knudsen, Levi Glue, thank you, and Reginald, thank you. Westfall, thank you.
Second.
Can I get a roll call?
Trustee Gator,
No.
Yes.
Mason,
Yes.
trustee Teets. No. Trustee Wiegand,
Yes.
Mayor Pro Tem McDonald,
Yes.
Mayor Shosse.
Yes.
Mayor, I ask for a brief recess.
I would second that.
5-minute recess, please.
Thank you.
We'll re-adjourn at 9:10.
I'm going to resume the meeting, 9/12/4/26/2022. Brings us to our next item. We now have a public hearing for a zone change request from C1 Community Commercial District to C3 Highway Commercial District at the northwest corner of Jefferson Avenue Street. We will hear a presentation from Mr. Byrd, and then we will open it up to a public hearing.
Thanks, Mayor Shosse.
There's a hand raised from trustee Weekend.
Do I recuse myself now or when? What's the problem?
Yeah, now.
Okay, thank you.
Proceed.
Just again, quick introduction, Cody Byrd, Planning Director. Is a nice introduction. This request tonight is a public hearing item for a rezone request at the northwest corner of Jefferson Avenue and 6th Street. The property is two parcels being considered as one development parcel, and it's approximately 1.29 acres in size. The request from the applicant is to change the zoning district from the current C1 Community Commercial Zone District to C3 Highway Commercial Zone District to allow for a higher intensity level of uses on the property. Just real quick to point out, this is the first of two action items that are kind of paired. The first action item is a public hearing item. After the close of the public hearing, the board has a second item following this that is the actual action on the rezone request. So just want to point out that those are two separate things. The time for public comments is during the public hearing portion, this first item. I also want to point out that the public hearing for a zone change request is a quasi judicial proceeding. You had the benefit of hearing from Sursa tonight in a work session with some information on public hearings and quasi judicial proceedings. This is one of those situations. I've also included in your agenda packet a procedure or an outline of the meeting procedures for a public hearing. Hope you've taken a look at that. It's page 45 if you need to reference that, if you want to follow along. Just to give you a quick overview of that process, and for those that may not have the packet in front of them, the process consists of an introduction from staff, or I'm sorry, it starts with disclosure of conflicts of interest, which Trustee Wiegand did remove himself, not for a conflict of interest, but because he's not here, not to be able to participate in the in-person meeting. But if there are any conflicts of interest on this particular item, you would need to recuse yourself per the recommendations of Saoirse that you heard tonight and for our normal procedures. There's also a step called disclosure of ex parte communications. Ex parte communications are communications or information that you've received or heard outside of a public meeting. And the reason you disclose ex parte communications is so that in the public hearing item, all the board members have all the same information to consider when making your deliberations and making your judgment on the quasi judicial proceeding known. To disclose ex parte communications, a statement of, I heard from so-and-so, their comment was generally this, or I did some additional research, I found this. Just, it's a means of sharing the information so everyone has access to the same knowledge. Following conflicts of interest in ex parte communications, I'll provide a brief introduction specific to the case. Then there's an opportunity for the applicant to provide additional information. I believe the applicant is attending via the Zoom call tonight, so they can be promoted to a panelist in a few moments. And then following the applicant's comments, if the board has any general questions about the information presented, that'd be a good time to ask it. It's not deliberations, it's just clarifications. You know, Mr. Bird, you said this, what did that mean? What does the code say? Questions of a general nature. Following any questions, Mayor Stossel will open the public hearing and you'll receive public testimony on the rezone application. Following the close of the public hearing or the public comment portion of that, the applicant will have an opportunity to respond to any comments that they heard. Staff will have an opportunity to respond to any comments. It's kind of the closing statements from the applicant and staff. And following the closing statements from the applicant and staff, the board would then close the public hearing. Your next agenda item is the action where you can deliberate on the item and make your decision and make your recommendation. Any questions on the general meeting procedures or public hearing procedures? Excellent. Well, thank you for bearing with me as we go over that procedure. So I'd recommend starting with disclosure of any conflicts of interest. If you have a conflict, you can simply state that, the nature of it, and recuse yourself from the meeting. Okay. I would encourage you to disclose any ex parte communications. If you've received any information outside of the public hearing, you can state that at this time.
I was notified that we would be.
Mike.
Oh, sorry. So I was notified that we are at risk of being sued if we don't move this along. So that was one comment that I was told or I heard. And the other is I did have some residents reach out to me and say that they'd like to not have this pass. And I think that's, again, I've stated that that is a board decision and not a single person's decision.
I also have heard the exact same thing.
I don't know if this is considered ex parte, but I wanted to list it anyway. I've received the same content as part of the Planning Commission previously. Given that it is the same content as in this packet, I do not believe that will have any impact on my choices outside of this impacting this public hearing.
Thank you. We've made some notes on that and we'll make that part of the record. So appreciate that. The next portion is an introduction. So I'd like to highlight a few things. As we mentioned, the location of the property that's requesting the zone change is at the northwest corner of Jefferson Avenue and 6th Street. There's a location map in your agenda packet that highlights in yellow the perimeter of the property. As I mentioned, it's about 1.29 acres in size. And the request is to change the zoning from C1 community commercial to C3 highway commercial. There's also a zoning map showing the existing zoning of the property and the properties surrounding it with some labels so you can see what the existing zoning around the property is. The applicant has requested the C3 highway commercial zoning to allow a higher intensity uses on the property. That was the statement on their application. So that is their request. Leading up to a public hearing, the town provides public notices. The Planning Commission public hearing and the Board of Trustees public hearing were advertised by publishing an article in the Fort Collins Coloradoan. The property was posted with a sign indicating the dates and times for the public hearing, and letters were sent to the adjacent and surrounding properties within 300 feet in accordance with our code at that time. So notices have been provided according to state law and the town codes. The Planning Commission did conduct their public hearing on April 4th. The Planning Commission considered the materials that are included in your agenda packet. For the Board of Trustees, I included the full Planning Commission staff report that was provided to the Planning Commission, so you have all the same information the Planning Commission did. In that staff report, it includes 10 findings of fact. Those are the factors that were evaluated and weighed by the Planning Commission in making their recommendation to the Board of Trustees. Again, those factors are identified in your staff report, so you can see what those were included. Following the Planning Commission's public hearing and allowing public comment, weighing those factors, the Planning Commission voted unanimously to forward a recommendation to retain the existing C1 community commercial zoning for this property. In your staff report is included on page 57. It's the Planning Commission's findings and their recommendation. It's a one-pager. And I wanted to just quickly highlight the recommendation from the Planning Commission so that those that may not have the packet in front of them can hear what that recommendation was. The commission did recommend to retain the existing C1 community commercial zoning. The specific findings of fact the Planning Commission cited as weighing on that decision included safety and access at the intersections would be negatively impacted if the higher intensity C3 highway commercial district zoning is allowed. The uses allowed in the C3 highway commercial district zoning, such as fast food drive-throughs and gasoline stations, are not appropriate for the location. That the increased impact of higher volume traffic counts on local streets would be a factor. That the development of the property would be beneficial to address identified utility, street, and drainage infrastructure needs on or adjacent to the property. That the surrounding area has existing residential uses that need to be protected, including recently approved attached single-family townhomes and second-floor residential lofts within the C1 community commercial district. That finding that buffering, setbacks, screening, and other typical zoning requirements would be ineffective in mitigating impacts of increased traffic adjacent to residential properties in the area. And finally, a finding that the consistency of zone districts along 6th Street north of Jefferson Avenue, and that there's a consistency of development approvals within the existing zone districts along 6th Street. So those were the specific findings that the Planning Commission based their recommendation on when forwarding their recommendation to retain the C1 zoning. At this time, if there was any questions, and again, all this information is in your agenda packet. So if there's any questions on what I just presented, the Planning Commission's recommendation, or what I've presented, just let me know. I'm happy to answer those now or after the applicant has an opportunity to speak. And if we could, the applicant is John Diet, if he's on the call to, okay, I can't see it if he is. Mr. Diet, if you're on the call and wish to present anything, we can't quite hear you.
This is John Diet. You hear me?
Yes, we can.
Well, my name is John Diet. I'm the applicant today. We were pursuing the rezoning, as you know, from C1 to C3. I don't know if there's much point in going through the presentation. I think that decisions have already been made. I had initial chat with Cody a couple times about the property itself. He doesn't mention anything, any problems with the property. He doesn't discuss these things until he waits to the public hearing. And then he goes on a long list of issues with the property. So there's really no point. I've already heard other people speaking today about the dysfunction, corruption, whatever else is going on in town. So I don't really know what the point is in me going through it, but we certainly, we're not doing a fast food restaurant. We're not doing a gas station. We're doing a retail cannabis store at this site. And I think I'm not welcome in your town, and that's fine, but we're not welcome to do a cannabis store.
Are you still there?
Lips are moving.
That cannabis.
Check
was
your
even permitted in
microphone. We
town.
can't hear you.
You can't hear me right now?
Yep, good.
So the land itself has adjacent property that's C3 zoning. We're not doing a gas station at this site. Everyone keeps talking about gas stations and semi trucks. We're not doing a gas station at the site, and I'm going on record saying that right now. We're not doing a fast food restaurant. I'm not in the McDonald's business. We're doing a retail store. Now, no one said anything about traffic counts. I could have easily produced and still can a traffic study on this site that would show minimal impact. I have, I do these all day I do this. I have many engineers on board that have done all our traffic studies. I could pop out a traffic study that would prove that it would not make an impact, a negative impact to the surrounding area. What else are you going to do with this land then? So a simple retail store can't operate there. You want a lemonade stand with a 9-year-old selling lemonade? What else do you want to put on this piece of a parcel here then? This piece of property? If a retail store can't go here, then what can go here? Stop talking about gas stations and fast food. I'm not proposing a restaurant, not proposing gas stations. There's not going to be semi trucks sitting around. I'm definitely irritated because Cody could have just been honest and transparent. And this has been one of the most dishonest people that I've dealt with so far of any community. I don't have problems with communities typically. We have transparent discussions, but obviously, I mean, look at all the people that have voiced in all their concerns today. I don't even have to elaborate. Just
Lost you again. Want to check your mic? Still cannot hear you.
Connection is fine.
Our internet connection's fine. Maybe you should check your internet connection. See what's going on your side of things. He removed himself. I guess we'll give him. Okay.
If he's listening, he could call in.
If you're listening, you can call in. I'm about to recite a number for you.
He's not on currently.
Oh, he's not. Okay.
Then it might, I'm sorry, go ahead.
We might want to give him a couple minutes to try and reconnect.
Yeah.
Before we move on, just.
Yeah.
To make sure this
Want to give
process
him
works
2 minutes, 3 minutes, public comment time? No, I'm gonna give him 3 minutes to possibly reconnect. Does anybody have some music they want to play?
You should get the Jeopardy thing and like nip it down. And those your 3 minutes you wanted. Right.
No, thank you.
I'll grab.
Thank you.
Are we having fun yet? Zoom and in person.
He's getting promoted to panelist, so he should be able to speak again. Mr. Diet, if you are on, you are allowed to speak now. You should have the permissions on your computer.
Hello? Can everyone hear me?
Yes.
Hello, can you hear me?
Yes.
All right, thank you. I was disconnected there. What a coincidence. What I was saying was, before I was cut off there by who knows what happened, that there's no reason that this parcel should not be allowed to be converted to C3 zoning. Y'all allowed, cannabis has been approved in your town, and you're not allowing any parcels to be C3 zoning. So basically, you've been able to effectively block anyone from operating a cannabis store in your town. And you can sell it to yourself or look in the mirror or whatever you want to do. And Cody has this beautiful presentation that he made that he wants to convince himself and everyone of all the reasons. He certainly didn't utter any of that. I wish you heard his tone when we had our dialogue about the property. I had a couple options to pursue. We went with this one because Cody had the least amount of issues with this property. And then, of course, magically, when we get to the public hearing, all of a sudden, you heard the whole laundry list that he's got. He talked for 20 minutes last time about all the issues with the property. He never said any of this to us when we had the meeting. So I don't know, it's definitely despicable behavior. Was it on purpose? Is it incompetence? I don't know. Maybe it's genuine. I understand your town is going through some changes. I'm normally have much more of a sympathetic tone to that, and I have sympathy and understanding for that. But it is disgraceful to allow for cannabis businesses to operate in your town and then to have deliberate movement from the town government staff members to block us from conducting business in town. Just tell us up front. I have a family. I have people that I'd rather not be wasting my time with here. I could have been doing other things. So yeah, there isn't a risk of lawsuit, as someone said earlier. There's a guarantee of lawsuit. There's a promise of a lawsuit. That's what there is. So you're effectively blocking us. The will of the people, narrow vote as it may be, but the will of the people was to allow cannabis stores into your town. We're trying to convert a C1 to a C3 zoning with adjacent parcels sharing the same zoning. And it's not a gas station, and it's not there's no semi trucks that are going to be piled up. We'll even go on record. We don't even allow semis into our plaza. There's no fast food restaurants. It's a retail store. So if a retail store can't operate there, you tell me what you want there then. If this is Nazi Germany that you pick and decide who goes where, how many ice cream stores are in town, how many real estate agents there are, where they all go. If you want to sit and decide where all of us can operate, if this is how anti-business you are, then I guess so be it. But this is completely ridiculous that we can't, when Cody, with all the facts that he's put through, yes, there will be a lawsuit. You can bet that, and it'll be an aggressive one. We should be able to convert this property from C1 to C3 zoning. There's no reason why it shouldn't be able to be approved to be over a C3 zoning. There's no reason for that. There's nothing else I have to say.
Mr. Byrd, would you please share again what the concerns were again from the Planning Commission?
Would you like the findings read again?
Yes, please.
Certainly. The Planning Commission's recommendation was to retain the existing C1 community commercial zoning based on the findings of fact, including safety and access at the intersections would be negatively impacted if the higher intensity C3 highway commercial district zoning is allowed. Uses allowed in the C3 highway commercial district zoning, such as fast food drive-throughs and gasoline stations, are not appropriate for the location. A finding that there would be increased impact of higher volume traffic counts on local streets, that the development of the property would be beneficial to address identified utility, street, and drainage infrastructure needs on or adjacent to the property, that the surrounding area has existing residential uses that need to be protected, including recently approved attached single-family townhomes and second-floor residential lofts within the C1 community commercial district. A finding that the buffering, setback, and screening and other typical zoning requirements would be ineffective in mitigating impacts of increased traffic adjacent to residential properties in the area. And a finding that there was consistency of zoning districts along 6th Street north of Jefferson Avenue and consistency of development approvals within existing zoning districts along 6th Street.
Do we know how many C3 areas we have zoned over in that area, say within a mile of that?
Yeah, I don't have a count for the number of properties, but the zoning map is on the wall here. And then a smaller inset was in the agenda packet. But generally, the properties on the east side of 6th Street, north of Jefferson, are zoned C3 highway commercial. And along the frontage road, south of Jefferson, are zoned C3.
So we have a large amount. Are we hitting an issue where what's blocking this from going in a different location than the location?
Let me answer
he's
that.
looking at now?
Can I answer that? Can you still hear me?
Yes.
Okay, sorry to interrupt. I just want to save you all time too, because I understand you're sitting here at nighttime, listening to everyone's problems late at night. Y'all want to go home, so I want to be respectful of that too. So just so y'all are aware, forget about me for a minute. There are no options in all of Wellington to put a retail cannabis store, period. There are no other options. There are none. There was one other option, which I had it under contract. What is it, 7840, 7860? Cody, you know it. You've had it there. I was directed to this property over that one because that one had more issues than this one, according to Cody. So I'm interested to watch that public hearing coming up because I think that they're going to be pursuing a cannabis license there. So it's going to be interesting to see if that one actually gets approved and I don't. Whereas the list that Cody gave me, which I have documented, was significantly longer than the almost zero issues that he had with this one. But to answer your question, there are no other properties because they all fall into buffers. I could provide you with a map that shows all of Wellington blacked out, that this is the only site that even allows for retail cannabis. So you're going against the will of the voters there. Look, I didn't have to do this. I have other things I could be doing. I have a dozen of these stores. I could be working in other markets that I would have been a sure thing, use by right, no games, no beauty contests like this. I didn't have to do this, but we had the discussions with Cody. The town voted for it. You got to allow it somewhere. You're facing a general lawsuit from everybody if you block it everywhere. I know other people that will get in on that. I only need one party to make it class action. I've got 4. We don't need all the town blocked out. We already have a qualified site here. There is no other. So let's not talk about, oh, there's 5 other properties that he could be doing this at, just if that's where you're going with this, because there are zero other options. So you are effectively, by denying me this C3 zoning, you are effectively blocking the will of the voters to allow retail cannabis stores. Now, I'm not doing grows. I'm not doing cultivation. I have the most robust security system possible. I have the most robust odor mitigation system possible. You're going to get 0 odors. You're going to get zero complaints. Retail stores don't create issues in the community. It's always the cultivation or manufacturing that creates any issues whatsoever. This is that we can mitigate traffic. Cody talks about safety and access. We can easily have safety and access in there. You can have deceleration lane in there. You can have proper egress, ingress. We can have the traffic study produced. Access is not a problem. Safety is not a problem. We're just adding, we're talking about the sky is blue is another reason why this can't go through. I mean, that broad compatibility surrounding use stuff, you know, I've heard it a million times. I do special use. I've done 3 special use permits in the last few weeks. I do this around the clock. This is all I do with my life. Yeah, there will be a lawsuit, guys, and it's nothing personal, but I'm going absolutely to town on this one. Absolutely to town. There's so many holes in this. I've never seen a community that has had so much room for a lawsuit, to be honest with you. I've seen so much
One
more
second, Mr.
tonight.
Beeth. Before we keep going, I apologize for interrupting, but I just want to
fine.
kind of bring it back and to some of those, the findings from the planning commission, because I just want to get a little bit more information about that. I hear your concerns. I hear that you feel like this process has been unjust. I hear your frustration with the process and with the red tape that you feel like has been put in front of all of this. So I apologize again for being disrespectful and interrupting.
No, you're
but I
fine.
do
You're
want to
fine.
recognize that it is getting late, and I want to ask a question relative to one of those findings. Is that okay, real quick?
Sure. Yep,
I
absolutely.
was wondering if Mr. Byrd or maybe one of the planning commission members could share the context behind the public safety issue. So is it just a high traffic count? We're concerned about the number of vehicles coming and going and that it's going to jam it up. I mean, I'm just asking for a little more context behind that specific finding.
What I heard from the planning commission was, in addition to their findings, a lot of the conversation and discussion was the potential for traffic coming off the highway, which is what C3 zoning is intended to support, is automobile traffic from the highway. It's stated in the zoning district, which is included in your packet, that highway traffic coming from I-25 down southbound 6th Street would then want to go back to the highway, making left-hand turns where there's inadequate turn lanes from Speta. Speta is the street that's adjacent to the property. It's north of Jefferson. That left turn going back and the inadequacy of turn lanes, turn improvements, and the volume of traffic wanting to get back to the highway against the flow of traffic was a factor that weighed heavily on the planning commission in writing those findings.
But that you could do right turn only. I've done it before. You do a pork chop right there. My engineers have designed 5 of them before. You do right turn only right there if you had to. That would be another option.
Cody, was there a traffic study done for this at all from us or from the petitioner?
No, there's not a traffic study done for
Got it.
this.
And that may not have been requested of the applicant.
It was not requested. That's correct.
A zone change request to consider what uses are allowed on the property within the zone districts does not require a traffic impact study.
Everything that Cody said from the planning commission, though, is based around what you would classify or what you were expecting from a C3 zoning of gas stations and fast food restaurants. So what can go there then? So yeah, anything that gets built there involves cars turning in and turning out. I think we can all agree on that. So what can go there then? Do you only want a barber shop to go there? Do you have a list of certain retail that you want there, that this is how America is, that we sit and we go through lollipop stands are okay, cannabis is not? I mean, what are we doing here? I mean, yes, whatever gets built there, cars are going to have to go in and out. So the question you should ask yourself is, do you want that land to sit there forever and nothing ever get built there? Because everyone that builds anything there, you're going to have the same stuff, guys. It's going to be, yes, cars are going to turn in and out. That's what they do for businesses. Yes, you can mitigate that if you had a desire to do that, but obviously you don't, or at least some of you don't, or at least Cody doesn't. I don't know who, but obviously there isn't an ounce of energy going into trying to mitigate these things. It's just shut this guy down. That's what it is. It's block cannabis from operating here. Anything could operate there.
Apologies real quick. Point of order. Where are we at in the public hearing process? Are we in the discussion portion right now from the board?
No, we're not even at the board discussion yet.
Okay, I maybe, I don't want to be out of line, but I do maybe want to ask if there are any other final comments from the applicant so that we can take those down. We're going over a lot of the similar items over and over again. I'd love to get, so we can move on to the public hearing, so we can hear from people waiting here.
I'll just conclude with, there is this meets with all the buffer setbacks of what the town is putting forth for retail cannabis stores. There aren't any other options. The surrounding residential is not an issue. It does meet the setbacks to residential. There are no drive-throughs. There are no gas stations. There are no fast food restaurants going here. It's standalone retail. And we could easily mitigate any safety or access issues for the property. And that's egress, ingress, everything that Cody described is easily mitigatable. But we don't want to do that because we don't want me in town to do business.
Thank you for those comments. Can we move to the next section? Thank you for your feedback.
Yes. Are there any questions from the trustees or staff? Thank you, Mr. Byrd, Mr. Dean.
I do want to make some clarifications for the item in front of us, just so we're very clear, because there's been a lot of conversation already so far. Is the item in front of us is a rezone request. It doesn't have a specific use for a specific for that use in mind. It is specifically for C1 to C3 for that land use. And the reasons I wanted to bring that up is that's the pertinence of some of the attachments that I've noticed and read in the packet. And those include permitted uses in C1 and C3. So although I know that there is a motive and specific interest by this applicant, given the item in front of us, we need to consider the entire zone district. Those are listed on page 48 and 49 for C1 and 50 and 52, 53 for C3. So there's been some concerns that gas stations and things have come up. So if and when zoning changes from one to the other, every permitted use in that zone is now a permitted use. So there would be no second questions to gas station. There would be no second questions to any of these additional uses that would be available in C3 above and beyond what would be available in C1. So, and I understand the passion and the motive and the reason why this change is being requested, but I do want to make sure that we are focused on the specific item at hand, and that is a zoning request from C1 to C3. If anybody has questions on what that entails, those permitted uses have been provided in our packet on those pages.
Thank you, Trustee Kenny. Trustee Gator.
So I will have some more questions later. I know one of the items that's on here with the application is the feedback from the neighbors and residents as something we need to consider. So I would like to hear with that. I do have some questions about the safety and traffic, but I think it would be better to potentially address those later.
Thank you. Trustee Dietz.
So in looking at the zoning and land use code and debating on, I see C1 transitional, C2, C1, C2. I'm not really seeing C3 district around where this is impacted other than Ridley's. So I see it on the other side of the interstate, which if you're looking at the map can look confusing at first, because you don't realize that that is an interstate unless you're around this area. As far as zoning, where are we on assigning zoning to different areas in planning commission?
I think that is a great question, but it's not applicable to this action item right now. So, because the only thing we can work in is our existing zoning map as what's presented in front of you.
Right, but we have a transitional in there that the zoning will change right next to it, correct?
Yeah, but that property is not in question for this public hearing. I don't want to confuse anybody as to what we're discussing right now, and it is only the property that's outlined in yellow. We're not talking about any other property, and it has to be the property of its existing zoning, which is C1 currently.
Any further comment?
No.
Trustee. oh, No, he's gone. Mayor Pro Tem McDonald?
No.
Yeah, I mean, I'll say comment wise, doesn't seem to fit in that location based off of everything that came back to us from the planning commission, in my personal opinion. Oh, questions. Okay. Question I would have is, I don't have any questions.
Mayor Shosse, if I may, having heard some of the questions and answered a couple of those, some maybe need to be answered later. It would be a good time to move into your public comment portion of the procedures at this point.
Thank you.
Thank you.
At this time, are there any comments from the public regarding this agenda item?
Well, having heard his recording over and over and over again, I don't know how many of you guys shop at Ridley's, but you try to get out of that intersection and go north. I mean, you can't see beyond there. That is stinking dangerous. And he's talking about doing a study of traffic now. Well, what about a year from now? It's not going to get any less. It's going to get worse. I couldn't believe that that somebody even asked to get something in that location for that. And you know as well as I do, at least what I've seen in Chaffey County, if we open up a store here for marijuana, there's going to be a traffic from Cheyenne and from Wyoming like you've never believed could happen. And I know that because what the police in Laramie, where I have friends, they got problems with that already. They can't hardly stop it. And we're right on the interstate, man. It's gonna be a traffic mess like you never saw at that intersection there on 6th and Cleveland. So he's talking through his hat. I mean, I just think I think the planning commission made the exact right decision.
Thank you for your comment, Rich.
I'd have to agree with Reg. One question I had, where's the exit? What side? Where's the actual exit?
For the interstate, or Cody, I guess clarify which exit you're asking
Oh,
about?
the exit for the facility that would be in question.
We don't know that yet because
Okay.
this is just zoning.
This is just where then they could make plans, so we don't have those yet.
Okay.
Excuse me. Go ahead. During the public comment portion, I'll make a note of any questions that come up and I can speak to those in closing remarks, but I'd encourage you to go through your public comments and we'll make notes of any questions.
Thank you, Cody.
I guess my thoughts on it would be, depending on what side of that property it comes out on, when you exit onto the frontage road, especially like at nighttime, it's hard to discern like what's I-25 traffic and what is the frontage road traffic. You can't tell sometimes. Like I've done it myself. Like you pull out and you accidentally pull out in front of somebody. You can't tell the difference. So with the amount of traffic that would increase from definitely Wyoming, I mean, they've got, I'm sorry, partial, but there's enough on North College that another 15, 20 minutes isn't going to hurt. I know we passed it, but as far as like, if you're going to place it in town, and if this is the only place that was deemed necessary, then we just don't have the room yet. That's all I have.
Thank you.
Karen, I live in the Knolls. I just wanted to say that I attended that planning commission meeting, and I have to say it's one of the first and very few meetings where I saw the board come together and consider all of these things. I don't know what they're called, the impacts and all of those things and the setbacks and all of those. And during that meeting, I was actually really super proud of that planning commission, that they worked together as a board. They asked the appropriate questions. They let the public comment. And they looked at all of the knowledge that Cody Bird had shared during that time about this location, moving from C1 to C3 and how that would affect our town, and it would affect the traffic and lots of other things. But I also would like to say that as each of you campaigned on your trail, I remember a lot of you saying, hey, with this passed, it might have passed by one vote, but it passed. And so I heard almost each one of you say, okay, it passed, so we have to figure out a place for it that is appropriate and have it, I guess, kind of zoned or whatever for that business. And I heard each one of you have a commitment to look for that area and to help that happen in a judicial manner, I guess I should say. And I'd also like to say that, what's the man's name?
John D.
John
Diet.
John, John, you know who you are. I would encourage you to come back to the Planning Commission with other locations and bring up other locations to the planning board and to work with the planning board. I'm sorry, is that way? Planning Commission, thank you. To work with the Planning Commission on another area. And if you feel that you've been having a hard time with that, we have 7 people on our board you can reach out to and ask for help so that you can maybe understand. And then our Planning Commission, you're also able to reach out to them and talk about other locations as well. And whether we like it or not, it did pass. And I've seen this board and I've seen the Planning Commission board doing their best that they can to make sure that it's going to be in an area that will not be, that would be the least impacted for our town and for our residents. So John, if you're out there, I think you should reapply and try different locations. This is not the only location in Wellington. It's not the end all be all. Please come back and reapply. Thank you.
Thank you, Karen.
Yeah, can I say something?
Yeah, nope, not at this moment.
Whenever my turn is, I'd like to speak, please.
Yes, sir.
Kathy White Alice, I live in Viewpoint, and I'd just like to go back to what Trustee Kinney said. This is just, it really doesn't matter what is in the plans right now to be built. If those plans fall through for some other reason, we have an area now that we would be saying, oh, you can have a gas station there. So I thought that was a really good point.
Thank you, Kathy.
Hello, Jesse Andreen from the Harvest Village neighborhood. I'm in agreement. I think that location is not a safe location based on traffic, but also based on how close it is to residential areas. I would imagine we would need a stoplight right there if it were to go in. So that's my thoughts.
Thank you.
Rick Freeman, 7425 Viewpoint Drive in Wellington. A couple things real quick. My main concern is increased traffic on and off of the interstate, and that we do not have adequate bridging right now, and we can't control that because we don't own the access. The other thing is there is a potential for another business there. Right next door is a chiropractor that does have long-term plans, did have long-term plans on making that a building very exactly like he has now, which has minimal impact, very little traffic, but there are other uses for that, even in C1.
Thanks, Rick.
Stiff, sitting back here. Mayor, members of the board, my name is Tom Donnelly. I'm here on behalf of an adjacent property owner at 7846th Street. A couple points. I think Trustee Kenny has done an excellent job of really laying out the issues with this rezoning request. But just maybe 2 examples. One, if you see the industrial zoned piece of ground up here, there would be no reason somebody couldn't request that property be zoned C3 commercial corridor, except that smacks of spot zoning, which is actually illegal in Colorado. I'm not suggesting that this applicant is outside of his right to ask for this rezoning request, but at the same time, the onus is certainly on him to prove that that it's deserving. And you've heard testimony. Well, I went to the planning commission meeting, and trustee was serving on the planning commission at that time. We heard concerns from a number of citizens, a number of property owners adjacent to that property, that the impacts were significant, could potentially be significant if the zoning change were allowed. And so a planning commission meeting is really where the public hearing is held. That's where your planning commission works through the issues that are presented by the applicant, by the citizens. You bring it all together and you try to craft something that actually will work, that will be viable. So then when it comes to you guys, hopefully it's in a condition where it's fairly innocuous, and you can say, yeah, this looks like good work. Here's what happened at your planning commission. After the applicants made their presentation, the public came up and spoke. The applicants actually didn't even respond to the comments from the citizens of this community. That's a very basic thing that they could do. That would have given the planning commission an opportunity to hear some of the things that maybe this gentleman is so offended about. Maybe they could have been an opportunity to work through some of those issues. That didn't occur. It was a total breakdown in public process, and it was 100%, in my opinion, the fault of the applicant. You're well within your rights to deny this application, as well you should, because the applicant didn't even do the bare minimum that they could have done in presenting a reasonable and responsible application for this rezoning. I hope you'll meet your charge here, and I hope you'll vote against this rezoning request. Thanks.
Thanks, Tom.
Mayor Shosse,
Yeah.
if you're looking for guidance, if there's no further public comments, the next step would be to allow the applicant an opportunity to respond.
Perfect. John, are you still there?
I'm still here. Yep. I'll be quick. Let me just respond to this clown that was just speaking a minute ago here about 7860. He says that it's on the applicant because we didn't respond. Look, I've done this a million times. When I sit there and hear the laundry list from Cody, we're not going to waste our breath on sitting here when we know that the town's already made our mind up. I'm only on here today for a formality because I need to be. I already know that you're not going to approve it today. But this guy wants to sit there. And second of all, this guy, he's competition. He knows as well as I know that there's an application coming through on that site soon. So everything that he says, of course, he wants you to deny it because his interest, he gets his commission when you approve the one at 7840, 7860, whatever that one is that he just represented. So this guy, yeah, he wants to say it's my fault for not responding. Look, I'm not going to sit here. What's the point in responding on the last hearing when we can understand that no one's going to approve it? Clearly, with what Cody said from the planning commission, that it wasn't going to happen. So there's no point in responding to that. Also, if the chiropractor next door, I hear this kind of song and dance from people from time to time. Oh, this guy was going to do something there. Well, why is it that we put it under contract then? Why didn't the chiropractor buy it if he's going to do it? What dream is he going to be doing this in then? What year is that going to happen? It's not happening this year. He didn't put it under contract. So this is all, hearsay that someone wants to put an ice cream store there or a chiropractor store there. And then someone else mentioned about why don't you get another location? I mean, that's just fluff. That's pure fluff. There are no other locations. It's not possible to put it anywhere else. And so basically the summary is, and I can read the writing on the wall, none of you want the marijuana stores unless it's in the middle of a cow field or somewhere else. You don't want the traffic coming to Wellington. And I get it. And that's a characteristic that you enjoy about Wellington is that there isn't all the traffic coming to town. And you don't want traffic coming to town. So you don't want a marijuana store there. You want it in the middle of a cow field, possibly, I don't know. There's nothing else to be said, really. I'm just on here as a formality before we pursue with the lawsuit. Thank you.
Thank you. With that, let's bring it back to the board for any final comments. Oh.
Sorry, I was making some final notes. Cody Bird, Planning Director. I wanted to go back through some of the comments and take an opportunity to respond to some of those. There were a couple questions and a couple comments I feel are worth making a note on. One of the trustees had commented about the uses allowed in C3 that's being requested tonight. And I think the reference was made that those existing uses in the C1 and the C3 that are allowed in our zoning code are included in your packet, and that's true. The comment was also that when you're considering zoning for a property, you have to consider all of the uses that are being considered as part of that request, and that's also true. One of the things that you look at for zoning is what is the right use for that piece of property? What's the right use for that dirt? To the extent that Mr. Diet, the applicant, it made clear his indication what is proposed for the site that was not included in the application materials. And so staff did not include that information in the Planning Commission report because the Planning Commission and this board considers what is the proper use of the land that zoning allows. So that's new information being provided to the board.
No, you chose to admit it. You had it.
Excuse me, sir. Can I allow Cody to have the floor here?
He's lying. He's flat out lying. It's in your inbox.
And respectfully, the information that the applicant is providing tonight is new to the Planning Commission and the board because that information was not shared via.
It was
any
shared
other
repeatedly. You are a liar. You are a liar, Cody. You are a liar.
The other comments that were made, there were several comments made regarding traffic and the impacts to that. There was a question that came up regarding where would the exit be from the proposed development. And the answer to that question is zoning, you're considering the use of the land. You're not considering what would be a site plan review that goes to the Planning Commission at a later date that would look at traffic, turn movements, accesses, things of that nature. So the request for a zone change is looking at the uses allowed on the property and the access point is not yet known to be part of a development proposal. There was a comment about considering other locations. I know that this applicant looked at other locations. There were a number of challenges to each of the locations that were proposed. The applicant chose to pursue this location. There are other applicants who contacted staff asking about other properties. The messaging from staff regarding the challenges with each of those properties that were being questioned was consistent in looking at what are the road needs, right-of-way considerations, access points, drainage, floodplains. Those comments have been consistent amongst the various applicants who contacted town staff. I will say that I couldn't tell you how many offhand, but there have been a number of applicants that have faced very similar challenges with finding an adequate location that meets the zoning, the buffering, the setback, all of the requirements that was in the ordinance approved by the voters. And it has been a challenge that all the applicants have been facing. There was also, excuse me, a comment that the applicant might reach out to board members for assistance. And I would strongly discourage you from doing that. These are quasi-judicial proceedings. If an applicant contacts you, you should simply state that the Board of Trustees may have this action item in front of them for quasi-judicial proceeding in the future, and you decline to comment with them. Comment was made if this application was approved and those plans fell through, that any other use allowed in the C3 zoning, if that was approved, would be eligible to be considered for the site. And that's also a true statement. Once C3 zoning was approved, any use allowed in C3 would be allowed now or in the future. And so planning commissions often look beyond the current applicant and what is, if the use is allowed 10 years from now, 20 years from now, further, an applicant leaves town for whatever reason, a new business could come in and it would also be allowed any of those uses permitted in that zoning district. One of the comments, excuse me, one of the comments made was related to the existing chiropractic business that's located within the C1 commercial zoning. That also includes 2 residential lofts above that particular development. It was approved 2 years ago, I believe. Went through planning commission site plan review under the existing C1 zoning. That site was approved and constructed at the same time the applicant submitted a site plan that included a phase 2. That's on the same property as the existing chiropractic and pharmacy drive-through business. That particular approval approved the site plan for the entirety of that site. So there is already another building site approved. The applicant on the adjacent property south of the property being considered tonight, west. West of that property, they already have their entitlement for a second building site. They would just need a building permit to proceed with that. That was one of the considerations from the planning commission as well, that there's other development approvals already granted within the C1, including the chiropractic office, that the residential lofts, the adjacent townhomes to the north are all approved within the existing C1 zoning and have been recent approvals. There was a comment made about light industrial property north of town, and that could possibly meet some of the setback requirements, but would be considered spot zoning. That's possibly true. I would suggest that the planning commission and the board of trustees in any quasi judicial proceeding consider the merits of the case based on the information presented to you at that time. So kind of, excuse me, closing remarks. There were several comments about traffic. The applicant, I believe at one point said that a traffic study was not requested, which it was not. That is not typically requested with the zone change. That is something that sounded like maybe there's an offer to pursue doing a traffic study to evaluate traffic impacts, what turn lane improvements or other things might be needed to address some of the traffic safety concerns if this was approved. So if that is a true offer and the applicant is interested in pursuing that, and if that's meaningful to the board, it would be possible to continue the public hearing to allow that additional information, recognizing that would take considerable amount of time to conduct that study and submit it and go through review. It would be a probably significant delay, so the applicant would probably want to weigh in on whether that continuation is appropriate for their business needs or not. The applicant also questioned the viability of the chiropractic site as to when and where and why was that property not under contract. And I believe I just responded to that concern as well, that other approval is on the site west of the applicant's property they have under contract. So I believe that will conclude my staff response to the public comments received tonight. If there's any other staff comments, I would yield the floor. Otherwise, Mayor, it's yours for the board to deliberate.
Thank you, Cody. Appreciate everything you do. All right, let's bring it back to the board for final comments. Trustee Gator.
Okay, so the question I had earlier was in regards to a traffic study, and I know,
I'm sorry. May I take back a prior statement and remind you for procedurally, the close of the public hearing is after the response, and the board's deliberations would be best suited under the next agenda item. The only action for this agenda item 3 was to conduct the public hearing. So if you've closed the public hearing, then you can move on to agenda item 4, which is the next, the board's deliberations and consideration of actions.
Okay, thank you, Cody. Hearing no further comments, we will close the public hearing. Moving on, we have an ordinance for 09-2022, an ordinance concerning a zone change request from C1 community commercial to C3 highway commercial at the northwest corner of Jefferson Avenue and Sixth Street. Mr. Byrd, do you have anything further to add?
I'd like to hand it over to the board for deliberations in just a moment. The couple things I did want to point out, and it's in your agenda report for agenda item 4. In considering your action for the Board of Trustees on a rezone application, you need to do a couple of specific things. And your options are to either adopt or approve the Planning Commission's recommendation, which would be to retain the existing C1 Community Commercial Zone District. You can also override the Planning Commission's recommendation to approve the requested C3 Highway Commercial District. And again, the continuation is always an option. You can always continue the public hearing subject to the applicant agreeing to such continuation. In this step for the board's considerations, you should also go through and make specific substantiated findings of fact. That's one of the important steps. What is the basis for either your approval or your disapproval of the application? We've included the factors that are evaluated as part of a rezone request. Those are enumerated in this agenda item. They were also included in the Planning Commission report for the last agenda item. So in making your findings, you can also adopt the findings that the Planning Commission proposed. You can modify those findings, adopt most of them and change a couple things, or you can adopt your very own findings for this Board of Trustees based on what you've heard tonight and what you consider to be important. So those are the things that you need to do as this part of this action item, is to adopt specific findings of fact. Your approval or denial of the application to rezone will be included in your motion, and then taking an action on the ordinance that's included in your agenda packet. The ordinance 9-2022 is written in a way that if you adopt that ordinance, it would approve the requested C3 Highway Commercial Zone District. So we prepared this in a way that allows you to take any of your available options to you. And I'm certain that the town's attorney could assist with developing a motion based on your discussion and guidance. So that's my presentation on what the board will be doing for this particular agenda item. If you have any questions regarding that presentation or the staff report, I can answer those at this time. Thank you.
None, and I'd like to lead this off, if that's okay. I do also want to acknowledge that some of these items I have a little bit more experience. So if anybody does have any questions, I'm happy to help. So regarding the findings of fact here, I do want to focus on a few of these numbers because they're the ones that are concerning to me. The one that I'm most concerned about is number 3, suitability of the subject property for the uses to which it has been restricted. And this is where I want to bring up the worst case scenario in my mind for the use of this property. In C3, in my mind, the worst case scenario within that zoning is a high traffic gas station. So if a property were to be zoned C3, it would have the permitted use of a gas station. So regardless of what the intentions are, what end up falling through, what happens in 10 years, whatever the case might be, if we were to switch this to C3, it would then be and could potentially be the worst case scenario in my mind, which is a gas station, meaning constant traffic in and out, trucks, those larger vehicles. And that includes a lot of pollution, noise pollution, and light pollution would be my major concerns. Given that that property in that intersection, in my mind, is one of the most, might be the most dangerous in our entire town, with utility box placement, the ditch on one side, and then surrounded by 2 more residential style streets. And there could be a benefit from a traffic study or improvements to that street, but the right of way and turn into that off of 6th Street is very concerning to me for that type of traffic associated with the uses that would be available in C3. So that was one of the items I wanted to bring up first.
Number 2, for findings of fact, zoning and uses of properties nearby. Currently, that whole development area is C1, but conditional or otherwise is primarily residential. So there are multifamily units. I don't know if that's exactly what they are use-wise, but there are many residential units to the northwest. There is a old farmhouse directly to the north, and there are the second-story residential units on the chiropractic building. So they're all primarily residential uses nearby, immediately adjacent to that property. So I do not think that that matches the use of the current uses that are shown there. Character of the neighborhood is also primarily residential. So I don't see that that matches either, and that is number 1 for the findings of fact. And I think this also relates to number 4, that if this were to be C3, it would have detrimental impacts on their nearby property. Regarding number 5, it has been vacant for a long time, and I would love to see this property developed. I think it would be fantastic, and it would initiate some of those improvements and safety things that would be really helpful. So that is not one I think that plays into this. The idea of having this, encouraging this property to be developed, I think is fantastic. That is good news. And then all those traffic concerns and those kind of things relate to number 6. And then all of the other ones I don't think are, I know that Trustee Gator will probably talk about this further about the neighborhood residents in opposition on number 8. So I'll leave that one there. And then, so based on that and those numbers that I highlighted, I would not recommend that we rezone this property, regardless of the fact that I really would love to see additional sales tax dollars for the town of Wellington. I do not think that this is the property with items as listed as a requirement of C3. And that's really the only things that we can consider right now as C3. Whether or not that facility would be good there, I can't say, but it is a requirement of what the voters voted for, that it is C3. And based on that and that it is not a suitable property as it is or qualifies at all within those items. So those are my items relating to those findings.
Yeah, Trustee Gator.
All right. So thank you, Trustee Kinney, for going through and covering some of the items on that. I would like to say, I wish that the applicant had come in with the intent to try and work through some of the things instead of making a preconceived decision as to how things were going to go. I would have liked to talk more about doing a study. A lot of the concerns that were brought up from the Planning Commission as well as from the residents dealt with traffic coming in and out of the site. So that was one thing that I would have liked to have seen us be able to work through that versus just deciding that we kind of have made a decision already, which I had not come in here with a decision made. I also understand and appreciate the applicant's desire of what they would like to do with the property and how some of the other C3 uses wouldn't be impactful on that. And that would have bearing if we were talking about a conditional use process right now, because in a conditional use, we can sit down and say, okay, what is the intended use? And even though it doesn't fit within this, let's discuss how much of impact would this type of business. With what we're looking at here, we are looking at zoning for C3. And again, it's great if the applicant wants to do the cannabis store that was voted on by the voters, but the question does remain, once we have approved that as a C3, it does not revert back to a C1 when that applicant leaves the building for whatever reason. So we do have to consider what are the other uses within the C3. And did want to speak to the items with what is the word of the neighborhood residents. That is one of the things that we are supposed to look at, is what is it that the people in the town are saying that are neighbors to that property, the impact that would have on their property, business, homes. There were several people that spoke from various parts of the town. There were some that spoke that were representing actual neighbors of that. And I think that there was pretty clear that they don't feel like that is the right site. Having shopped at Ridley's, I agree, trying to put another high traffic location in that intersection would make things a little bit crazy and probably dangerous. So I would say that there's pretty strong opposition on number 8 with the neighborhood residents. No other comments?
Trustee Mason. Trustee Teets.
Yes, so I want to say thank you for the planning commission on asking a lot of questions that I had literally laid out, and some of my questions that I would have had about the same kind of issues. So I would have to say that when I was looking through here, I was pleasantly pleased to identify when I was highlighting that I saw pros and cons added into this. It wasn't all negative. It wasn't presented in one way or another. I mean, I even took different highlighters to highlight the positives that were highlighted for it compared to the negatives. That being said, I really, truly, I think that the most important thing is making sure that that intersection is safe. I know I was in an accident there a few years ago. So I will say from that side of things, it can be an extremely dangerous intersection. But other than that, I would say that the planning commission actually summed up a lot of my questions I had on it.
Thanks. Mayor Pro Tem. Tom?
It's a difficult discussion to have because as I believe it was the member of the public, Ms. Karen, that said that, several of us did say during the campaign that it was approved by the voters and we were going to work with applicants through the process to make it like any other business coming to the community, take down those barriers for entry. I will share that I'm disappointed in the applicant's presentation this evening. I think that there was probably a more constructive way to have this conversation that would have served them better in this case. I appreciate and value the opinion and the perspective and the expertise and the findings brought back from the Planning Commission. I'm very curious about that traffic study on that corner. I'll be totally candid about this. Why not let somebody else pay for it? I mean, at the end, the intent is to eventually have that corner developed into something. But we can't sit here and make assumptions about the impacts that the traffic will have unless we actually have the information. So despite the applicant's poor performance this evening, my preference would be to wait to find out more information. I would prefer to table the item until we have all the facts and not make assumptions. However, I do believe in if the board comes to a decision in following that consensus.
Thank you. I mean, where I'm at on this is it just, it doesn't fit into the area. The impact on the proposed development of the community facilities. I myself have been on that road. I mean, you had a good point with the traffic study. Have somebody else pay for it, but once again, it's not that I don't think it's going to be the correct location due to everything that's around there with the residential. It can be detrimental effect to the nearby properties. So yeah, that's where I'm at on it. Do we have any further comments? No. So then, Dan, I would like to seek a motion.
Cody, do you have a good list of the specific findings of fact that were brought up? Because I think we should repeat those to make sure that they're agreed to by the board, because you need to adopt the findings as a whole as opposed to the individuals. So I think that's something we should, I don't want to keep going back through it. And possibly we could go back to the Planning Commission's specific findings of fact just to have a basis for a list, because a lot of the items actually are very similar to what was said by you all this evening. Specifically, the first item on the planning agenda's item findings was safety and access at the intersection. So I think that fits into what was being said here. So maybe I think it would be good to go through Cody's list because he always takes very good notes of the findings. He does this a lot. But then we might want to go back to that planning commission one and maybe we can fine tune it.
So I will do my best. I wrote a lot of my notes in shorthand, so it's not very polished, but if we can capture the intent of what you were implying, then we can, wordsmith it a little bit. And this is where Mr. Sapienza is going to polish my notes. So what I jotted down, what I heard was that a significant finding was, what I made a notes on that was said was finding of fact number 3 was a probably the highest level consideration, that potentially the worst case scenario would be if a proposal fell through and a high traffic gas station chose to locate there at that location, that there's existing traffic safety conditions at the intersections, and that a significant factor was the presence of existing residential uses immediately to the north. That the finding number 1, the character of the existing neighborhoods, was a significant factor. I believe that was repeated by another member as well, that the existing character of that neighborhood is primarily residential. The finding number 4, there's detrimental impacts to the existing residential. Finding number 5, that this was whether the property was vacant as zoned, or that it was a positive finding that it was a desire to see the property redeveloped. And that was repeated once or twice. There was traffic impacts noted, and that there was public comments in opposition of the requested C3 zoning. I've got more notes, and I'm going through them kind of in the order that they were shared. Some of them maybe need to be consolidated, but there was another comment about considering all uses allowed in the C3 zone. Another comment on opposition of neighborhoods, of the neighbors, residents. Comments that the planning commission findings evaluated thoroughly the factors to be considered, and that their recommendation included both positives and negatives. And then there was a comment that the traffic safety would be best evaluated through a traffic study if the applicant was willing to provide that. And then the last note that I made was not relative to the zoning, but I thought it was a unique comment in that when the voters voted for the ordinance that allows marijuana retail establishments in the town of Wellington, that the voters voted for C3, to allow it in C3 zoning, and this property was not zone C3 at that time, so it may not have been a consideration of the voters at this particular location. So those were the notes that I made relative, if that can be cleaned up a little bit into findings.
So
I agree with all those things.
I've got some of the findings of fact that were passed on by the planning commission. I was going to suggest, Mayor, that if I go through that list, we can determine whether or not we agree with that. And then we can add in, I think there's been a couple of additional ones that have been brought up today. The first finding of fact from the planning commission was safety and access at the intersection would be negatively impacted if the higher intensity C3 highway commercial district zoning is allowed. I personally would prefer to say could be, because there are uses that might not, cannabis might not have that. But is that something we would feel comfortable agreeing that would be a finding of fact we would agree with from the planning commission? Okay. The second is uses allowed in C3 highway commercial district zoning, such as fast food drive-throughs and gasoline stations, are not appropriate for the location. The third one is increased impact of higher volume of traffic counts on local streets. I would agree it's a potential issue. The concern that I have is that we don't have a traffic study showing that. So I would have concerns calling it a finding of fact, because I don't see that again. That's my concern with that one is it could be that we think it would, but we don't have anything to support
Well,
that.
Trustee Gator, I want to back up to not this one, but the one that you mentioned before that, the gas station, the retail drive-through. I'd rather leave that out and leave it that it just doesn't fit within the character of the neighborhood because the applicant, I mean,
Okay.
Yep.
Okay.
Leave out that entire finding of fact, or just leave out the part about drive-throughs and fast food?
okay, let's repeat the finding of fact. So we can be.
The finding of
specific.
fact number 2 that I read was uses allowed in C3 highway commercial district zoning, such as fast food drive-throughs.
Stop at, that's the C3 period.
Okay, so we would say uses allowed in C3 highway commercial district zoning are not appropriate for this location.
Yep.
Okay,
I can go for that.
okay. The higher volume of traffic counts on local streets. Do you feel comfortable as a board leaving that one out? Because I don't feel like we have facts to go on with that one. We have thoughts.
I feel leave it out.
Yeah, or make it super generic, just public
Okay.
safety concern.
Development of the property would be beneficial to address identified utility, street, and drainage infrastructure needs on or adjacent to the property. I think we talked a lot about how that would be good for the area, and I would agree.
Yeah.
Okay. The surrounding area has existing residential uses that need to be protected, including recently approved attached single-family townhomes and second-floor residential lofts within the C1 Community Commercial District. Buffering, setbacks, screening, and other typical zoning requirements would be ineffective at mitigating impacts of increased traffic adjacent to residential properties in the area. I would agree with, well, depending, like if we had like a gas station, I would agree, but we don't know for sure that it would be a gas station. I personally would feel more comfortable either rewording that or potentially leaving that one out. Okay. Consistency of zoning districts along 6th Street north of Jefferson Avenue and consistency of development approvals within existing zoning districts along 6th Street. And I think that's speaking to the consistency is that on the west side of 6th Street, it's typically C1 zoning. On the east side of 6th Streets is where we have the C3.
Yeah.
And so that's what that item's discussing. So, and to that, I would add, I don't know appropriate wording, Mr. Sapienza, but there was significant feedback from neighbors of the area that they felt that this would not be appropriate. I know that's item number 8, opposition or support of neighborhood residents. And so I would say there was a finding in our meeting of significant opposition from the residents to rezoning to C3. And then there was another finding that we had talked about with it not being zoned C3 at the time of the vote. Did we want to include that? Okay.
It kind of is applicable though, correct?
If we were talking about a conditional use, I would say that it would be applicable, but we're talking about a zoning. If this was a conditional use, we could make an exception based on, okay, this is going to be this type of business. We can't do that with a zoning request. We can't say you can have a C3, but only this C3, unfortunately, because that's not what's in front of us. Okay. All right. So the only additional finding of fact from the Board of Trustees would be the feedback from the neighborhood residents. Am I missing anything else? It would be an additional finding of fact that we have on top of what the Planning Commission had.
No.
Okay. All right. Mr. Sapienza, are you ready for me to go?
Okay.
I think I've got it here, but if you have it.
I'm gonna,
Okay.
I'll give you the framework for
Okay.
a motion here. And I think then you'll list out those items that you have,
Great.
or I can just read out a motion and you can,
Try it.
or and you can just
Well,
say,
okay. If the board would prefer Mr. Sapienza to read it, go ahead. I don't have a preference either way.
I just to save you the time of
Go for
rereading
it.
exactly what you read.
Go for it.
Move to adopt the following findings of fact. One, safety and access to the intersections will be negatively impacted if the higher intensity C3 highway commercial zoning district is allowed. Two, uses allowed in C3 highway commercial zoning district are not appropriate for the location. Three, development of the property would be beneficial to address identified utility, street, and drainage infrastructure needs on or adjacent to the property. Four, surrounding area has existing residential uses that need to be protected, including recently approved detached single-family townhomes and second floor residential lofts within the C1 community commercial district. Five, consistency of zoning districts along 6th Street north of Jefferson Avenue and consistency with the development approvals within existing zoning districts along 6th Street. And 6, public comments from area residents at the town board public hearing were in opposition to rezoning the property to C3. And to deny the application for a zone change request and to postpone indefinitely ordinance number 09/2022.
So moved.
Second.
Roll call.
Trustee Gator,
Yes.
trustee Kinney,
Yes.
Gleason,
Yes.
trustee Teets,
Yes.
trustee Wiegand, Mayor Pro Tem McDonald,
Yes.
Mayor Shosse.
Yes. All right, our last action item is the 20. Oh,
We've got two. Okay, the last one will be really quick, but both of these items need to be taken care of tonight. And we also need to go into executive session for a very short period. So, sorry.
yeah.
That's what we're here for.
Yes.
We have
Okay,
nothing for
let's
the
move
next month.
Good evening, Victoria Runkle, Interim Finance Director. And we also have as a participant, our bond counsel, Mario Trimble of Kutak Rock for this evening. Very quickly, I will go through this as quickly as I can. As we are preparing for the sale of the 2022, I'm going to shorten it to the SRF loan for the wastewater. We are looking at all our debt and we have to meet the covenants of our debt, of our previous debt. And the town of Wellington has, go forward, I apologize. The town of Wellington has two previous bond issuances that were made prior to 2022. And one was one was in 2002. And the last payment on that is actually in August of this year for approximately $161,000. The other bond issue was in 2014, and those payments go through 2034, and those are the problematic ones. In February of each year, we have one interest payment, and in August of every year, we have the second interest payment, which is very normal, 6 months apart, and the principal payment. And again, the 2022 bond covenant, just to let you know, it only requires us to reserve 3 months of operating costs. So I say that because we have a little table here we're going to walk through. But the 2014 bonds, however, have a covenant that states, and you can move forward, okay, that the 2014 says that the current net revenue must be 1.2% of what is referred to as the maximum annual debt service. And yes, that is referred to as MADS. I just want to say, okay. And we provided you the table that with the basis of the assumption, the maximum annual debt service would occur in 2030. But we have to use, per the covenants, per the promises, we have to use the current net revenue. So even though it's not going to happen until 2030, we still have to do the current net revenue. That's what the promise was. The need is in 2030 is 3.122 million, but our current net revenue is estimated to be 2.5 million. So we had a shortfall of 564. Continue. Thank you. So I provided this just to, I'm not going to walk through this, but this is the calculation that has been approved by our bond counsel. So just wanted to show you how we got to those numbers. You can go forward. So the facts about the 2014 bond covenant. The outstanding principal is 1.77 million. the outstanding interest is $467,000. So if we pay it through 2034, that's our outstanding principal and our outstanding interest payments. This is what I really do love. These bonds can be called in September of 2024. And what does that mean is that they would be completely paid off and we would start saving all that interest payment. So that was, I mean, when we started looking at this, that's what I was, that piqued my interest, I admit that. So we have to meet the need for the bond covenant. That's our first problem and our major problem. So proceed. We had two options. One option is to refinance the outstanding debt, and we certainly could do that. The problem is that would eliminate, we could address the bond coverage issue, but refinancing has costs in and of itself, legal costs, and everybody's shaking their heads, so I don't have to go, but selling costs. So there's quite a few costs associated when you do a bond issue, even refunding. And if you looked at and I provide that for you, if you looked at the interest rates that were made in 2014, those were great interest rates. And we would not be able to make those interest rates right now. They were just fantastic. So Victoria Runkle was going, I know it's a really, that deals with the covenant, but I don't see the upside for us, for the town. So then after speaking a lot, and I want to give credit to Kutak Rock and Mario, because we were going, but Mario, I have cash. There must be some way I can do this, okay? And I had to give credit where credit is due. And he said, wait a minute, we could set up a trust. And what we would do is move the current cash balance, some of our current cash balances, to a trust bank. And we already have two trust banks that are very, very interested in this. And we'll deal with all that tomorrow. But they, both of them, very, very competitive. One is UMB Bank and the other is a Zions Bank. And they're both known as trust banks. They deal with a lot of bonds and trusts and things like that. So obviously we called banks to see if they were interested, and they are very interested. And we would move money to the trust. We would get that to them. And that would defease, what's the word is defease, but remove it from our books. And the covenant then is removed. And we have dealt with, I mean, we've talked a lot with the state on this to see if they're okay with this option. And they're very, very amenable to this, very happy with this option. So it would eliminate, if we move to a trust, it would eliminate the bond covenants, as I said. And again, the trustee bank then makes all the payments and all the reporting requirements. So they do all the work of Emma and things like that. And our agreement would state that they have to call the bonds in September 2034 or 2024, I apologize. And that would then save us about $319,000 in interest payments. We would, when we give them the balance, the $2.2 million, that would be, we just move it from our reserves to a bond reserve. And we will earn interest on that money. So we're not losing any interest earnings on that. And that will be a factor at the end, you know, when the money's all exchanged, how much we would actually get back from the trust would be based on how much interest we earn and that. So that would be a positive, if you will. We aren't losing any revenue or resources, if you will, any interest earnings by moving it to them instead of leaving it to us. I will say that the downside, and I mean, I want to be very forthcoming, is that we are prepaying bonds, if you will. And that means that we won't have that money in, I mean, once we give it to the trust, it's theirs. I mean, I don't, for the bonds, but we don't have that money to use for some other purpose. I just want to be very clear about the downside to that. On the last page, the recommendation is that we would set up the trust, and we do have a motion in the paper to do that. But I want to say that one of the things I did provide for you in the document is what the whole financial, if you will, reserves of the wastewater utility. So currently, we're sitting on $9.5 million of cash. That was always, I called the former deputy finance director and said, what were you thinking? I mean, it's a lot of money, right? And he said, we always assumed that we would have to pay for the plant design with cash. And so they were putting money aside for the cash for that. So I'm assuming, and it's very estimated, that the plant design would be 4 million. And the reserve for operating cash is 3 months. That's our policy. And the 2022 bond reserve is also 3 months. And we would transfer to the trustee 2.4 million. And so the town would still have 2.6 million as of this very moment with all this cash transfers of $2.6 million in reserves. And that will be seriously discussed as we look at rates, because I think there's a lot of good questions in that, and the CIP and things like that. So with that, what we're asking for is the board to approve I'm going to read it, the motion that, again, our city attorney wrote. And we do have the bond counsel who's been with us all evening. If you would like to ask any questions, he's also a participant. Oh, he's there. I'm sorry. Hey, Mario. This is Mario Trimble. He's our bond counsel with Kutak Rock. So with that, we have the motion in the paper, but I can read it if you want, or questions. Or I guess I'm not as good at the process as Mr. Byrd. So.
It's open for public comment.
Okay.
Is there any public who would like to speak on this?
Christine Gator, Downtown Core. Just want to know if there's any fees to moving it to the trust account. And then will this affect our water bill? Will our rates go up in any way because the money is moved over? Thank you.
Thank you.
Those are very good questions. Yes, there is a $1,500 fee to the trust to do the work, to report to Emma and do those sorts of things. So there is a fee for that with Zions Bank, and the other one has a little more complicated fee structure, but it's about the same. Okay, so, and I think that it's, and I didn't bring that with me, but I also think that we pay $500, I think, a year. Mario? Yeah, we also pay $500 a year for them to manage the money. So that's true. As part of the fee question, the rate question, the answer is the town, we have to pay these bonds in any case. So it won't have any impact on the current rates, but this would be something that, because we've moved the debt off the books, we will not have to factor that in when we look at the 2023, 24 rates. So the debt actually is gone, essentially. We do have the 2.6 million still in reserves that should be a positive as we develop the rates for 2023 and 4.
Any other public comment?
Oh, I'm sorry.
Any other public comment? No. Okay. Any comments from the board, Trustee Gator?
Okay, so I did have on the rates, I understand that we don't have that immediate change. I understand that piece because the other way we raise revenue is we raise the rates to deal with the covenant. So I think this is a much better option. The concern that I have though, is that with taking the 2.4 million out of the reserves, I know in a lot of the presentations that we have been given prior, and I know that doesn't take into effect the debt, but a lot of that has taken us eating into the reserves for a couple of years before that comes back positive to keep from having to take the rates through the roof. And my concern is with us taking out a large portion of that, about half of what we have in reserves, that we're still going to be able to avoid having to make those rate changes. So I'm just trying to understand that piece a little bit, because I know that was part of the factor, was making sure that where we're going into reserves. I know we changed the policy to 3 months, so we're good on that side. But I don't know if you could address kind of the.
I can't like right off my head and, you know, because we're gonna have to put this all into a rate model and understand it. The short answer is, I don't think this is going to be a major impact on your rates because your debt was always going to be there.
Right.
So, I mean, that's the, you know, that was the push, if you will, in your rate model, is you also had this debt on. And so this takes the debt off and it does lower your reserves. I won't deny that, but it should have a positive influence, I think, on the rates, because we're removing the obligation, we're removing the liability. And so any cash that we're looking at or dealing with, I mean, it should fit. Okay. And we will definitely be, I mean, we have to do this to do the 2022 issue, but I mean, this will be a major discussion as we're developing a rate model, the reserve. Yeah.
And then were we able to move the engineering costs into the loan in terms of paying for those as part of, because I know you mentioned we originally were trying to pay for $4 million of engineering costs. Were those able to be rolled into the loan?
Excellent question. The answer is because you passed the reimbursement resolution, we haven't factored that in only because that would be at the end of the bonds, if you will. So we could pay ourselves back if that makes sense. But until we get the construction done, we are absorbing, we are accepting the engineering, my estimate, the $4 million. And I think that's a little high of an estimate to me, but we are doing that at this point. But we're hoping at the end of the project, we have enough money to at least reimburse ourselves of some of that engineering cost. We won't have 4 million though. I mean, we won't have that much. Yeah. Mm-hmm.
No further questions. Just my concerns are making sure it's going to be on the rate. I understand that we're retiring the debt. We're just, instead of retiring the debt over the next
12 years,
13 years, we're retiring it in 2. So we're taking where we normally would have paid, a couple $100,000 a year, and we're taking out $2 million all at once. And so it's just how that factors in. But if we're saying it should be positive, we just might have to get creative, because if this does come out to where, then we're going to have to figure out where to cut so we're not hitting the residents for making this change. That's my biggest concern, is that if it comes back that, oh, well, we're gonna have to raise rates because you did this, we got to figure out somewhere else to cut so the residents don't get hit on this. So other than that, I don't have any other concerns.
And remember, we will be saving $300,000 in interest payments. So that's definitely a win. I mean, that definitely is more revenue than we had in our model before.
I love paying off debt early and all that. I just want to make sure that we're not smacking the residents in the face to do it for the next year.
Right. Oh, no, we're not doing that. Yeah, I mean, yeah. Mm-hmm.
I have similar concerns. I know that, fund balance has a significant part of the variable of all the equations that we use for any of the rate calculations. So I guess this is my confusion. Without knowing that and without using and calculating that out right now, are we able to determine the direction that we want to go? Because I would feel more comfortable if we had that within the models that we were already utilizing with the new balances. Is that seem like
the motivation for this was that in order to issue the 2022 debt, we can't do it with the covenant that we currently have in the 2014.
Okay.
That's
So
our
it's just- it's
primary
not
problem right now. And
So without this, there's no way to cover that, correct?
right, I mean, we're working on Plan B. I mean, legitimately, we can't come to you and say, you have to do this. And there's no options. The option B that we did discuss today with the state is that we wouldn't take the $3 million loan. If you remember the green project loan, we wouldn't take the green project loan, which would lower our debt obligations. It wouldn't close the gap. We're just kind of, and we're just constantly nibbling at that $500,000 shortfall. That's the best way of saying that. We have to close that gap. And the only way we can close that gap is to take less debt. And because they're issuing the other debt in a very large issuance at the state level, it's like, today was the day. They said, are you taking this or aren't you? It's like, we got to do it. We got to do the project. Then they said, well, you don't have to take the $3 million debt, which means that later we'll have to deal with that. You know what I mean? But that was one way of nibbling at that $500,000 shortfall. And then the other way is that they said today, they do not know what the interest rates will be tomorrow when they sell, but they said, well, we think that the debt service schedule that we gave you is conservative or higher than it will be in the end. Mario's here. We talked about 3 o'clock today and said, okay, those are good options. Probably not the whole $500,000, so to be honest, so that would be what we would have to do, is we would not take the $3 million issuance, which, remember, that only has a 1.5 interest rate on it. So that's the best one. But that's what we would have to do, is we'd have to start saying, okay, what can we do to nibble at that $500,000 and get it down? And I'm not sure, but I do think, I know the rates, believe me, I do. The rates are a major issue. We've talked about this. I think with the interest rate, with the interest payments eliminating, I think I think you're going to be fine.
Yeah,
Yeah.
and a significant amount of that was just the debt service. That's a
Mhm.
large percentage of that payment in the same equation that we're
Yes.
talking about. A large part of that payment is just the debt service. So if we're eliminating that, then that portion of the payment would also be eliminated.
Mhm.
Okay,
Yeah.
so
If-
I
if
feel
I may.
confident. I look forward to seeing the numbers, so we know exactly. But of course, we won't know until
Right.
through the year anyway. So there's
Yeah.
a lot of unknowns, of course.
Well, we
but-
hope that we're running models in
Yeah.
August for you.
Yeah.
So, yeah.
But
Mhm.
the trust obviously looks like a much better solution than the option one, so.
Not to derail the discussion, but if I may offer a couple of observations. First, thank you all. I have to commend you all. It is 11 o'clock and I'm sitting in my basement office. You all have a longer drive to go before your day ends. This is why I love doing public finance as opposed to corporate finance. That is the interaction with folks like you who give up your time and your sanity, honestly, to do what you do. So thank you. I commend you on what you're doing there. In terms of the reason why we're here today, this came about as a part of the due diligence process and getting the financing put together. And I want to stress that it's not a cash flow issue, it's a covenant issue. It just so happens that the solution I believe, will have a positive impact in terms of cash flow. We can't say that with certainty until we run all the numbers, but when we put money into the trust, it's actually, and Vic, I apologize, but I've been running numbers all afternoon, so I've got a little bit more updated final number. It's actually going to be about 1.9 million, not the 2.2. 2.2, well, $2,237,575 is what would be paid on the 2014 bonds if you paid them in due course, according to we call it a 6/1/12/1 schedule, interest twice a year and principal once a year. The callable 2014 bonds are outstanding in the amount of about $1,425,000. And the interest on that callable portion is that $319,000. So if we're getting rid of the interest by paying in 2024, we actually only have to place the 1.9 million with the escrow agent or with the trustee bank. So that 319, it's not even money that's going to go out and come back to you. It's money that you're actually just going to get to keep in the form of the savings. On top of that, the 2014 bonds had a reserve feature. So that's an additional $176,000 that you're going to get back. Well, the dollars are fungible for tax purposes. Those dollars get allocated to the refunding, but it frees up another 175,000, 176,000. So, you know, we're near $500,000 already. I can't say with certainty that, you know, we're absolutely not going to have to, that this is going to have that this isn't going to have any impact on rates. But I would eat my hat if we did. If we did, it wouldn't be because of this defeasance. It would be because of some other factor. It really does represent a solution to the problem of being able to issue or enter into the loan with the CWR PDA unbridled from these covenant restrictions. You know, placing more money in a reserve, meeting this 1.2 times coverage test. And I think it means that the town can achieve a savings. So it's a win-win in terms of solving the problem and also finding a savings. I hope that's helpful.
Very helpful, thank you.
Trustee Mason. Trustees.
I do have just two questions, and I'll try and make them quick, guys. So where are we as far as the balance that we are allowed to have in like our actual fund balance account? I know we've been pulling from that some and watching how in these meetings over the many months. Do we have any penalties if we drop below what is allowed in our fund balance for the town?
Oh, no, you are far above the requirements that you have. I mean, that you need, yes. I mean, you have 9.5 million in cash. We're assuming that we'll use 4 million of it for the design pre-planning. But again, you only have to have legally, that was on page 3 of the memo, you only have to have reserve operating cash of 23 months worth, that's 244. And this is, you know, every fund is separate, different, right? So this is just the wastewater fund. And the 2022 bond reserve will be 3 months, will be another 244,000. One could argue that could be the same 244,000, but yeah, I'd rather be very conservative and say, no, we're going to put it all aside. And you still have over 2.6 million in your reserves. After you kind of reserve those, you still have 2.6 million. So you're far above anything that you are required to have.
Got it. So, but as far as the new loans go,
The
there's the minimum amounts that you have to prove to repay back the loan, correct?
Yeah.
And that was what changed our rates.
This one, the new loan, once we remove the 2014 bonds, okay, the new reserve in the 2022 bonds requires only 3 months of your operating monies. So instead of that MADS number of 1.3 million, the highest average, you only have 244,000 that you have to put aside.
And that is an operating reserve, not a dedicated debt service reserve. So it's simply fund balance. You just have to maintain the fund balance in the sewer fund at that level.
And we will be bringing back to you in the rate review clarity on policies so that we're written, so that we know that, so the finance director is telling you, I want you to have both the operating cash reserve and the reserve for the board. And that may not be your policy because it's setting aside money, but we'll bring that back for a policy decision. But for this evening, I want to make certain that we were as conservative as possible and show you we still had cash available.
Got it. Do you see any other issue with this in all of your investigations that would cause the residents' rates to be affected?
At this point, I'm gathering all this and understanding it. I believe that this will address, I think this is a good move, particularly because we're bringing back that interest that we would have had to pay on the 2014. We're actually, in a better financial situation through this move. Now, how that translates into rates, I've been in this business a long time. I still think it's going to be a positive influence on our 2023 rate process. Yeah.
Got it.
Mhm.
Thank you.
Mhm.
No further questions? I think it sounds great. All right, so with no further comments, I would like to seek a motion to
I would like to adopt a motion directing the finance department to set up a trust with the oversight of both
Trustee Gator,
different
excuse me,
motion.
there is a proposed motion in that has been approved by bond council that we would highly recommend we use.
On the right one. I was on the wrong page.
Is it in the staff recommendation section or is it
In
in
the
the
staff
separate?
recommendation section, it's a
Got
rather
it.
lengthy one.
I was looking too far down. Thank you, Vic. I move that the town board of trustees acting for itself and in its authority as the governing body of the town wastewater enterprise upon final document approval by the town attorney and the town's bond council, authorize the mayor to execute a defeasance escrow agreement and all other documents necessary to establish a trust account with a trustee bank and authorize the town wastewater enterprise to fund such account in an amount sufficient to remove restrictive covenants associated with outstanding bonds.
Second.
May I get a roll call?
Trustee Gator,
Yes.
trustee Kinney,
Yes.
trustee Mason,
Yes.
trustee Teets. Yes. Trustee Wiegand,
Yes.
Mayor Pro Tem McDonald,
Yes.
Mayor Shosse.
Yes.
We'll make this quick. So pursuant to Chapter 2, Article 3 of the Wellington Municipal Code, that references appointed officers, and it is required to be done at the first regular meeting after the town's biennial election, which would be today. So this is appointing the town administrator, myself, interim town treasurer, Victoria Runkle, the town clerk, Crystal Eicher, the town attorney being represented by March and Olive, the municipal judge, Teresa Blau, and the assistant judge, Sarah Steben. This action would also confirm appointment by the municipal judge of the municipal court clerk, who is Adrian Wright, and also serves as our front desk receptionist at Town Hall. So the other item that it includes as far as the code, the appointment for the town attorney requires to affix the attorney's compensation. Included in your packet was the contract approved by the trustees on February 23rd, 2021. The attorney's billable per hour rate is $170, and for the paralegal and for research, it is $80 per hour. Staff recommends approval of the resolution. And I'm here for any questions.
Any comments or questions from the board? Trustee Gator.
Nope.
None.
Patty, you still want to do this job?
Killing it. You guys are killing it tonight. This is hard work. This has been a tough meeting and I'm so proud of all you guys. So this is, and I'm proud of everybody who's stayed. It's like, wow.
Trustee Teets.
Have one question on number 4 of the attorney's agreement. It says, in the interest of budget management, the board of trustees hereby designates the mayor and town administrator to serve as the primary contacts for the town attorney outside of the regular board of trustee meetings. So does that mean we're not allowed to reach out to Dan if we need a clarification on something?
No, you can reach out to him directly.
Perfect.
If something starts taking a lot of his time, we talk about it so that we can make sure, because we do have budgeted amounts, but yes, you can reach out to him directly.
We work very hard to keep the bill for the town of Wellington quite low. So we'll be judicious with that. If our bill gets outrageous and we need to fall back on this provision in some way, we'll certainly give you a lot of advance notice.
Thank you for the question.
Trustee Wire.
Okay. Yes.
Do you have any questions?
No.
No, thank you. Mayor Pro Tem McDonald. No questions from myself either.
Public comment.
Public comment regarding this agenda item. Going once, going twice, sold.
Nice.
All right, let's bring it on back. Final comments, trustee Gator.
No final comments.
With the motion, do you need just to approve the resolution as written, or do we need to also add the rate?
Nope, just resolution is written.
Okay, thank you. No other questions?
No.
No comment.
Trustee, what do you say?
No comments.
No, okay. Perfect. Hearing no further comments, I would like to seek a motion for resolution number 19-202- a resolution to the Board of Trustees appointing officers of municipal judge until the 2024 election.
So moved.
Second.
Negative roll call.
Trustee Gator,
Yes.
trustee Kinney,
Yes.
trustee Mason,
Yes.
trustee Teets,
Yes.
trustee Wiegand,
Yes.
Mayor Pro Tem McDonald,
Yes.
Mayor Shosse.
Yes. Mr. Saspinosa, anything? Do you have any reports?
No further updates right now.
Thank you. Ms. Garcia, do you have any reports?
So I was going to talk to you guys a little bit about the water and sewer rate roundtable, but I'm going to send you all an email tomorrow morning on that because in interest of time, I do want to remind everyone, we do have a town hall tomorrow night here in this location at 6 p.m. So very excited for that. Staff super excited. We'll be sending out some information to the trustees tomorrow about what your role will be at the meeting, but Michaela Henschel will be facilitating her first roundtable for us. So we're really excited to have an in-house facilitator and excited to have the community show up.
Other reports from staff? Okay. Other reports from the board? Trustee Gator.
There are other things I won't bring up tonight because of the lateness, but there are a couple of items that do need to be brought up. First was from Commissioner Kafalis's meeting, I believe it was last Thursday, when he came out to the T-Bar. One of the things that he had brought up as a good idea in regards to the roundabout, or not roundabout, the intersection by the high school, was potentially doing a joint letter from the county commissioners, possibly the school board, about the priority of the intersection and getting that out to CDOT, just having all the elected officials in agreement on that. So if it's okay with the board, I would love to have our staff work with county staff if that's something that they would approve. But I told him I would bring that information back to the board. I believe Mayor and Trustee Teets at least were there as well. But I did want to make sure I brought that back to the board. It was a great idea by Commissioner Kafalis, and I think it'd be great for us to work with them to say we all recognize as a priority, and if it helps, great.
Yep, behind that.
We will take care of that and
Okay.
send the draft out to you all.
Perfect. And then I did also want to bring up in the CAC meeting yesterday, or gosh, it's only yesterday, there was a discussion about ADA parking for the fireworks. And so the CAC is working on stuff in regards to the festival. Because the fireworks is actually something separate that the Board of Trustees approves, the CAC does not approve the fireworks. That's something that we need to potentially add in and to figure out. I don't think that's included in the cost, but providing parking for ADA with that was brought up as a concern. And because that really is a Board of Trustees event, not a CAC event, that's something we just need to figure out with staff what that's going to look like. And then the other item I think we're going to be okay with, there was a discussion about drone footage possibly being needed. We don't know if that's going to need to come back. If it does, I'll let you know. But at this point, it seems like we're probably okay. But if I hear otherwise, I'll let you know.
Is that for like crowd counts?
Yes, it's
Okay.
for crowd counts. And so we had a couple of different, we had one person that's going to do it for free. Someone else was going to charge for it, not unreasonable amount, but that was not an item that was included in the CAC's budget. And they're already trying to figure out where to cut the budget for 4th of July because some things are coming in more expensive. And so adding, if there was things we needed in terms of crowd head count and things like that were going to cost extra, I was going to ask that we not pull that out of the CAC's budget, because that's information we as the town want, that we find a way to put that somewhere else. But it sounds like we might not need to pay for it. So if it changes, I'll let you know. But at the moment, we're okay on that.
Thank you. Dave, you still there?
I am here.
You have anything? Any updates?
No, I do not. Thank you.
All right, moving on. We have an executive session. Have at it, Dan.
Hanging with us, making it through all this.
You.
Thank you for coming.
Like a motion? to go into executive
Executive session for the purpose of determining positions relative to matters that may be subject to negotiations, developing strategy for negotiations and or instructing negotiators pursuant to section 24-6, 402, 4 ECRS regarding negotiations with North Poudre Irrigation Company as required by CRS section 24-6, 402, 2D.5, 2A and 2E. The executive session proceedings will be electronically recorded and the record will be preserved for 90 days through July 25th, 2022.
Second,
Roll call, please.
Trustee Gator,
yes.
trustee Kinney,
Yes.
trustee Mason,
Yes.
trustee Teets,
Yes.
trustee Wiegand,
Yes.
Mayor Pro Tem McDonald,
Yes.
Mayor Shosse.
Yes.
We just make sure all the Zoom participants, thanks.
Zoom, please remove yourself from the webinar. Please remove yourself from the webinar.